Okay. Mic's on? Is your mic on?
Bedford DOB? Yeah, sure.
Okay. Good morning. This is the New York City Board of Standards and Appeals public hearing for February 26th. Appeals calendar, continued hearing items, item number 1, 2017-248A, Long Island Expressway and 74th Street, Queens. Received a request to withdraw this application.
Yeah, and before we just bring that to a vote, I did want, because all of us reviewed the materials, and the Department of Buildings did an enormous amount of research on this, and it was, in addition to being very persuasive, they just dug everywhere, and I just want to compliment them on their enhanced research access and methods. It's really, really helpful. Plus, they were able to find applications from the 1970s that just sort of told the whole story, and it's the reason that the applicant withdrew. There's no way to refute hard facts. So anyway, I'd like to make a motion to withdraw.
Chair Promoter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown?
Aye.
Commissioner Shetta?
Aye.
Commissioner Shabeta?
Aye.
Item number 2, new cases. Item number 2, 2017-263A, 6266 West Broadway, Manhattan. There's a request to withdraw this also.
Right, so I'd like to make a motion to withdraw.
Chair Promoter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown?
Aye.
Commissioner Shetta?
Aye.
Commissioner Shabeta?
Aye.
Withdrawn. Special order calendar, continued hearing items. Item number 3, 86755BZ, 6615 Borden Avenue, Queens. Once again, 86755BZ, 66-15 Borden Avenue, Queens. Oh, there you are. Hi, how are you? Good morning. Sorry, I didn't see you.
That's okay.
I have to swear you in, though, okay?
All right.
Raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board and to respond honestly to board member questions?
Yes, I do.
Okay, great. Please state your name for the record.
All right, my name is Nancy Lee Paul. I'm with Nasir Kansada Consulting. Excuse me. I'm here to respond to the executive meeting yesterday. And I guess one of the main things is to create a timeline of when we expect things to happen. So we're proposing that on March, the dumpsters will be relocated to the Clinton Ave side and enclosed in a fixture, a enclosure.
So that the enclosure would be
On the
installed.
Clinton Ave, yeah, it'll be installed and the dumpsters will be relocated over to that side. We will encourage them to keep the tires and the debris removed.
I'm sorry, you're going to encourage them?
Well, I'm not there every day. When we went out there, there were like 4 tires, which was a good improvement.
Start.
It was an improvement of what had been there, so we will,
No, so it's more than an encouragement. They're not allowed to store things on the
Yes.
outside of the building, so it's
well,
a
when
directive.
they make that enclosure, maybe they can,
But it can't become like a trash storage area. The dumpsters are for trash.
Granted.
The enclosure is for, I'm not sure, maybe for materials, but you're not
Yeah.
supposed to have stored materials either, so.
well.
Normally, we have those enclosures for cars that are, for example, awaiting service.
Yes.
And then the dumpsters are in that enclosure. Yeah, so.
Once we make the change to a convenience store, the issue is mute as far as the tires. Also, the lights will be changed to shielded lighting on the various, I think there's 3 of them, light fixtures. In April, so the asphalt and the concrete that needs to be removed in order to prepare for planting will also be removed.
Okay, so just the dumpster, the tires, and the light shields, that's all going to happen in March.
That should happen in March, yeah.
April is when you're,
We're hoping to do planting in April. So, I mean, as far as the removing the asphalt will be either the end of March, beginning of April.
okay.
And the planting will happen in April. So our goal is that by the beginning of May, the front, the wedge on the right side will have been planted, and the arborvitae hedge on the west side will have been planted. I would like to hold off on planting near the building area and in the rear until that construction is done. Otherwise, it's liable to get damaged. And the asphalt resurfacing will happen after the construction, because otherwise all the tracking will just, they'll have to do it again.
And when is construction?
Well, upon approval, DOB approval, it'll be within that, like, say, 6 months, whatever. It'll be within, say, a year, assuming we get a BSA approval fairly soon.
So, because we had comments about the landscaping, right? That-
Okay, so-
So what I wanted to say is, before you talk about that, since you need to come back with a revised landscaping plan, can you be more specific on a drawing about your phasing of the work, so that we can understand how much landscaping is going to be done in April? Because what we're ending up doing then is allowing you to proceed without all the landscaping in place, which always makes us a little nervous because of the follow-up, right?
Yeah.
So if you could show a phasing diagram, just take the plan and show when this work will be done. That way we know to expect. We'll send out our compliance officer to check that your work is in place before we vote.
Okay,
Okay, and you would provide us photographs also to show that the work is in place.
all right. A comment about putting trees in the back where the triangle is, that's in a northern exposure. It's basically, there's shade 24 hours a day, pretty much, because it's on the north side, there's street trees, and then the house also blocks it. So we're proposing to do like a rhododendron or something back there, because arborvitae will not survive, they like sun. But a rhododendron is evergreen, it can grow like 6 to 8 feet tall, and it'll, if it gets past the 6 foot, they'll actually have flowers, as you can see. So.
Flower in the shade?
Well, no, rhododendrons are,
Shade.
yes, yes. And in reference to the planters in the front, actually, if you look at, they've been there for quite a long time. At one point, when we took the photographs, the owner had moved them, I don't know why, and he put them back. It's not normal to have planting areas right where all the traffic is. Gas stations don't normally have planting areas in front, so we either propose to keep those planters or remove them. But we're not proposing to do any planting.
My recollection is there's sort of an ugly concrete block wall there.
Well, the 3 planters are these white, this tall with a tree about that big, which I got somewhat visual obstruction, but,
In terms of traffic, you mean a visual obstruction?
well, yeah, coming in and out. You're looking.
Oh, you're talking about right up against.
Right up the
building.
front, yeah, right at the curb, right on
No,
Borden.
she's not talking about those, she's talking about the ones over there. Along the perimeter
I'm
on
confused
Clinton,
then.
you're talking about, right?
No, the ones on perimeter on Clinton, where we want to install. I'm saying there were 3, my
Oh, you're
understanding was
talking about
there's.
those 3 that are on the curb, that's different than the ones you were.
Yeah, so maybe I misunderstood what you were discussing. I proposed to even remove them.
Oh, no.
These in the front.
In the front, no, so I didn't have any particular interest in planters right where the cars drive in.
Okay, well,
I was talking about along Clinton. It still shows on the drawings, on that long strip on the drawings,
yes.
it still shows them existing planters. And those are all potted plants.
I think they have small trees in them. They're like stone planters, and they have like small shrubs in them. The front one has flowers and I think a couple small shrubs, but right at the very front corner.
No, they're planters. They're round planter boxes.
Oh, okay, so they're kind of whitish? Well, those are the ones that he moved from, those are back, that's what's up front now.
And then there's one at least I see in the photo provided, which is in a square, kind of a
Concrete block.
concrete block.
There are 3 built-in planters that have been there, I don't know
Right,
how long.
yeah, so they're all in above-ground planting, so that's not normally how we want planting to be done. So
Right.
that should be in-ground planting in a 4-foot deep planting bed.
Right, so, I mean, what we're proposing is that the stone planters that are there, we're not proposing to change them, but in between, that we would dig out the concrete, and plant arborvitae wherever those 3 planters are. The white planters, they got moved to the front, which is why,
Why would you want to keep some in a concrete block box, and some in-ground?
well, I mean, we can
One,
remove,
the concrete block is more trouble to maintain. You know, the water from watering leaks through it, cracks it in the winter. That's the reason we don't like these above-ground planters.
Yeah.
They crack in the winter and they look terrible.
well, I can ask them to remove, I mean, they're
So
gonna
I-
be knocking
yeah,
stuff
so
down
I think-
anyway, so just take the whole thing out. and-
Take the whole thing out and
Okay.
dig, and when I mean wide, I mean front to back, right? So 3-foot wide
Right.
planting beds as opposed to depth of.
Yeah,
soil,
yeah, yeah.
Right?
Yeah,
Okay.
okay. I don't know if there's anything else, I think that was pretty much,
Okay, so we need you to resubmit drawings before you actually start the
Okay.
planting work, and to give us that phasing drawing.
okay, all right,
So the drawings would be showing the extent of planting that we're talking about, with more planting in that area that
Uh-huh.
you're talking about with rhododendrons.
Right,
Because at the
yes.
moment, it's shown as ground cover.
okay. Excuse me, the only thing is, where we're showing the dumpster to be, I'm not gonna show trees there, because they're gonna get,
Right,
so there's that fenced-in area where the
Yeah.
dump, that's not having any trees.
correct,
Okay,
okay. Makes sense, right?
Mm-hmm.
Unless you put it behind the dumpster area.
I just think no one's gonna see them, they're just gonna get damaged.
No, I mean, accessing the planting. Yeah, that's true. Okay. Okay. Good. So are there any speakers on this one? All right, so revised drawing showing planting, show a detail of the planting bed. Okay, it should have curbs, so it prevents the cars from
Correct.
hitting the plants. And then, of course, specification of the planting type, like you've already done, and the phasing drawing. Okay. So it shouldn't take too much time. We should see you in March so that you have time to actually get going, right? So if there's a way, because it's all we need to check. Is there a way to put her at the very end of the...
Oh, very. March 26th is 25.
Okay. Oh, we had an adjournment. Okay, yeah. So it's March 26th?
With
a
a submission of March 6th.
Okay,
Is that enough time?
yeah, I think that'll be all
Next
right.
week, actually. Is that enough time?
Well, no, I mean, the submission part, we already kind of,
Oh,
whatever. I'll add it, change it a little bit. But the submission is only basically the one, well,
It's 2 sheets. It's one sheet of,
Phasing diagram.
yeah, so it's the landscaping plan that needs to be
Right.
revised. It's details of the planting beds,
oh, okay,
right? And it's the phasing diagram, so it's a separate sheet that shows when you're going to do which work.
okay. All right,
So I
what
don't know
about
if
next
that's...
Friday instead of next Wednesday?
Okay, yes, we can do that.
With the difference with that, with the 6th?
for a week Friday,
March 8th.
yes, that's fine,
That's
That'd be
fine?
okay?
yes.
So submission date of March 8th for hearing on March 26th.
Thank you.
Mm-hmm.
Thank you.
Well,
Just sign when you're finished? Okay. Item number 4, 81387BZ, 110 Borum Place, Brooklyn. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board, and to respond honestly to board member questions? Thank you.
Good morning, Madam Chair, Commissioners, Frederick A. Becker. We attended your review session, and actually the applicant does listen to instructions. The notice that was posted in accordance with your rules 21 days prior to today's hearing, which was on February 6th. The instructions that were given to me with the revised notice were given to me on March 12th, subsequent to the initial posting. Subsequent to that, we did send the managing agent a revised notice, which was posted on the main bulletin board for the building, which has all of, I think, 4 units. I have copies if the board wants to see the updated notice, which is the one that was sent to me by...
The ones that show a close-up of a bulletin board?
No, this is the revised notice, which was sent to me by Ms. Monroe and is in the format as approved by the board. So after we had posted the prior notice, we always send copies of the notice that is posted. We then reposted this one. So the original one was done prior to instructions.
Have you submitted those photographs?
These were not submitted, but it's just, you can see.
Thank you. Yeah, we can put them can we put them into the record?
Absolutely.
Great.
Absolutely. So that is the timing, and that is what we did, and that is why the notice that was originally posted was not in accord with the instructions that were given to me a week later.
Understood.
But once we were given those instructions, we did listen.
Appreciate it.
Okay. Can I see those, by the way?
Oh, sorry.
Sorry, I'm just scribbling on it.
I think it's all one.
This
So there
is
are
the
multiple copies.
this is the main bulletin board in the building where anything is posted.
This one at least gives you an idea of what the bulletin board is. It says the name of the realty company on the top.
Okay, the hearing notice is wrong.
Oh, no.
Why?
It says the public hearing for March 26th.
Oh, it's February 26th. Okay, confused it.
Bing.
All right, but
Sorry,
the other
guys.
one was the other one was up for several weeks.
Well, let's just put it this way. Are there any speakers up from the public on this? 110 Boyram Place? It's a gym? No? Not sure exactly how to handle this.
They might be coming on March 26th, though.
The one that's,
The original ones.
The original one
and then
was-
there's a subsequent.
But the
notice
subsequent
that-
one then overrides if you were planning to
Yeah.
come
It was only
today.
posted yesterday.
So if you were planning to come today,
Might have
and
been
then there's a
distributed.
notice that says, oops, it's not today, it's in a month.
We've been in touch. If I'm finished.
All right, so, but what is notice supposed to look like? Notice is supposed to notify people when to come to a hearing. Clear notice, come to a hearing, submit your comments, et cetera, and, I don't know, I think because our intention was to give clear notice. This was not clear notice, so I think we should give clear notice.
Is this still posted in the lobby?
It was posted yesterday, unfortunately late, so the other notice was up until yesterday.
But do you know if this is still up there today? Correct.
This is up there as of today, but the other one was up until yesterday. I was emailing back and forth, and I got an email yesterday that said, sorry, I posted it late. That was yesterday afternoon. So they had, until yesterday afternoon, they knew the hearing was today. And we've had no comments from the club, we've had no comments from Ms. Brown, who posted this. So
Right,
we've heard nothing from anyone.
Right, but often with these gyms, we hear nothing until we reach out to the neighbors, and all of a sudden we find out some neighbor experiences vibrating glasses in the morning at 6 a.m. So that's why we,
I do have with me, if it's any help, I have with me the business manager for the club, who can speak directly, if that will help you here, to answer any questions regarding comments. I'm just offering.
no, so that was not the question.
If there aren't any other outstanding issues
No,
on this
there are none.
application for the board, I feel like this could have dissuaded someone who would have been planning to come today to come till March 26th.
Yeah.
It could have. So I would suggest that the case be closed, got to be closed, and we just put it on for decision for March 26th.
Okay. Put it on for decision and it's re-noticed.
No,
just
just keep it there.
Just
Don't do anything else.
Okay.
Not touch it.
Okay, that's fair.
Just leave it there.
Okay, fine.
Okay, that's a
Okay.
good idea. Okay.
Okay,
Okay, let's do that.
thank you very much.
So we're going to close this?
Yeah, so are there, wait, I asked about speakers. Are there, a motion to close?
Chair Promoter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown?
Aye.
Commissioner Sheta?
Aye.
Commissioner Shabeta?
All right,
So it'll be on for decision for March 26th.
Thank you very much.
giving the public an opportunity to speak if they.
Oh, and if
attend.
anyone
Of
attends,
course.
yes, yeah.
Okay, thank you very much. Appreciate that.
Item number 5, 22300BZ, 272 West 10th Street, Manhattan. Hi. This is the Boy Scout thing? So I was a Girl Scout, sorry. On my honor, what was it? On my honor to try, da-da-da. Okay, this is your team? Okay, please raise your right hand so I can see them. Thank you. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board and respond honestly to board member questions? Oops. Wait. Oh, you did already, yes. Thanks. You did it already, right? Didn't you do this already?
Richard Lobel of Sheldon Lobel PC for the applicant. Good morning.
You have it, you signed in already. I have it.
Chair, we had a representative at the executive session. We understand that the board was satisfied with regards to the additional materials submitted relating to the applicant's programmatic needs. We also note the submission of a letter by Michael Hiller indicating withdrawal of the opposition as was previously expressed. And as was discussed by the chair at the last hearing, we were able to reach an agreement with the neighbors. We also further understand that as far as technical issues are concerned, there was some questions regarding the plans, particularly about the positioning of staircases in the, within the proposed enlargement. We're happy to have the project architect address those with the board.
Please state your name for the record.
Catlin Travers. I believe the question about egress was about stairs E and F in the existing buildings. The stair F is relied upon for egress from the upper floors and particularly at the cellar and first floor level for the auditorium. It cannot be removed under any circumstances. There's a potential for the capacity of stair E to be relocated to another stair, but the egress width cannot be eliminated entirely. And it would require a greater square footage increase to increase an existing or a proposed stair to make up for that egress capacity if we were to eliminate it. So we don't see that as a reasonable option for the school.
So it's just the units that are, the egress units are X, and you're fulfilling the X by putting some in these existing stairs and the balance in the new stairs? Is
We would
that-
have to shift it
Yeah.
additionally into the new building.
Yes, okay. And some of it, does it have to do with the proximity also to the, of those two stairs to the areas that are being egressed?
There are certain conditions where, for assembly areas, where you need the stairs at different distances. I believe in the case of that stair, it's a capacity issue.
Ah, okay.
And you'd
So
have
it's
to,
really
you'd have to
capacity, not
reduce,
just-
you'd have to
Yeah.
reduce the PA capacity in the existing and the proposed building.
Okay, thanks. Any other questions for the architect? Thank you very much.
Chair, I understand that there was really one remaining item, which was the approval of DEP of the remedial action plan. And the school, and we have the assistant head of school as well as a member of the board here, is under a significant amount of pressure with regards to timing issues. Obviously, it behooves the school to have construction take place during the summer.
One second.
Sure.
Sorry.
Is that DEP?
Wish.
It's for you.
Yeah, right. So we do have it through discussions this morning with DEP and that they are prepared to issue a letter. Sadly, it was not today. It would likely be on Friday.
A letter
Signing off on the wrap.
signing off? Oh,
Correct.
okay, yes, we were told that March 1 would be the date of at least response. I don't know about sign off.
It would be the promise date for response, comments, or sign-off.
Right, so have you had a conversation with them that it implies
The conversation,
sign-off?
the conversation with, right, it was just merely on the wrap in the Phase 2, and so the discussion on good information this morning was that sign-off would be achieved on this Friday, on or before.
The applicants, your environmental team still has to update the tech memo to reflect all of that. So that should be weighed with the new calendar date. continued hearing
Yes.
decision.
Right.
That
so
can
we
be
need
done-
the tech memo updated.
And we're sure that that can be done contemporaneously with the sign-off, so it would come in at the same time.
So you're assuming sign off, but you don't know that DEP would add some additional something or other that should go into your tech memo. So you'd arguably receive sign off on Friday.
Correct.
So you need to do something or other to the tech memo Monday.
Correct. We've chained our environmental consultants in a room, and they're going to be producing whatever the necessary tech memo amendments are at the same time.
We have 3 adjournments next week.
Yeah.
Okay. All right, so let's do that, but you guys are going to have to really chain all the consultants
hustle.
to their chairs, desks, and
Okay.
feed them intravenously.
Okay. Agreed.
Okay.
Okay.
Any other outstanding issues?
No, there's nothing else.
Speakers? Speakers.
Are there any speakers on this application? Yes.
Morning, John Daly, Fire Department. The Fire Department objects to this application. As per my letter of December 3rd, we requested that plans be filed with our rooftop access unit because the buildings are less than 100 feet. We, the Fire Department, need access to the roof, a 6x6 area, which I believe will alter their design, which may require them to go back to Landmarks Commission.
Oh, I thought they haven't been working with you on this? This came up a long time ago.
I contacted the head of the unit yesterday, and I was informed that there were no plans were filed as of yesterday.
So
Wait.
we had,
Is there a comment, there's a comment letter?
It sent a letter.
Who is copied on it? Sheldon LaBelle's office, but it doesn't say Sheldon.
I'm just looking, what's the date of that letter?
December 3rd?
December 3rd.
3rd?
It said, at the request of the fire department, Tech Management Group has reviewed the plans submitted with the above application to be heard by the board on December 4th. The plans will have to be revised to comply with 2014 Fire Code Section 504.41 rooftop access. Access to the building's rooftop shall be provided on the West 10th Street and Greenwich Street elevation for fire operations. Access shall be unobstructed from both exposures. An area of 6 feet by 6 feet minimum clearance shall be provided across the parapet wall and provide rooftop access areas for each 12 linear feet of building perimeter accessible from each frontage space. The applicant is advised to file plans and applications with Tech Management Unit of the Fire Department for approval and permit.
That's the roof, or are we talking about the play yard roof? Or the
Yes,
roof
well,
of the bulkheads?
Well, the playground roof, but also the building is less than 100 feet. So as per the fire code, section 504.4, access needs to be provided for buildings less than 100 feet.
For ladder
For the ladder
Yeah, yeah.
operations.
Okay. And that's because they don't, their fence is right up on the property line,
Yes, Madam
right?
Chair.
Oh, it's this.
Yeah. Doesn't that show area around? No? What is
No,
this?
no, that's just,
That's just the roof line or something like that. Oh, because there's a drawing that shows kind of I guess it's the roof or the parapet wall that's on an angle, something like that. That makes it look like they're providing the 6 feet, but it's not. Okay. Okay, well, then, yes, go ahead.
We actually would like to respond.
Kat Travers from Marvel Architects. The current rooftop design has a fenced enclosure around the perimeter with hinged panels in all of the openings. The design is being priced with those hinged openings, and we were planning to submit with DOB and FDNY and review it completely.
Those plans should be filed immediately in case.
Go to the mic.
I'm sorry. Those plans should be filed with the fire department. If we may require them to provide additional access or a different design, again, or change their facade, they may have to go to the land office.
And just so I understand, you're saying the
The parapet wall is about 15 feet high, and the landmark's approved, and it has a fenced enclosure infill inside each of the openings of the play roof, each of which is hinged for access. And then we will submit, as is required, a fire department access roof plan with, landings and pathway for approval.
Okay. I believe that they should file prior to the board decision.
Okay. So since you know what your plan is, you know what the fire department's issues are, why don't you file with us and therefore with fire department the proposal, so fire department may have a chance to quickly review. We often have these with schools where in fact, we have an application very recently where it took quite a long time because the applicant kind of wasn't listening. But the issue was constantly about access to the roof, and eventually they worked out an access plan. So if you work closely with fire department, I think you'll be able to resolve this quickly, but I don't know that you'll be able to resolve this by next week. No.
I was just the applicant in expediting the job, but as a previous case that we had, I would probably need about 3 weeks to, communication between all parties to get resolved.
Okay. All right, so 3 weeks gives us till March 26th.
I think there's a March 19th hearing date, which would hopefully be sufficient for all parties.
It is lightly, it has 21 versus 27.
Oh, okay. All right. Because fire department can sign off literally the day of, right? So if we put it on for March 21, continued hearing?
I believe that's sufficient.
I'm sorry, March 19, I'm sorry.
March 19th. I believe that's a sufficient amount of time
Okay.
that we'll be able to expedite the review and comment and go from there.
Okay.
Great.
Thank you.
All right, great.
The official submission date for that hearing is tomorrow.
Okay,
Would you like to alter that?
so obviously you need to submit to fire department immediately. So
Correct.
that they begin their review. And and in terms of the submission, obviously we're waiting for the DEP. So those are turnarounds that have nothing to do actually with us.
Sure.
Right here. So as long as you respond quickly to DEP and respond quickly to fire department, we don't have anything else to review here. And we can't close this because we have open environmental.
Understood.
Okay?
But obviously, just for the benefit of the school, would leave the board with the opportunity to close and vote on this application on the 19th.
Correct.
Okay.
Are there any speakers on this that I already asked? No? All right.
Thank you,
So
Chair.
the next hearing is March 19th.
With a submission date
Well,
from them.
from the
applicant.
yeah, from the applicant of ASAP.
ASAP. Okay.
That's what I said, submit to fire department and DEP sign off
Yeah.
is waiting.
Right.
Okay.
Great, thank you.
Okay. Item number 6, 1809BZ, 250 West 54th Street, Manhattan. This is administratively adjourned.
I just want to state, this
Do I-
is the
do I-
last adjournment that we are going,
Right.
this will be the last adjournment.
Would you like us to send a letter to the
Yes.
applicant?
Yes.
Well, it's the third, is it the third adjournment or fourth?
Is
It
this
is
the
the
third
third.
adjournment?
Third
Yeah.
adjournment.
Not
But it's
consecutive.
the matter is very simple. So I really don't see the need to prolong this, so we need to put this as the last adjournment, and whatever time they need to get everything done, give them enough time so that they can address all the issues.
Okay.
Okay, so how about, How about a submission May 1st for a hearing May 21st?
I think that gives plenty of time.
5/21, May 1st?
Yes.
1/51?
And when is the submission date?
The submission date is May 1st,
And the hearing date?
is May 21st.
Plenty.
Item number 7, 231-14BZ, 124 West 23rd Street, Manhattan. Raise your right hand. Is that your only person speaking? Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before the board, and to respond honestly to board member questions?
No, this one, swearing sheet. That's what I need.
Good morning, Jordan Most from Bryan Cape on behalf of the applicant. We were, of course, we were at yesterday's review session. I just wanted to quickly run through and sort of update the board with respect to just the chronology of events. Back on January 23rd, all the treadmills were replaced in this Orange Theory gym on 23rd Street. Test was conducted by Cerami on January 24th, which included not just a test of a treadmill, but a treadmill on a replaced wood floating flooring on isolated mounts. On February 5th, Cerami delivered a report to me, and on February 6th, I submitted to the board with that report. And then subsequently, because I know this was the subject of some discussion yesterday at the review session, the full installation was undertaken by the applicant on about February 12th, so about 2 weeks ago. The new floor was installed underneath the new treadmills, and that's where we are today. So we remain hopeful that conditions have improved. The testing on the limited basis certainly indicated that this was a much better setup, and that it produced sort of a reduced sound, and actually no sound that would be heard. But now I guess there's been a 2-week sort of trial period, if you will, where the treadmills have been in full operation, the 15 treadmills on this new flooring.
But there hasn't been testing of all the treadmills in
Correct.
operation for a class.
That's correct.
Wait, I'm sorry.
Go ahead. When's that going to happen?
We haven't actually scheduled that. We were sort of waiting and maybe hopeful. I know there's someone from the building is here. Maybe that's not even necessary if we hear that there are no noise impacts from this improved installation.
Have there been any complaints in the last 2 weeks?
We have not heard any complaints, no.
And when's the last complaint? When did you hear the last complaint?
So I I'm reluctant to characterize them as complaints. I would just rather characterize them as inquiries, because very often, actually, they don't actually materialize into actually being able to be attributed to the gym space. Sometimes there's no activity in the gym, or sometimes it's not any activity in the gym.
Okay, so the latest inquiry...
At any rate, yes, fair enough. February 2nd and February 5th, there were inquiries made by Andrew Lee regarding noise in the gym. Every time since the last hearing, all videos have been immediately shared with Andrew Lee as per the board's request. So,
And upon him reviewing these videos, was it attributed to something well, at least did he attribute it to something?
We didn't hear back from Andrew Lee that he disagreed with us or felt otherwise. So,
Okay, well,
but
we'll
you
find out.
don't have to hear it
Right,
from
you're
me, you
right.
can hear it from him.
Thank you.
Okay, so my inclination is to say, you went to all this trouble to do this thing, you hired a testing lab, and you should finish this off by having a testing lab check during a full class that's taking advantage of all the treadmills, because that's what the testing consultant, the noise consultant actually said, was this may not work great when all the treadmills are in operation. So this is a way to find out whether it's working when all the treadmills are in operation.
Yep, I understand that. I guess my concern is that yesterday's review session, it seemed that there was more emphasis was being really placed on the neighbors, and that almost arguably without regard to what the test results are. If the test results conclude that there is no sound or it's inaudible, but someone says they still hear something, the test results may be disregarded. So,
Might be.
I guess
Because they're not vibration testing, as far as I remember. They're noise tests, right?
I think
Are
they
they
test.
vibration
I think they
also?
test
Okay.
both, yes.
Okay, all right, well, let's hear from Mr.
Sure.
Lee first. Mr. Lee?
Please state your name for the record when you come up.
My name's Andrew Lee, reside at 124 West 23rd Street, Apartment 4B. I also serve as president of the condominium board there. So I guess progress has been made. I guess I'll speak chronologically as to the noise complaints on February 2nd, February 5th. At one point, I heard thumps. I was sent video in a timely fashion, I should note. It showed some people doing burpees. It was, I guess I would say, inconclusive. The other video was I had heard treadmills, and the video indicated that they had a full class at the time. This was before the changes were made to the flooring system. So at this point, I don't think that that's especially relevant. We did conduct testing on, I believe, the 24th of January. And what you recited seems to be consistent with what I was present for the testing. And basically, they were only testing one treadmill at a time out of 15. And I guess the results were essentially inconclusive. They basically couldn't pick up anything, either, with the old flooring or the new flooring, but they also had installed new treadmills. So basically, we couldn't really tell if there was improvement, or if there was improvement, what was causing the improvement, because of there were just too many variables. New flooring was installed, I believe, on February 12th and 13th, less than 2 weeks ago. As I emailed written comments yesterday. As I noted in my written comments, there is a 16-story condominium under construction immediately next door to us. They're doing construction, they're working on the foundation right now, and they're doing construction Monday through Saturday, starting at around 7 o'clock a.m. So as a result, there's literally been only one day that I've been present in my apartment when there wasn't construction going on. That was actually Sunday morning. I note that I didn't hear anything, but that said, that's not a very large sample. I think basically what we need is more time, and I think it would be helpful if someone could make observations with a full class, with all 15 treadmills in use. So my request would be that we be given more time to observe and also conduct testing, and hopefully, we will determine that our issues have been resolved.
Okay, thank you very much.
Thank you.
Hard to get silence in New York, isn't it?
Any other speakers?
Yeah.
Are there other speakers? Sorry.
No? Okay.
Okay, so interesting confluence of events. So I actually personally think you should test. You went to all this trouble, this testing
We'll
lab?
do the test.
If it's a cost issue, so I'm a bit torn. If it's a cost issue with regard to testing, then the option could be more time, and Mr. Lee, if he has any complaints on the various Sundays that he's there,
In the realm of costs,
in the realm of cost.
this has been an incredibly costly process. Lawyer coming all this time and doing all this work. Installing
Right.
new subflooring, et cetera, et cetera, et cetera. So I would say to finish this off in a more timely manner, that the testing would be
Okay.
the most expeditious. Okay. So, all right then, how much time we could put this on for April, I suppose? Something like that.
We don't, I'm sure we can test within a matter of a couple of weeks.
April 9th is 27, April 23rd is 21.
23.
Okay. April 30th is 12. April 23rd then, of the submission, April 3rd.
423 and 43.
That's right. Okay.
Thank you.
Thank you.
New cases, item number 8, 1059-84BZ, 943-61 Kings Highway, also known as 2032 Coney Island Avenue in Brooklyn. Okay, raise your right hands. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before the board and to respond honestly to board member questions? Yes. Thank you. You can sign when you can finish. Or you can, yeah. Please state your name for the record and proceed.
Good morning. My name is David Kupfer. I'm an attorney with the law firm of Kennedy CMK, and we represent the applicant 24 Hour Fitness. With me is Stephanie Hibbert, who's another attorney with my firm, and the operations manager of the particular club, Stacy, is also here with us this morning. By way of background, the club is located at 943 Kings Highway, also known as 2032 Coney Island Avenue. Prior to the operation of the club by 24 Hour Fitness, Bally's Total Fitness was the PCE until a transfer of ownership in 2015 to 24 Hour Fitness. Historically, the BSA has granted a special permit to this PCE. The latest approval was on December 15, 2015, when the board granted the present 10-year term for the existing special permit, the expiration of which is May 7, 2025, and granted an amendment to permit both the change in the operator to 24 Hour Fitness and a change in the gym's hours of operations with conditions. Before the board are copies of our application, including our subsequent submissions. The application was originally made on July 5, 2018, to reopen and amend the resolution of the BSA for a special permit to reflect minor changes in the interior partitions and layout. The changes are as follow. On the first floor, minor partition reconfiguration of the retail space. A portion of the employee lounge has been converted to retail. A child care room has been converted to a cycling room, and a new 3-foot 8-inch egress door has been installed. On the second floor, there's been a partition layout change in the aerobics room, and spinning and cycling has been relocated to the first floor as mentioned. And on the elevations plans, there's reference to a new 3-foot 8-inch egress door installed, which is egress for the second floor and cellar. We submit that these improvements are not controversial in nature, and we respectfully request that the board approve our application.
Thanks. Can you say, when the spin room was relocated, was a spin room constructed that's like a box within a box or anything like that, or it's just they move the lights?
They're just partition.
So I don't know if you heard, did you listen to the review session? Do you know about this Monday morning review?
Ms. Hibbert was at the review session.
Okay. So one of the questions was, how long has the spin room been in the location, and whether you've gotten any complaints about it?
I'll let Ms. Hibbert speak.
All right, thank you.
Hi, good morning, board. Good morning, chairperson. So as to...
State your name, please.
Oh, yes, Stephanie Hibbert. As to your first comment with respect to the cycling room, it has actually been in operation since approximately 2016. That was a question at the review session.
In the same location that it is now?
Yes, that's the first floor.
Okay.
There are 25 spinning bikes, and I know chairperson had a question with respect to the sound attenuation measures, and there are double thick decking they're double thick 1-inch width. Oh, hold on. It's definitely a tongue twister.
True.
Yeah. It's in the revised statement of facts, page 9 to be exact. Thank you. It's okay.
We have a table here, you can put all the...
Yeah, we have like a lot of submissions on this. So on page 9 of the revised statement of facts, which we did submit on February 19th, there are double thick decking with 1-inch rubber floors, and there are cushion tiles as well to reduce and or eliminate noise vibrations to the tenants in close proximity. And based on conversations with the operation manager and other employees, there hasn't been any complaints as to noise with respect to the tenants in close proximity. There was also an additional question with respect to the massage therapy room. Also in our 2/19/19 submission, we did clarify that as well. There is no massage therapy room anywhere in the PCE, and as such, we revised our plans as Chairperson instructed us on 1/29 to do, and those were also submitted on 2/19/19.
I thought I looked at those and I saw massage therapy room. Which floor?
The plan, it's BZ, should be dash, tell you the exact plan number. So the plan is Z-003 that was submitted on 2/19/19. And it has been revised to show the current use, which is storage.
Ah, it was that storage room, okay. That was the storage room up here. One of these rooms was therapy. Okay. Okay, thanks. All right, is everybody okay on the spin studio and so on? We often have issues with spin studios, that's why we were asking. Okay, are there any speakers on this? And fire department signed off on this one, right? Yes, okay. So, all right, so I'd like to make a motion to close then.
Chair Promoter?
Aye.
Vice Chair Chanda? Aye. Commissioner Otley Brown?
Aye.
Commissioner Sheta?
Aye.
Commissioner Shabeta?
Aye.
And a motion to grant.
Chair Promoter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown?
Aye.
Commissioner Sheta?
Aye.
Commissioner Shabeta?
Aye.
This application's been granted.
Thank you.
Thank you. Don't forget your stuff.
Be careful the wire. Thank you, Mr. Burke. Just sign. Let me just take this inside. Inside. Okay. Item number 9, not here, this one. 33698BZ and 33798BZ, 324 and 334 Flatbush Avenue, Brooklyn. Please raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board and to respond honestly to board member questions? Okay.
Good morning, Todd Dale for the applicant. So from review session, I know there were a few questions that were raised. Sorry, I'll try to,
We can
little
hear.
throat problem.
All right.
So with respect to certain questions that were raised, first, I know there was a question about access and how the different sides would work. Just to clarify, there are 3 ADA lifts within the site. The main entrance will be at the 312 Flatbush building, which, the way we describe it, is the one that's the rectangle lot, not the angled triangle lot. So that's going to be the main entrance.
The one to the right.
The one to the
Far
right, as you face it from Flatbush, correct. So patrons would enter there, that's where the reception lounge is. There is a lift there that's dedicated to this space. It is a different sort of setup there, but that is their own dedicated lift that's there that could take patrons up to the second floor. When you travel from east to west, there is a grade difference between the two buildings. There is a third or second lift in the middle there that raises approximately 18 inches to allow access over. And then there's another lift in the triangle building that goes from the second floor down to the first floor. There are existing doors that are there. They do not plan to use those. The plan right now, I think they
Sorry,
leave
there are
them-
existing doors that are there.
There's existing
what?
doors on the triangle building.
Yeah.
So, but they're not going to be used for active use. The plan is to leave them there for egress purposes, but they'll probably have security bars on them, you know, at some point. They would, you know, like to leave the doors there because in the future, depending on operations, they may want to switch the layout, come back to the board, you know, as required. But that's the setup right there. It does require going up, down, and over, but we would say that, you know, for any business, if you're visiting a gym, an extra walk is not going to hurt you.
Yeah, I mean, it's a gym, but,
So that's
but
what-
it's,
so-
this is always about disabled access,
Exactly.
right? So,
There was a question about the cellar, spoke to the project architect after the review session comments, and he said that it would be classified that as non-occupied space, so it wasn't required to provide a lift down there.
yeah, I agree with that, right? So when you say lift, that was the part that was confusing. These are really like lulas. They really go a full story. It's not
Exactly.
just going up a few feet. One
Well, the middle one-
goes up a few feet, and the
Exactly.
other is a full story lula, really. Okay.
Exactly. That's the setup.
Okay.
Okay?
And the other one, there's two. There's one on each
There's
side?
one on each, correct.
Okay. Clear.
So that's
Thank
what
you.
it's there. Now, there was a question, I know, at the review session, I believe there was a question about the fire department, but since then, the fire department did submit the letter of no objection. We do agree with the condition that was noted in there. The fire department noted that the certificate for the place of assembly hasn't been obtained. As the board knows, you're required to get the CO in order to get that, so that's part of the whole process. We are aware of that. We've been responding to the violations, and our firm has actually been appearing at court for those. And as soon as we are able to get the TCO, then we can get the PA as part of this and resolve those situations. So we are aware of the fire department's condition. We understand and we agree, and we're working towards resolving it.
Okay. So I think the only question then would be whether fire department is okay with us proceeding, and they'll take care of it. Chief Daly is nodding his head yes.
Okay. That's good.
So, okay.
There was a question about the TCO as an update. Again, I spoke with the project architect and the excavator yesterday to provide the board clarification. Their current estimate right now on the long end would be 18 months to obtain the TCO. That involves completing the construction, and it would also then be predicated upon the board granting this so they could get the TCO. I asked them, just to clarify, there was a lot of history with the site with the multiple buildings, the examiner leaving, we detailed that in the letter. There are currently 2 DOB applications, one 3007-463 for lot 15, and one is 3101-20754 for lot 19. They've cleared all the old applications. Those are the 2 applications that everything are proceeding under, and they're going to move forward on those applications. It really was a lot of administrative history with the prior architect and the original Jim that filed things improperly, and it's been cleaned up. Crunch has really brought the full army towards this one to try and resolve the issue. So that's the timing for the TCO. And I asked them regarding the process, and they said that to get the TCO, it would be the standard, basically standard inspections. They told me it was general construction inspections, that they would need a plumbing inspection, a PA inspection, an energy inspection, and then to get the letter of approval for the sprinkler and the fire alarm, because there is additional space, they would need to get that. But those are the inspections that would be involved to work towards the TCO. But as I said, 18 months was the window that they provided.
Thank you very much for finding that stuff out.
I know there was one other question also, just to clarify, the zoning analysis of record, there is an error with the one. When they were doing it, there was a typo and they missed one of the floors. So it really is just a little bit of a change. Depending on what the board determines as far as the schedule, we could even get that changed and submitted today.
Really? Okay.
If you don't rush it along.
Let me just ask if there are any speakers on this. I don't think we had any issues other than just these clear-ups, so if you could fix that now.
Okay. I'm going to be here for a while.
Okay.
So if the board agrees to a second call, I will reach out to the architect right away, get the zoning analysis changed for the one lot, get that submitted to the record.
Okay, great.
Thank you.
All right, thank you.
Item number 10.
Wait, just 1 second on this. I just want to say, you don't need to be there for me to say, I just want to say that if fire department has conditions that they'd like us to incorporate into the resolution, we'll incorporate those conditions, okay? I didn't see their conditional.
There was a condition.
John Daly, Fire Department.
Yeah.
No, Madam Chair, thank you.
No condition.
We have our violation orders on the property. We will do our due diligence and enforce them. I don't believe the board has to add any condition. Thank you.
Okay, great, thank you.
Item number 10, 12207BZ, 1630 East 15th Street, Brooklyn. Raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before the board, and to respond honestly to board member questions?
I have the tax map.
Good morning, Madam Chair, Frederick Becker. We attended the review session yesterday. I understand there was some clarification needed on the zoning lot boundary. We provided updated plans which more clearly show the zoning lot boundaries that were on the original EP1, the plot plan, and we provided zoning lot district boundaries on the site, the floor plans, EP2 and 3, which had not been previously done on the prior approved plans, and the site still clearly in compliance with Section 7711, and does the plans conform to the zoning, to the radius diagram and to the zoning map.
Can I ask you, before you submitted those plans to us, did you yourself check the zoning map?
Yes?
What did the zoning map say?
The zoning map shows the zigzags.
And what's the distance from the, of the district boundary line from the street line?
That I don't recall offhand. I mean, we said we're approximately 20 feet, and this is what the architect gave us with a scale. It still is within the 25-foot.
So, this is why I asked you the question. Did you look at the zoning map and verify that what the architect was showing on the plan was accurate relative to the zoning map?
He confirmed...
I asked you,
No,
did you?
I did not reconfirm the architect's plans.
Okay, so the architect's plan is incorrect. I'm looking at a zoning map right now, as did Commissioner Shanda. The zoning map shows the district boundary line 160 feet in from Avenue P. You're showing, or the architect is showing 180 feet plus or minus. How you get plus or minus, the zoning map doesn't do plus or minus. Then I go to the tax map, and unless the tax map is incorrect, the property line on East 14th Street is exactly 160 feet from Avenue P. So explain to me how those drawings are correct, and you verified that they were correct.
I will check again. Are you claiming that the site is... All right, you're saying it's 160 feet from Avenue P until the C44A
Not
zone?
claiming, I'm looking at a tax map.
Okay, fine. Okay. And, all right, I will go back and check. He's showing 180. I don't know.
So you have to independently check this,
Okay.
right? Your zoning council, you have to be looking
Well,
at
according...
the zoning map and
Mhm.
looking at the tax map and verify that the architect is correctly describing the location
Well,
of the zoning district
I'm
boundary.
looking at the radius diagram,
Is that a zoning map?
but it's taken from the zoning map, and it shows...
But does if it's taken from, does it mean automatically it's accurate?
No, but if it shows the tax lots as they are shown on, you're claiming the tax map shows different from the
I'm not
radius.
claiming anything, I'm reading the tax map.
All right. Let me...
Okay, well, revise the...
Okay, so you need to revise it, but it's not acceptable, really. We directed you to take a look, and you did not take a look. You relied totally on the architect reconfirming or whatever, just restating what was said before. It wastes our time. All right.
Okay, we can...
Are there any speakers on this? All right. We still need fire department. I think fire department...
Fire department sent the letter.
Send the letter. I'm sorry,
This
I
morning.
know this because we had a lot of stuff going on yesterday. So they sent a letter and it was a sign off, right? Okay. Okay. So the drawings need to be revised if you want to revise them today, but you
I
need to
don't
take
say-
independent
today won't-
responsibility.
Today won't be possible.
Excuse me.
And my apologies for the inconvenience of the board.
April 23rd?
I mean, we can get them done within a matter of days. That's the...
Right, so that's why we're going to put it on for April 23rd with an April 3rd submission. We have a very full calendar in March.
I do have a decision coming up, you just gave me, on the 26th, if it could be...
We have a very full calendar in March, so April 26th, is that what? April 23rd? April 23rd.
Okay.
Item number 11,
Is it continued hearing, or is it a closing?
continued hearing.
It's a continued.
Continued hearing, we don't have
Because you don't have the
accurate
plans.
document.
Okay, fine.
Yeah.
Just checking.
Okay.
Thank you.
April 23rd.
Item number 11, 2016, 4141BZ, 27 Barclay Street, Manhattan. Raise your right hand. And who's speaking? Just you? Okay. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before the board, this board, and to respond honestly to board member questions? Yes. Please state your name for the record.
Hello, my name is Eric Daniel. I'm from the law firm of Kramer Levin. I'm here on behalf of the applicant. With me today are Phil Sfraga from the Four Seasons and Luigi Russo from Slice Architects. Also with me is Elise Wagner from Kramer Levin. At the board's review session, the board made 2 comments that I would like to respond to. First, the board pointed out that the statement of facts identified the elevation of the outdoor terrace at 78 feet 10 inches above datum. We will update the statement of findings to identify the height of the outdoor terrace as 52 feet, 5.5 inches above curb level. Second, the board requested that the applicant provide massage licenses. I brought with me today proof of the current New York State registration for the massage therapists that work in the spa. These are in the form of printouts from the license. These are the license verifications from the online verification database of the New York State Office of Professions. And they provide the name and license number and the date through which the registration is valid.
You have those here?
I have those with me here.
So here's my question, because the only thing that needed to be changed on the statement of facts was quite literally the height of the building. So the idea of having to put this off to another hearing date.
But the plans are accurate, correct?
The plans are accurate, the statement of facts, it's okay?
That's fine.
I just want to make sure council doesn't...
That's fine. Well, we refer always to the plans and any.
Okay.
So we
if-
do need the registered licenses in the record. Are you able to submit those copies electronically?
You email them to me?
Did you do them now?
Yeah, you need to do it now, and we're putting it on for second call, okay?
Is that possible?
Yes.
Okay, that'd be great. Thank you. Okay, so are there any speakers on this? So everything else was, right, everything else was fine. So if we could just get the licenses submitted, then we'll put it on for second call.
Can I
As soon
just
as
ask-
you have them.
Can I
What?
just ask a question? So it says date of licensure is 3/4/2004, and it said registered the last day of 3/21. Does that mean 2021?
Yes, yeah, list the month and the year.
That's my question. I don't know. You see all the dates in there? Because some of them are from 1996.
Yeah, list the month, and then it says
Oh, the month and
last
the
day of the
years.
month, and then the
Yeah, 120.
And these are persons you know to be performing these services at this location?
yes.
So the way that you did this was you got a list of the people who were performing the services, is
client
that it?
sent us
And then
the
you
list.
looked up their licenses as opposed to them sending you? Is that how you did it? Okay. We often actually see the licenses with little
photocopy,
photos.
yeah.
So, okay. All right, so second call this?
Yeah, so if you can just electronically submit all of these
To
submit.
To submit.
CC myself and Ms. Matias.
Okay.
And then we'll be able to just call you back.
Okay.
Okay, thank you.
Decision items, appeals calendar, decision items. Item number 12, 2016-4473A. 7274 East 3rd Street, sorry.
Morning, Madam Chair, Commissioners, Mark Mitzner.
Right. Okay, sorry, I'm scrolling. I think, did you want to say anything? No, other than your name? That's it, okay.
That's all for a decision.
Not my appearance, and that's it.
It's closed, so.
It's closed, right? Okay. And we didn't find any further submissions from the neighbors. Are there any neighbors here? Actually, it's closed, so that's maybe why we don't have any further submissions. But wasn't there something where we were supposed to hear about I want to just ask, are there any neighbors here on this one? No, okay. So then I'd like to make a motion, let me see, fire department, to grant on condition that, on the conditions of the fire department's conditions, right? And that the fire department would, basically, we would be relying on fire department's inspection of the building to verify that existing doors and smoke detectors meet fire department standards, okay? That would be our condition.
John Daly Fire Department. The fire department agrees to the conditions set by the board. And I have notified the administrative companies and also various units in the Bureau of Fire Prevention. So, and they will report back to me immediately. I'll provide a report to the board, and we're good there.
Great, thank you very much. Okay, so those are the conditions that would be in our resolution, okay? So on that motion, a motion to grant.
Chair Promoter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown?
Aye.
Commissioner Shetta?
Aye.
Commissioner Shabeta?
Aye.
Okay, thank you.
Thank you.
Application's been granted. Continued hearing items, item number 13, 205-15A through 214-15A, 12860 to 12876 Hook Creek Boulevard, and 12863 to 12875 Fortune Way, Queens. Sorry. Want to do the next one? Yes, Schley.
Good morning, Todd Dale for the applicant. To start, apologize for any confusion with this application. Just so the board's aware, we had originally submitted an adjournment request because we knew that there were outstanding issues. But after we had discussion with board staff, we did submit the information in the slightly revised restricted declaration. Just to give some background on this, we understand the need to determine whether utilities under the shared roadway and also with respect to the HOA. Our office wasn't previously retained to work on the HOA. We are now. So we will move forward to address that accordingly. And any organization that we set up will reflect utilities whether they're there or not appropriately, okay? With respect to the restricted declaration, just so you know, the one that we did submit referenced a future HOA, and that was the intent because we didn't know what was going on with that. We can amend that accordingly. Just as a quick aside, also the fire department had submitted, the other thing is at the time of the last submission, we were still waiting for an updated fire department letter, which was part of the reason for the adjournment that has since been submitted. I actually spoke with Inspector Daly about the conditions and the items that were put in the fire department's current letter. We're going to reach out to the property owner to discuss the possibility of sprinkling those 5 homes. However, just so the board knows, based on code and the existence of 129th Avenue, we think some of the information the fire department might be incorrect. So we're going to respond accordingly before the next submission, either addressing the points from the fire department letter, working with the fire department regarding their condition, or proposing to install sprinklers, and again, we'll include that in the next submission. Just so you know, there was some confusion. 129th Avenue, just so the board is aware, is actually currently paved and improved right up to our lot line. There's a guardrail that's right there. So some of the concern about the distance of the fire apparatus access road is actually, the measurement is off, because the fire apparatus access road would actually just be the proposed Fortune Way. It wouldn't be measured all the way to Brookville Boulevard because 129th Avenue is a city map street. So that's where some of the confusion comes up with the sprinkler, but we realize that that's something that has to be addressed. We also spoke about the question, we'll clarify the hydrant issue. There is a hydrant shown in the cul-de-sac. It may not be exactly where the fire department prefers. We can move that one way or another as needed. So the short of it is we realize that there's more that has to be done to respond to the sprinkler issue and the maintenance agreement. We are involved with all aspects of that now,
Yes.
so we can
Okay.
move
Makes it more
forward
efficient.
accordingly.
Okay.
The question I would have as far as the time for adjournment.
Before you just do
Sure,
that.
sure.
So, our council has a copy of my notes that I made yesterday about everything that has to be in the restrictive deck.
Sure.
But you should have notes from yesterday's review session to make sure that all of those issues are covered in your restrictive deck and HOA, so we don't have to do this again.
No, I understand. And just so you know, I know there was a question like about the sign. We did include an actual copy of the plan that actually showed the sign,
Yes.
but we didn't use the language of the sign in the declaration. We can
Right.
specifically reference the sign.
Sort of
and say the
tying it
sign.
up.
Sure,
Yeah,
that's not a problem.
Right, okay.
The question I would have as far as timing, though, is I know the board, we've had HOAs for situations like this before. Is the board's preference, I guess the question would be, how far into the HOA process would the board want it, like filed, completed? Because I know sometimes we...
It's a draft of the HOA, right?
Just
You
a
know
draft.
that you're really,
Okay.
it's a very long process. You need to get it approved by.
Okay, so if we had the draft of the HOA and then the restrictive declaration referencing
Reference,
the draft
yeah.
HOA, that would be sufficient?
Yes.
Okay.
And because we want the restrictive deck recorded, right, and the HOA might not be approved by the time it's recorded, it would say the HOA which will be recorded or something like that. In other words, it's
The future
still a
HOA
commitment to a
yes.
future HOA.
Sure.
Right?
Okay.
And then, as is the preference, as soon as your team has done all of those documents, submit them both to submit and to council's office, our
Or
council's
just to me
office.
directly, yeah, that's fine.
Yeah, and let her know that it's being submitted so it can be reviewed in advance, because the part that holds this up is we often don't find out it's been submitted. Council doesn't find out it's been submitted until we start to review the applications, and now it's too late to do a turnaround of a legal document, right?
So, time-wise then, since we're not waiting for the final HOA approval, I believe that, the restrictive declaration would be very easy and quick to do. The HOA timing will take a little bit longer, but not as long since we do it. So we're agreeable to a board schedule, but if I had to guess, I would say, let's say 4 to 6 weeks to submit, I think.
That's good.
Is my estimate, but we can be flexible one way or another.
1, 2, 3, 4, something around March 20th to April 3rd.
And by then also the plans would be revised to reflect the fire department's comments with regards to cul-de-sacs and sprinkler.
Yes, yeah.
and all.
The issue with the fire department we will work with the fire department directly. It's either going to be the sprinklers installed, in which case it's resolved, or if they understand and agree with our interpretation, then we would make any changes to the hydrant accordingly.
Well, 6 weeks is April 10th for April 30th.
That sounds lovely.
It'll be spring.
Any speakers?
Are there any speakers on this? I also have a question about the sprinklers. Is it a concern of expense? Is that, and it's really such an enormous expense? I'm just curious why there's so much pushback. It's because it's expensive for you to keep coming back, right?
Yes, how's this? I'm not making that business decision. Okay? But sprinklers are not, for new homes, it does add to the cost of homes, and that's one concern.
Requirement. So you could make that a selling feature even. I think you would prefer to live in a house with sprinklers, frankly, these days. But anyway, okay.
Okay, so the 10th and the 30th.
Yeah, it brings down insurance costs. It's how you would market it. Cheaper insurance, things like that. Yeah. True. Anyway,
And
let your
March for the
client know.
orders I'm given. March for the orders I'm given.
Okay, thank you.
Sure.
So April 30th and April 10th submission?
That's right.
Yeah.
Thank you, Council. Item number 14, 2016 4296A through 4298A, 3236 and 3238 Schley Avenue, and 580 Clarence Avenue, the Bronx.
Good morning, Todd Dale for the applicant. So thankfully, at long last, we had resolved the issue with DEP. We learned a lot about drainage plans along the way, and hopefully everyone will take that knowledge moving forward. With respect to the other questions, we did yesterday submit revised plans. I don't know if the board saw them, okay, with the corresponding zoning analysis, and all the lot areas and zoning areas correspond. I know there was a question regarding the yards. As I went back through the note, I think that these yards do comply with the R3A equivalent, which is the 8 feet or 0 feet. There was a question at one point with the existing home that is on Lot 5 and the space between, but it needed to be 8 feet, and it, as shown on the plan, there's actually a note there that it's 8.17 feet, 2 feet on our subject Lot 7, and 6.17 feet on the adjacent lot. I think that's 23-461C. That's something that we had gone over before, but there is a note on the plan, and they did confirm that there is that 8.17 foot difference in addition.
And then just to help you clarify this, on the lot, the home that says proposed second floor.
Yes.
So there's an existing one-story house that has a non-compliant front yard, is that correct? And so they're just pulling back the second floor to the required 10 feet. Is that right? Okay,
Correct.
that's the part that I wasn't.
Yes.
And then, and so we're measuring from then the property line for the 10 feet?
Yes.
Or let's say, not from the property line, actually. We're measuring from, I don't know what we're measuring from. That's part of it. So you're setting the sidewalk. I guess that's my
That's the existing
curiosity.
street line.
That's the existing street line.
Right.
And the line that you're measuring the 10 feet back from, how is that, what is that line? Right,
Yes.
so.
I don't
It
have
says-
the magnifying glass with me right now, so it's a little difficult.
And I think
Actually, let me
that's
look at this
the
bigger
existing
plan
No,
here.
but then go to the next, go to the new building.
But the new buildings are from,
They're measuring the front yard from the new sidewalk line, right?
Yeah.
So,
So that is actually the property line that it's measured from, because the sidewalk is actually within mapped Schley Avenue, because Schley is actually a mapped street. So as I read it there, that concrete sidewalk and that new sidewalk that's being there, that lot line where the numbers 40, 40, and 50 are, that's actually the property lot line, I believe.
okay, so this is a little bit of a mystery, so all I just want to do is say something to the effect of DOB and DOT to verify measurement, front yard, well, it's really DOB's measurement.
And we would agree to that.
Yeah.
Just so the board also knows, we did not submit it to the record.
I need to finish that sentence.
Sorry.
Yeah, so we know what to do, because they're
DOB
right.
to review.
To review location of houses relative to the required front yard.
Say that one more time.
Or maybe there's another nicer way to say it, but DOB to review the location of the proposed houses.
And expansion.
And the expansion of the existing house, comply with front yard regulations relative to distance from property, street line, or whatever, yeah, let's say.
We understand.
Front yard depth, just say front yard depth.
Okay.
Because I don't know how they're measuring it. And I
Understood.
think that's something with the planning, I think they're gonna have issues with the plan examiner, who also won't know how to measure.
Just to be clear that we're not waiving any.
We're not
further-
waiving, yeah, to be clear, we're not waiving any front
We
yard
understand
requirement.
that no waivers are being provided, and we will. Just so the board knows, it wasn't part of the last submission, but I had spoken to the architect. The original builder's pavement plan that we had submitted to the record, the draft one, actually had, remember, up to the north of the lot, it had that strange L to the
Yeah.
continuing sidewalk. And based on the board's suggestion, we had made it a smoother curve. Subsequent to that, while we were waiting for DEP, this was actually 2017 that was submitted and approved, that shows the new division, and it actually includes the same measurements over here as BPP. We didn't submit this to the record, just so the board is aware. Although that was changed, they are going to have to amend this during the process because some of the footprints of the building have slightly changed. The street arrangement is not changing at all, but because the footprints are changing, this is going to have to be amended again a second time during the process. But I just wanted to let the board know that the swoop up top, I guess I'm calling it, has been reviewed, and they've also looked at that measurement line, but we understand that it'll be further reviewed during this process.
Okay. Did I already ask if there were speakers on this one? Okay, so I think we are good to go, right? Everybody, yes, right? Good? Yes? Okay, so I'd like to make a motion to grant...
To close.
I'm sorry, to close, sorry, to close.
Chair Perlmutter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown?
Aye.
Commissioner Sheta?
Aye.
Commissioner Shabeta?
And a motion to grant, on, I guess, on condition that DOB verifies that the front yards comply with zoning regulations, and that, to be clear, that there's no waiver of front yard regulations, okay?
Chair Perlmutter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown?
Aye.
Commissioner Sheta?
Aye.
Commissioner Shabeta?
Thank you.
Oh, you stepped out.
That Commissioner Shepard here for the.
Huh?
Commissioner Shabeta stepped out while I voted? Will you voted?
There were just 4 votes.
Okay, fine, okay. Item number 15, 2017-16A through 2017-19A, 1558, 62 Clintonville Street, 150, 93, 95 Clintonville Court, Queens. And item number 16, no, the wrong one, huh? This one. Item number 16, 2018-105A, 150-87 Clintonville Court, Queens. Yeah, sorry.
Good morning, Sandy representing the applicant. Sandy Agnostu.
Hi.
Hi. I attended the board's review session yesterday. I noted the comments, and I'd like to update the board on the fire department issued a letter of no objection yesterday regarding the proposed project in its entirety, which includes lots 23 and 24, with certain conditions that were actually part of the previous letters that were submitted. Those conditions are all noted on our plans, and they include open space easement for 3 buildings, that the 3 buildings in the private access road, 150-87, 150-93, and 150-95 Clintonville Court, be fully sprinklered, and all residences be equipped with hardwired combination smoke carbon monoxide detectors. Also, the following conditions must be met: joining open space declaration and access driveway declaration or homeowners association declaration shall be recorded and noted on the certificate of occupancy.
So were those easements, declarations, and so on drafted?
Yes, we submitted on October 6th, we submitted the homeowners association and also declaration of covenants. On February 6th, we submitted the draft restrictive declaration, and I received comments yesterday from council regarding those, which we will revise and resubmit. Yes.
As soon as you receive the revised RD, can you just send it to me before your
Sure.
next submission date, just so I just happened to miss it the last time, my apologies.
Okay, and actually spoke with the attorney regarding it yesterday and forwarded the comments to him so he can work on it. And we also submitted easement descriptions and updated survey showing the easements on February 6th.
So you submitted what the fire department describes as joining open space declaration?
Yeah, in addition to
I'm not really sure
that,
what that is. I'd
okay,
like to hear them.
we also have a reconsideration from the Department of Buildings, which that's in the record as well.
Sorry, what's that have to do with the joining open space declaration?
I'm saying for frontage space.
Sorry. Fire department requires an adjoining open space declaration. Are you saying that's not required now, or you're saying you're going to provide that, or are you saying you provided that?
No, we did provide the easement diagrams on February 6th.
I think you don't understand my question. Let's get fire department to tell us what adjoining open space declaration is.
John Daly, Fire Department. In reviewing the reconsideration issued by the Queensborough Office of the Building Department, they required the applicant to file an open space declaration. I just wanted to continue that language while the Fire Department does not require declaration, the Building Department does, and so I just wanted that language included in my letter of no objection.
So this is an open space declaration. What's adjoining open space?
Okay, from what I reviewing the plans and the reconsideration, the driveway that they're proposing, that there be no building there, or no obstruction with signs and things like that. That's what they were able to obtain reconsideration from the DOB, that, okay, your front yard, I think it was 12 feet, and plus part of the driveway, we'll count that, they counted that as open space. So the DOB issued that recon, and we'll have to honor that and accept it.
Okay. So, I understand.
So the easement is therefore not located all the way from the frontage of Clinton. It's after the front yard is defined, it's whatever is behind that is to be counted as the easement.
Correct, right, yes, so.
Thank you.
Thank you.
You're
So an open space declaration is a standard declaration that's required that exists in form on the Department of Buildings website. I'm thinking that that's what they're talking about, but I don't know. So you didn't provide to us an open space declaration. You provided apparently an HOA and a
Declaration of covenant.
declaration of
And a
covenant.
restrictive declaration.
And a restrictive declaration, none of which are addressing the subject of open space that DOB requires, which is a separate thing, right? Open space declarations are kind of a form declaration that you can get, like they have lot line window decks and things like that, right? Right? That's what
I'm looking at DOB's website right now, and I see a frontage space declaration, but I don't see it.
We have, okay.
So you need to clarify what it is that DOB is requiring, because we need that.
We have a reconsideration from the Buildings Department regarding the open space and frontage, and it includes the diagram that shows the easements, which was approved.
Yeah, but you're misunderstanding the difference. A declaration is a document that's recorded against the property. It's a legal document, right? There's reference to a declaration for open space that needs to be recorded. So your easement recon, I don't really know what that is, but there needs to be an easement created, which we don't see. An easement is also a legal document that needs to be recorded against the property. So you can't just show the easement on a drawing.
No,
That's
okay.
right.
We did submit those on February 6th, the easement descriptions.
No. So this is the part where not being a lawyer is putting us both at a real disadvantage here. A lawyer drafts an easement document, right? So you need to have a lawyer draft the required easement document so that we have it all wrapped together. And if this is something that you're not understanding, you're going to need to consult with counsel. You're going to have your client hire a lawyer for this, because we can't keep going back and forth about what this is, okay?
Right, okay.
Okay, so we need to clarify whoever drafted, for instance, your HOA and your...
It was an
covenant.
attorney.
Okay, so the same lawyer will need to do this open space declaration and easement document to grant the easements. The idea is that the various neighbors enjoy an easement one to the other. Okay, and that lawyer will have to have clarified for him or her what needs to be in those documents, okay?
Okay.
It may also help if that attorney assists in the hardship argument, focusing on your particular hardship in this.
Yeah. Well, before we go to that subject, I know what you mean, but I just want to finish up with that, these issues. So, okay, so what I'm thinking is you need to have the lawyer on at a meeting or a phone call or something where you're discussing with DOB what they require, because it seems that you don't understand what it is that DOB wants. And the lawyer can't draft a document unless they understand what's necessary, okay? So they have to be present somehow in that conversation. Okay.
Okay.
That might be a conversation that they have with DOB counsel's office. That might clarify things.
I think if you look, Sandy, at the page 3, is it 2 of 5 from Ira's Borough Commissioner Gluckman's? I think you wrote this, but it says the frontage space includes access to certain lots, shall be permanently structured, therefore building frontages require open space easement will be filed with the necessary city agencies that DOF as part of several individual legal documents like HOA, zoning lot declarations, right-of-way access easement between tax lots 24 and 25, and a parking easement for tax lots 21 with tax lot 20. Those are some of those documents.
Yeah, okay, so you have right-of-way, you have parking, you have several easements, so again, please involve the lawyer in this. Okay, then, I'm sorry, Commissioner Chabet.
No, I just think that it'd be helpful if that attorney assists your submission with regard to hardship, and really focuses on your particular case and how you do cite Browse. I think a more thorough review of that case might be helpful in your submission.
Okay.
Thank you.
We cite other cases as well where the board...
You do. I think that when
Yes.
focusing in on what we're asking for, which is your hardship, making it akin to what the court finds in Browse as a hardship would be helpful.
So instead of citing to cases where the board granted, you're answering the specific question that's in the statute. Why is this situation hardship? okay? As opposed to saying, you should give it to us because you gave it to those other guys, right? Which is essentially what the argument is in your material.
And some of those are split votes, and just something you should consider.
Okay.
All right, so I'm thinking we need some time to produce those documents and turn around from their council to our council.
Do you want to do late April?
Yeah, that's probably.
So that'd be a submission in 6 weeks, April 10th submission or an April 30th hearing.
But when we say those submissions, the lawyers have to start communicating immediately, okay? So the attorney for your client has to complete these, as soon as the document is in a draft that's considered complete, to send it directly to our counsel's office so that the review can start. Part of the problem is you submitted those documents in October, but you didn't tell anybody you were submitting them, and so the counsel's office didn't know to review them.
Actually, Madam Chair, the council was copied on that submission.
Okay, so follow up with a phone call, because
Okay.
as you might imagine, they get thousands of emails.
I understand,
Okay, so follow up, because what you're trying to do is encourage a turnaround,
Okay.
okay? Okay, so we already said, thanks. Did I ask about speakers? Are there any speakers on this? Okay.
Did you email me?
April 30th, April 10th.
Thank you.
Thank you.
L'Oreal, did you receive on Barclay Street, 27
Oh,
Barclay?
sorry. Are we done with this calendar? Yes, I did.
Okay, do you want to second call it or keep going on the As?
Keep going with the A's. I'll look at it. Yeah, I'll look at it while you do the next day.
Okay. New cases, item number 17, 2018-147A, 3805 Beach 38th Street, Brooklyn. This application's been withdrawn. Request for withdrawal, sorry.
So confused. Okay, yeah. So a motion to withdraw then?
Chair Promoter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown?
Aye.
Commissioner Sheta?
Aye.
Commissioner Shabeta?
Aye.
Okay, you can second call it.
Okay. So second call item is, sorry, 2016-4141BZ, 27 Barclay Street, Manhattan. We have all the information?
Sorry, yeah, go ahead.
Please be reminded, you're still under oath. Please state your name for the record.
Eric Daniel.
I just wanted to confirm that we got submitted, how many pages?
The DUI?
Various
Massage license.
massage therapy licenses,
14.
none of, all of which are current. The earliest one expires in June of this year, June 2019. Many of them expire in 2020, 2021.
Good. Okay, all right, so I'd like to make a motion to close.
Chair Promoter?
Aye.
Vice Chair Chanda? Aye. Commissioner Otley Brown?
Aye.
Commissioner Sheta?
Aye.
Commissioner Shabeta?
Aye.
And a motion to grant.
Chair Promoter?
Aye.
Vice Chair Chanda?
Aye.
Excuse me. Commissioner Otley Brown?
Aye.
Commissioner Sheta?
Aye.
Commissioner Shabeta?
Aye.
This application is granted.
Thank you.
Thank you. It's a quarter. We have 15 minutes unless you, yes, or yes.
Okay. Item number 8, continued hearing items on the zoning calendar. Item number 18, 2016-4153BZ, 4701 19th Avenue, Brooklyn. Please raise your right hand, gentlemen. Sir? Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board and to respond honestly to board member questions?
I do.
Sign your name and proceed.
Hello, good morning, Madam Chair and members of the board, Eric Blatnick. We attended your review session yesterday, and we heard your comments, so I don't know if you'd like for me to give you some information. I think that might soothe some of the comments, although I can understand how you were missing some of the information and how you might have come to the conclusions you came to. or if you'd like to list off your comments, whatever you'd like to do.
Well, there's one pretty significant comment, so maybe
Yes,
you want to discuss the one that's the most significant? So we can-
Yes. So we submitted to you this letter, which I think caused a lot of confusion. And we've been trying to do everything you've been asking us to do the whole way through. We've shown our good faith, I think. We've given every report, every response. And it was a letter that reads that the Board of Trustees of Project Witness and Congregation Zikron Yehuda and Chana, each New York Religious Corporation, have reached an agreement in principle. Nobody's done anything, just reached an agreement in principle to merge the corporations with Project Witness as the surviving corporation. We understand that we have to go to New York State Supreme Court pursuant to Section 2A of the Religious Corporations Law. So we gave you that. What we didn't do is tell you why we gave you that. And that's very specific to the conversation. We weren't trying to take away from the tone of the application, from the philosophy of the way that things were being presented to you at all, or conflict with anything we gave you before. We had a very practical problem after we came out of your last hearing, and that's why Samuel Krieger is here. He's a specialist in religious corporations law and transfer of religious properties, and I went back after the hearing, as you said, sort of we all said off the cuff at the last hearing, let's make a lease, you should make a lease, some acknowledgement that Project Witness actually is using this building, it's going to be Project Witness in there. You said it can condition it on it, but really it would be best if we have a lease, and I know from past practice with your board, it's best if we have something tying it in. So I went back to Samuel and I said, hey, Samuel, we need a lease. Samuel said, I can't give you a lease. I said, why can't you give me a lease? He said, I can't give you a lease because Ruth Lichtenstein, who's the CEO of Project Witness and is the whole thing, she does fundraising, and she can't do her fundraising and get her grants with it as a lease. She would have to be the owner of it. So I said, okay, so do an ownership. Can we transfer ownership?
Hold on.
Yes.
So what you're saying is that she would be unable to get a grant if she is
A grant from funding agencies.
a grant from
Yeah.
funding agencies if she's a tenant of.
Not just that, and also from benefactors, from donors. From her experience, she's very well versed in fundraising. She's a very prominent person in this community. And the donors, to get the real big donors, and what she needs to do in her plan to create this entity, she knows an ownership has to really be in
Okay,
place.
so it's not legally speaking, it's her practice.
It's her practice. Legally, he could do a lease.
Right, of
He said
course.
practically speaking, it
She's found
gumps
some
her up.
difficulty in her experience that she finds it it's much easier for her as an owner. But
raise
this
funding.
just came up now?
Yes, because like we were all talking in the hallway, nobody ever thought that it was going to get to this point in front of the board. We didn't think it was going to get here. She
No,
had
I'm
every
sure,
intention
but-
of doing it at some point and of transferring the ownership, but you pushed us to the point, so it came to a flash earlier than
So
we would have.
They always had intention of transferring the ownership.
Yes, and everybody that's involved, by the way, it's friendly organizations.
I
You have
get it.
two friendly religious
Counsel,
people.
I understand, it's just that earlier submissions, that wasn't what, it was never going to be.
You pushed it to the point that it came to the flash point where she actually had to think about it and figure it out. And when it came to that flash point of the lease discussion, that was when she sent it around to Samuel, and she said, I practically speaking, I can't do a lease.
It'd be
difficult because to get money. So then we said, okay, so then transfer the property. That's the second best I know the board would be happy with. Put as an ownership, so Project Witness owns it, and the congregation keeps their piece. And Samuel turned around to me, and I'll let him speak in a second, and Samuel turns around and goes, that'll not just require what's called Supreme Court approval, which is all the merger requires, that requires another step. If you either do a lease or you transfer it, now you got to go to the Attorney General, to Tish James, and Tish James and the Attorney General, they're a little backed up in this division, and that turns into a whole mishigash. He's got to go get an appraisal done. So he said, the easiest thing for me to do is to merge the corporations. I merged the corporations. He said, I could do that just with state Supreme Court approval. He goes, that takes relatively quickly. That'll give the BSA the acknowledgement that Project Witness is a legitimate corporation and has skin in the game and ties Project Witness into the property. And it satisfies Ruth by her having Project Witness having ownership, which satisfies the fundraising paradigm, and it's speed because it doesn't require state attorney general approval. So that's, I'll let you come up because I think I've introduced it, but Samuel is the genius.
I'm far from a genius, but...
State your name for the record.
My name for the record is Samuel Krieger, Krieger and Prager. Section 12 of the Religious Corporation Law and Sections 510 and 511A of the Not-for-Profit Corporation Law basically require that a religious corporation, not basically, they require that a religious corporation that sells, exchanges, mortgages, or leases as the lessor any of its property for a term in excess of 5 years requires Attorney General approval. It's become since the law was changed, it's become much more of an arduous process and a long process. So when they came to me and they said, what's the most efficient way to doing this, I pointed out to them that they can do the merger. Merger does not require Attorney General approval. It does require court approval, and it's a petition. We've done it a number of times, and then we would merge the two entities with Project Witness being the surviving entity. The initial suggestion of a ground lease was something that would require, as I said, a lease in excess of 5 years. If there was a lease between Project Witness and the congregation was the lessor, it would require Attorney General approval on the ground lease. And as Mr. Palatnik has pointed out, there were practical difficulties vis-à-vis Project Witness. So the favored possibility, obviously, is the merger. The second favored possibility, better than the ground lease, I see, would be a sale, transfer, donation by the congregation to Project Witness of the subject property, again, which will require Attorney General approval and the backlog and the application and the timing on that. And the third one, actually, and probably the most disfavored for many reasons, would be the ground lease. I think that's my presentation.
Can you state the sections you cited again?
Section 12 of the Religious Corporations Law, sections 510 and 511, and 511A of the Not-for-Profit Corporation Law.
Thank you.
Any other questions?
Not so far. Thank you.
You know, and our submission certainly could have been a lot clearer in giving you the rationale as to why we came to this conclusion and how we got there. So I think that might have given you more of an understanding of what we were doing when we made the submission. And I apologize for that.
Okay.
The other thing I wanted to mention on another note, if I could switch to another topic, you were right. I hope that makes you feel better in the sense that what's the enlargement issue that you raised with the building? We went back to Mr. Garfinkel last evening.
No, let's not go
Okay.
there yet.
All
We're
right.
very far away from talking about the building.
Okay.
So, admitting that my knowledge of corporation law is limited. Now, all of the assets of the corporation, if this merger were to proceed, the corporate merger were to proceed, all of the assets of the corporation now sit in Project Witnesses.
Of both corporations would sit in the name of Project Witness.
Correct.
It's as if General Motors had merged with Ford, all of the assets, and subject to the liabilities, right?
Right, and General Motors being the surviving corporation, just for argument's sake, that's the end of that. General Motors owns everything, right?
General Motors, and a building that where title right now is in Ford Motor Company, you go to the title company, you show them that here's the merger papers from the state of Michigan or the state of Delaware, more likely the state of Delaware, and, they'll issue the title policy. General Motors is successor by merger to Ford Motor Company.
There you go, okay.
But that hasn't happened just yet.
Hasn't happened. This was
Okay. This is the
the
18th.
boards,
Theory.
Decision.
The boards of the two congregations have agreed, if required, that they will enter into the merger.
So-
But under, again, the sections that I cited to you, the boards... No, the boards can withdraw that, can terminate that merger at any point in time prior to the filing with the Secretary of State.
Right.
Okay, thank you. Okay, so coming back to you, Mr. Palatnik. So, under the current proposal, and I don't know how we do this otherwise, because the Project Witness let's just pretend that this went through, because otherwise, how do we think about this, right?
Or we could do a sale, which separates them entirely,
The
which
bigger
we're willing
point-
to do.
Yeah, I think you're missing what
Yeah, you're
Jeff's
missing the
problem
point.
is.
Go.
So here's the thing. I actually read a quotation from the last hearing where you actually said they're separate entities, they don't have anything to do with each other, they run separately, we'll give you some kind of restrictive declaration that indicates
Right.
how separate they are, et cetera, et cetera.
Right.
And then the next day, kind of theoretically, the next day, we find out they're not separate anything, they are one and the same.
No.
And now,
Wait, just-
they are with your proposal and with all of the different options that are being offered, we're learning that the congregation in its merger dissolves. That's what happens. We just had that explained. No, the religious institution dissolves because it gets taken over by Project Witness, right? So it's, wait, didn't you just say Ford and General Motors, Ford
Yeah, but
goes
that doesn't
away?
mean, that Ford is going to stop producing cars, and it doesn't mean, it hasn't happened yet, and it doesn't mean that the congregation is not going to
But it
continue
does
running a
mean-
congregation.
It does mean it's absorbed by a parent, but now another company.
Nothing is happening.
I understand. We're trying to, I think that, at least I can speak for myself, I think Project Witness is a great program. But we're trying to work out how this is going to work if one company owns all of this. And if that's the case, it's really hard to make an argument for a variance.
Eric Blatnick, I understand that.
It's hard to make the argument that they're separate for land use purposes.
Yes. We don't have to.
Because unfortunately, your ramifications
I understand.
Don't interrupt
We're
her,
with
please
you.
let her finish her
Yeah, yeah.
sentence.
have land use ramifications, which is now you are interrelated. And because you are interrelated, it begs the question, why can't we talk about developing the entire property that now Project Witness owns?
That Project Witness would own if they
Would
actually-
own.
I'm with you, which is why this was just an idea.
Now,
This was, legally and perceptually, we were trying to find a way to address the practical concerns and the board's concerns. We came up with an idea. My mistake in my submission was I didn't write after I submitted that document, this is an idea. It says right on it that they've reached an agreement in principle. So for the record, so we're crystal clear, nothing has happened. I understand the trap that I've set for myself now by submitting this, and that as a result, if we went this route, it would merge the two and you can't be separated. What I'm suggesting, and we just finished the thought, is we can separate the two and do a transfer of sale.
It can't just be theoretical.
No, we can actually do a transfer.
Right, but can I just say that you entertaining this idea has proven to us how interrelated both organizations
They are. No, that's not, if I can. They are the same people that started the synagogue. Then in the same room, one day at a later point in time, said, hey, Ruth, who's a part of our crew here, has this great idea. Let's start up a second organization. They are the same people, 100%. At the last here, we never are saying they're not. The same people are involved. Same exact people. Different organizations. One is a prayer-based religious shul congregation. The other is religious-based that does educational programming. Two totally different things. The original organization, the prayer-based one, said, let's create this second entity. Now, at the hearing, the board said, there's nothing to tie you to this variance from this entity, Project Witness. I came up with this crummy idea. He came up with this crummy idea. It sucks. It's a horrible idea. Now we're saying to you, that idea is horrible. We're happy to transfer the two. All the same people are involved. They'll agree to anything that you need to give you the confidence that Project Witness is developing this portion of land.
If I may, just offer
Yeah.
a suggestion, in that you've already established in the record, it's kind of very clear to the commissioners that you said they're the same people. What if you amended the application to include both sites and developed the two buildings?
They're
in larger
the same
communities?
people. It's not the same program. Just because a religious
Right,
organization.
I'm asking a question.
Let me
Is it possible
maybe
to
explain
enlarge?
it more clearly.
But Mr.
My-
Platnick, just the comments being that this seems like you're doing a lot on this site, you have a lot of circulation on the site that's now currently before the board. Maybe if you enlarge the site, you could accommodate both programs in the same building, and it'd be a more palatable application for the board members.
Ms. Monroe, I respect what you're saying. We went through 5 or 6 hearings on this. We've vetted everything. We've hired a traffic consultant who's done it for $30,000, who's done a report. Everybody was satisfied at the last hearing. We finished the last hearing. The only remaining issues, we talked about character, we talked about transportation, we talked about everything. The only remaining issues were the noise and the environmental issue, the egress issue, and the request for a lease. Our submission of this last document that we're talking about right now, this document with an intent to merge, was done to try to satisfy the board.
I understand, but you also understand it's within the box.
It was not done to blur any lines. There are two separate organizations that we're presenting. They are two entirely separate
I don't think the
organizations.
concern was that we're blurring lines. I think the concern is that it makes it appear as if they're Can you tell me what the exception to Ms. Monroe's suggestion is?
The exception to...
Your exception to Ms. Monroe's idea?
The suggestion that you look at both buildings and enlarge them.
The plan by the religious organizations, which there are right now 2 religious corporations
Right.
sponsored, am I correct with that? That right now there are 2 distinct religious corporations?
Understood, yes.
Their desire is to have 2 distinct buildings. They've done no actions, we've been through this, the papers are filled with it, that there have been no filings and nothing creating one zoning lot on the property, and we
Right.
established that at earlier hearings.
Right.
There's been no commonality in any filings at the New York City Department of Buildings. The only commonality is that the very same people, and this is common for, I'm going to an event tonight for Metropolitan Council on Jewish Poverty with people that are on boards of directors. I saw actually a former commissioner was just appointed.
If we
to
could just keep it to the
I am, because
application.
it's just, I'm trying to keep, many people sit on the boards of multiple organizations.
I
Just
understand.
because they do, we're not trying to blur the two.
Yeah,
But
you
you
have.
actually are.
You kind of
Yeah,
are,
you
and to
have.
me, your better bet is to go the way of council
you've
in
just-
at
I've
least
suggested it.
merging it and then addressing why programmatically it does not work that you develop them as one building.
If that would satisfy the board as a path to an achievable,
because at
I don't
least-
see why it makes a difference, though. I don't understand why if
Because
you
at least
transfer the
you're
property.
addressing it for the record. Because remember, your case is a case that others could look on to build their own case. So I think you have to air this out, this issue.
And I'd like to suggest something to pick up on both of these, right? We've been talking about since the beginning that the 2 sites are too small by themselves. I've said many times about this fiction of a enlargement of an existing little wood frame house to turn it into a public building where this is a total demolition. I hope that the property owner understands that this is not an enlargement of an existing
that.
house. Right, well, that's not what the drawings show.
I said a moment ago, we agreed, I said you were right, and we agreed it's a new building.
No, so it's a
few minutes
brand-new
ago.
building. So understanding that it's a brand-new building, which is an expensive operation, new foundations, new everything, very expensive. Understanding that for a new building, to have so many staircases and an elevator to create hardly any usable floor area is frankly a waste of money. And because these 2 entities, which we are learning are really one entity, in fact, willingly made into one entity.
They have not been,
Stop interrupting. They're going to be made into one entity. That was the proposal. That reveals to us that they're one entity. And the site adjacent is also a tiny little site with a little wood frame house on it that also is not suitable to be made into a synagogue. That's a public building for many hundreds of people that will also require demolition. However, if those two structures were combined into one structure, you'd have the same number of staircases, the same number of elevators to create space that's really usable, and you could have a synagogue in that space. And I'd like for the owner to hear this. We heard programmatic requirements that are not being fulfilled in this tiny little building. We heard that you need an archive. There is no room for an archive in this building. There is no room for archivists to work in this building. There's no room for a museum in this building. But there would be room if the 2 uses combined onto one combined lot, and then you'd have a floor plate that's adequate. And by the way, you wouldn't probably need as many waivers. It would be a much more economical building to build. You'd satisfy the needs of both the congregation. You could have separate entrances for the synagogue and for Project Witness. It'd be a better project, and the intentional kind of ignorance of the reality of this, I find very distressing, because I'm really sympathetic personally to the cause that's being pursued here, but I'm not sympathetic to the idea of throwing money out to build a building that on the moment of its completion will be obsolete. And I think that's irresponsible frankly, on the part of the board who is developing this. So I think now that, and this all came up because we received a piece of paper. You're right. Up until this point, we were kind of like, what are we going to do? But then we receive a piece of paper that admits
It was an idea.
I don't understand.
And it's the same people. Am I able to respond? Can I?
You can
please
respond, but.
Can I please respond?
But I really want there to be a
Everything that you
response.
there is a response, and please, if I could just be given the time to speak, okay? Everything that you, Madam Chair, just said about, let's just talk about the fact we left last hearing. The only thing that's changed since then is that we gave you an idea of ownership. So all these issues of the character of the neighborhood, the size, the program, were all very vetted, and you just said you were pretty much okay with it until this came in. So let's go back to this, okay? You're giving us an idea to save money. It doesn't fit in, and whether or not, if I could just finish, please, Ms. Monroe.
Yeah, sure.
Whether or not it will save money or not is not what's relevant to our proposal. Nothing that we've made our argument on is based upon any economic efficiencies. We are allowed to build this, if we desire, out of solid gold, if we desire. And if I just finish, please, let me just finish 1 second so we get and I don't know the path, I don't know how if you're trying to help us, or I can't figure out standing here if we're trying to be helped or not. We were asked to show a path by which Project Witness could actually physically have skin in the game. If it goes back to the fact that from everything you're telling me, it should be the lease, which is the way we finished it up last time, then Ruth will sacrifice her fundraising experts, her fundraising needs, and we will do the lease the way we left it at the last hearing. And we will, rather than sacrifice the approval, because the only thing that has changed since the last hearing, where we finished it up at the last minute, the last words out of everybody's mouth was, "We're okay with everything." The only thing that's changed is we came up with an idea to practically solve a problem. If that's rubbing you wrong, yes, it's all the same people. They sit on the boards, and some of them probably sit on even more boards that might not be next to each other. But that's not what we are making the basis of this. So if you say to me, Mr. Palatnik, this is Meshuggah the way you're doing it right now, and this idea of doing this merger is nonsense, then we will enter into the lease, and we haven't done anything yet.
No, so what you're asking us is to unhear what we've heard, what's in the record. It's in the record. You submitted it into the record, and the conversation from the very beginning was that this cannot be the same entity because you cannot arbitrarily select which part of the zoning lot or the property you're going to build the building and leave the other part and essentially create your own hardship. So that's the part that comes in now, right? So what we, I think, are all seeing is, having admitted that you share ownership with the two sites, you are now self-creating hardship. The hardship complained of, you're interrupting me.
1 second.
The hardship complained of is that the site is too narrow.
Is it possible that this project would be better if you're joined by latitude instead of longitude?
No, it's not better. They have their personal desires to have a separate facility, which is the way that we discussed
And we're going to
it.
need that in a programmatic needs. We're going to need, as commission.
We gave you a
Commissioner,
programmatic.
So if I could just wrap
Go
up
on,
this
yeah.
conversation, because I feel like we're going in circles. So you've heard what the comment is. Because of what you provided in the record, the board is now thinking that an enlargement of the two buildings in tandem could, in fact, reduce the waivers and accommodate both of your programs. So I would suggest that your next submission be something that either shows that that's not possible.
It's not, I'm not going to submit that, because it's not the desire of the two religious corporations that are standing in front of you right now to merge their properties and sacrifice their congregational shul for Project Witness. It is their desire to create two buildings, exactly as is proposed to you, and to provide any form of ownership that the BSA would require
So put
to
it in a
document that.
programmatic needs statement and address it in your statement of facts and findings, because what you did.
We can do that.
That's what we're
Right,
saying.
that's what we're telling you, that's your way out. Either you're going to develop the building in tandem with the building next door, because you really are a related entity as much as you're sitting here and arguing that you're not, or you're going to show us in a programmatic needs statement and your statement of facts and findings that those programs must remain discrete, separate programs.
And you're going to have to.
And this is why.
And I would have to say that because I'm a visual thinker, writing it up in a statement of facts is not going to be enough for me. I need drawings.
But what are
I
the
need to
drawings
understand. The drawings are showing why in the world, and by the way, don't forget how many different
don't
kinds of...
want to.
Would you stop interrupting me?
But also, if we
Don't
just
mean to.
clarify, variances aren't to facilitate what an applicant or a property owner wants to do.
No.
Is that fair to say? Would you agree with
It's, you
that?
can't force two separate, you
I
can't
think the
force a
same
zoning
thing.
lot to be merged where the owner doesn't want to merge the zoning lot.
I think that's what the argument is that they're returning back to these independent lots, and since the corporations are individuals, these are two separate corporations as of today. And I think that's the argument that's being
That's what we're
presented.
presenting. We can merge them. Physically, you can merge them. We don't want to.
Counsel, I don't think, I think you asked a question earlier and you stated, I don't know if you're trying to aid or we are. Everyone here is trying to work this out. They gave you, repeatedly, they gave you your way out. You're gonna have to show how your programmatic needs require it to be this way and not
The other way.
the other, not being joined on one floor under the
The
other.
congregation wants its own building, and Project Witness wants its own building. Yes, we could merge them if physically. You could definitely knock it down, you can merge the two and build one. I understand what you're saying. They don't want to.
And
they don't have any desire to. They want to
Why?
put
It's
it
more
fully
than that.
separate. Why? Because one is a congregation and one is Project Witness. And the congregation hopes to grow over time and wants to use its space for those reasons. Is that the direction you'd like me to bring it into?
Well, you could help us walk us through the arguments that the programs that they run and the hours of operations that they run. Would it conflict with what Project Witness hours of operations are, and the flow of the traffic of the shul and the flow of the traffic going to the Project Witness will result in, I don't know, separate sets of
I'm glad
access points?
I'm glad to cooperate.
I'm just thinking
And I
these
appreciate
things
it.
out. These are the questions I would want to be answered. It's like, are there reasons programmatically, operationally, that even if you had this big site, you would need same amount of circulation space, you will not be able to consolidate.
No,
the
that's not,
circulation
but that's, I
space.
can't take you there in that
It's about
discussion.
not joining, it's about not joining the parties because they're such separate entities.
Because they're different entities, they're different, listen.
And they have
this is-
different functions, and so, but you need to address it in your...
We'll address, we will provide, I appreciate all of the thoughts,
Right,
and
and
we
then
will.
I
And Madam Chair, I'd like to get you more comfortable if I
Yeah,
can.
so like I said, I'm a visual thinker, right? Talking me through this isn't going to get me through this, right? I would need to understand, so we have seen, as you know, many, many synagogues that have other functions in them. They have mikvahs in them, they have school programs in them, they have catering facilities in them, they have all kinds of things in them, and somehow or other, those supposed, apparently disparate uses work together in a common building. We even have one that's in hearing now that's on the lower floors of an apartment building. So I ask again.
Because, if I can just, maybe this
No,
was lost.
I'm trying to finish my sentence, right? And so I ask again that the drawings show why you can't have a synagogue in part of the building and the Project Witness uses in another part of the building with separate entrances, like we see in so many synagogue applications, where a synagogue and another use is combined in the same building. And it doesn't mean that you wouldn't be entitled to a variance, because we're still talking about religious deference, we're talking about educational deference, but we are talking about the fact that now we can't unlearn what we've learned. And this issue of self-created hardship, which is going to come up in another hearing shortly, 2 more hearings, today, which you should stay for, right? Is something that I cannot overlook. I cannot unlearn that this is effectively a combined ownership, which a document reveals to us. All right?
Can you correct that?
No, we don't need to hear this again. I've already heard it.
You can't prove your case here right now. You just
I-
can't. This has to be done in writing.
I think there's one other point that I'd like to make, and that's one of the reasons to keep them separate is because of the fundraising situation. There's I do not believe, and based on the information we've been given, that they're going to be able to, they have 2 separate funding sources, 2 separate fundraising sources. The congregation doesn't have Project Witness doesn't have the ability to raise funds to redo 2 buildings, and the congregation doesn't have funding, it has funding to maintain the building it has currently. And that's one of the reasons, that's a very practical reason why the two buildings have to be kept separate.
I also have to just remind you that I know that in 2014, plans were filed at the Department of Buildings to convert the synagogue into a residential building. So it's clear that there isn't really any immediate use plan for the synagogue to be a synagogue. Otherwise, why file
If I could
plans?
address this
Right.
for the record, because that's not, the comments that are being made are not really being entirely accurate, okay?
There
It was
were
a
plans.
2014, first of all, was 5 years ago, okay? At that time, somebody made a filing at the Department of Buildings to build
The same
to
architect
enlarge
who
a
made the
house.
filing
Right,
was-
okay? It wasn't followed through on. It doesn't mean that that's, I don't understand where all the negative intent is on them. They were coming up with some idea, they were coming up with an idea at the time of what to do with the property. Somebody made a filing, they didn't go through with it. It was just vetted in our statement at page 23, I think, with the Acris filings. A couple of hearings ago, there were 2 Acris filings, and then the assertion then was that we created one zoning lot. We had to prove to you that the Acris filings were just the property descriptions, and then we wrote it up in our statement. The exact, I think it was at page 23 of our Statement of Facts and Findings, speaks to the fact that at the November 13th, 2017 executive session and at the November 14th, 2017 hearing, the board referenced documents ID number and Acris, and then we wrote, however, these documents are separate zoning lot descriptions, not mergers, for 165 and 166, and they were filed because the principal of Mossad Haram Levitt considered expanding the building. We told you all that. We went through it. So now, of course, you're right to say that we made the filing, somebody made the filing in 2014, but I sense that you're feeling like it evidences their intent to not exist as a congregation on the property right now, and they are existing on the congregation, as a congregation on the property right now.
So what this was all about is because we found that the ownership of the 2 sites are the same, the question was, how can the board be looking at, when we do this on every single application where someone comes to us and says, I have a 25 by 100 lot, it's too narrow, I need waivers, it's, unique and narrow and so on, and we say, who owns the lot next door? And the answer is, someone completely unrelated owns the lot next door, so therefore I'm stuck with this 25 by 100. But sometimes the answer is, I own the lot next door, but I never merged it as a common zoning lot. And we say, sorry, that is not a hardship condition because you could use the adjacent property. In the case of religious institutions, we don't look normally at or we do also, but at the unique physical condition, right? But we do look at self-created hardship. So what we looked at from the very beginning and why checking into the history of the lot was essential was, are you creating the hardship complained of by only building on the 25-foot lot? And it appears, while we were willing to accept the premise that was presented to us that the 2 institutions were independent before, now with this document, most of us, I'd say, are no longer willing to accept that premise. So you need to now make an argument that persuades me, anyway, that you, and others, obviously, that you're not self-creating the hardship, because now that's a finding I wasn't pursuing very much before, and now I'm finding there's a self-created hardship.
And before you win, though, Counsel, it might be a good idea to have an open mind of using the both lots. And why I say it is, I'm just asking your client to explore it. I think you'll get a lot more use out of this one on being latitudes and longitudes.
We appreciate the board's comments. Nobody's trying to sound disrespectful. I understand what you're saying. Hey, merge them, you'll get out of here easier, it'll be quicker, it'll be faster. That's not the intention of the organization.
You have more room.
Let me give you a good practical reason why. This organization is created, obviously, to stop the proliferation of hatred that we all see going on all over the place, right? So people from all faiths and religions are walking into this building. All faiths and religions. You have people of every single nationality. They don't want to walk into a shul or anything that's represented as a shul. They want to go into a neutral place. We spent this whole hearing process talking about the papers are replete with education. We're basing the whole application on being educational. And the reason is it is educational. It's meant for every single denomination to walk in there. I put a Star of David over this building. I change
But
it.
that's not what.
But that's, by merging the two, by putting them, we've just spoken for an hour about merging the two. By merging the two, there's an ark in the building, there's a Torah, there's a bima, there's a rabbi potentially residing in the property, there's prayer going on in the building. These are the conflicting
I think
things.
those are your arguments for your programmatic
Yeah, I don't
meetings.
see what the
think
problem
that's-
is.
Oh, they're good. Okay, I'm good. All right.
And be fruitful.
That's-
Go do it.
That's,
Make those arguments.
we'll set
And-
forth
and
with that.
I had a question. I mean, is the synagogue not there not as far along in their plans to develop as compared to the
Correct,
project?
that is correct.
Add that in and as to identify like how.
funding sources.
And I think the argument
I
that you don't
think
want projects.
those are, I mean, that would be difficult for you to put together a program for a synagogue if you don't know, if you don't have the funding and you don't know what the future is.
That's what we're trying to communicate.
So-
That's what we're trying to say.
But I
That's
do
what
want to
we're trying
say,
tell you.
because, you know, playing devil's advocate, because I'm just so astonished by reading this document that you know, beside myself. I want to say that when you say that you don't want people to be walking into a shul, people don't walk into a shul when they go into an apartment building that's built upstairs. They're not aware, actually, that they're in a building that is part of shul. They're not. They're not walking under a Star of David to walk into their apartment building. Nor are they when there's a banquet facility in the same place. They're walking into the banquet hall. So when you make these arguments, don't be one-sided about your argument. If you're saying we're different, distinguish yourself from all of the other ones where we have combined uses in the
I
same
will,
building.
but
We have
again,
a lot of
the-
synagogues
the-
in apartment
listen, what's good for the goose isn't always good for the gander, and I don't think that this is a subject that's so broadly spoken. It's obviously a very emotional subject when people come to the subject matter and learn about it and everything. This is much different than a shul, than somebody coming into a shul in an apartment building. You're bringing people in to sensitize them to diversity. We're not trying to create an
So
establishment.
make this
that
argument
has
in
it.
writing,
We'll be
so
happy
we
to.
don't do it here and on the fly like this, okay?
We'd be happy to give you more information.
So I don't want to go through I think this is a threshold question, and I don't want to go through anything else on this. I don't think it's necessary. Did you want to say something?
Because there was a lot of discussion. I think there was a discussion also as to the funding, the fundraising requirements of both entities. No, I'm sorry. They started a discussion as to the different funding, the fundraising requirements for both, and why there would be conflict. I don't know if that
I
was
don't know if
something.
there would be conflict. If there would be conflict, they have to be very detailed about it. It's not just suppositions, right? Because again, apartment buildings with synagogues in them, apartment buildings with churches in them, schools with synagogues. We have all kinds of combinations with synagogues. And so, yeah, or not with other religious buildings. We don't just need to use synagogues. Okay, so it's just a direction that if
We
you're going
appreciate
to
the
do
direction.
this, don't just tell one side of the story, distinguish the other similar sides of the story. Otherwise, you won't have completed your argument. Be scholarly about this, both sides of the argument, okay? All right. And you heard I don't know if there were even other comments. Everyone was in such a state yesterday.
Speakers?
Are there any speakers on this? Okay.
Can we speak?
Okay. Schedule. So you're going to need some real time to put this together, a really coherent, and I expect plans to support your argument.
If I could just ask for some specific, how can we give you plans to show you that we don't want to meld?
You're making plans to show that the combined use, you're making plans to show the combined use.
But we don't want to merge.
I know you don't want to, but
the
if you...
buildings.
But But if it shows that the.
We have no desire to,
that the
we have no
merger-
desire to merge the buildings. We have none.
So I'm not going to actually tell you how to do it. I'm going to say, you have an architect, and the architect knows how to put together a set of plans, and that's what you need to do, and I'm not going to tell you how to do it because it seems kind of
For instance, the
unnecessary.
plans can tell the visual story of your written submission, why it is that there are conflicts, maybe physical conflicts in having both these uses in the same building. That's a suggestion.
Okay, because earlier we started on the plan discussion, Madam Chair, you pointed out that there would be commonality of items within the building, that we could save all kinds of money. We could have one elevator, we could have just one staircase. So I guess we could show you a plan that shows you how that idea really doesn't work, to meld everything together like that, to save all that money, the stairways and the circulation, and all that really does is bring everybody together in a common place, maybe. Maybe we could.
Again, I'm
show
not
you
going to
that.
tell you physically how to do drawings. It's for the architect to do. You've heard what the problems are, and my issues, in particular with the application, because, so for example, one of the concerns is that the waivers are great, and the building is tall. So, right, that was one of the concerns expressed at the
We
very
left the
beginning.
last hearing, none of that was an
one of the
issue
con-
anymore.
Because those are
It was
the,
resolved.
you're requesting a lot of
The
waivers.
board was comfortable with the last hearing.
Just listen to what I'm saying. You're requesting a lot of waivers. Let's see what a building that combines those two uses does. And then, for the person who does the programmatic needs analysis, she's not here today, I don't think. She could talk about the programmatic needs of both institutions and how that works or doesn't work.
Okay.
And, please understand that though we're sympathetic to this application, it's a really great program, we didn't create that piece of paper that just got handed to us, and we can't ignore it, we can't unlearn it. We have to respond to it, and it
Paper was just
opened
an
up-
idea.
It opened
Yeah.
up another finding that was not under consideration for a while.
I'd just like to clarify again that the law specifically provides that the boards of directors can determine not to proceed with the merger at any time until the merger is
No, I
final.
understand, we're just concerned about precedent.
Well, more than that.
Well,
Concerned about what just
I'm
happened.
concerned about precedent, I agree too.
We're concerned about a statement made
Right.
to the board with a document that reveals a different
No, it-
reality. Okay, so I think we're done.
So how much time would you need to prepare?
If we could submit in May.
Okay. May 1st would put you on May 21st, or
If we're later than that, please.
May 15th would put you on June 4th.
That's great.
Okay, so May 15th submission for June 4th hearing.
Thank you.
Thank you.
Thank you. So we're
I
going
think
to
we need
take
a
a break, 30 minutes.
30 minutes?
Well, 10 minutes, it's 12:30. Do you want to take lunch?
Let's take a 10 minutes.
10
and see
minutes
what
is
we can
okay?
do.
All right, 10 minutes. Gee,
Back on the record at 12:40.
Hard workers.
yeah, I guess so. It just happens to be lunchtime in like the normal world.
Gloria, do you want to call the...
What was it? 4339?
Yeah, unfortunately, the previous one.
I just was wanting.
Okay, we're on the record.
Drawings.
Zoning calendar, continued hearings, item number 19, 2016-4274 BZ, 1411 39th Street, Brooklyn. Call them together. Item number 20, 2016-4339 BZ, 5018 14th Avenue, Brooklyn.
Signed the wrong sheet, this one.
It's okay. Son. Okay, everybody raise your right hands. Good. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board and respond honestly to board member questions? Good. Go. Sign in later. Yeah. Oh, my mic.
Good afternoon, Madam Chair, Commissioners. Neil Weisbart on behalf of the applicant. We attended a review session yesterday. I'd just like to hand out some revised plans.
Those are the plans that were just submitted, right?
No, those were two sheets that were just submitted. That's only in regard
To the notes.
to the vapor barrier.
Oh, and the
These plans-
mechanical ventilation.
These plans have been formally filed and take into account the mechanical ventilation. So the first comment from the board was to provide the pedestrian site safety plan as part of the approved set, of the proposed set. And in the set that I just handed out, Plan A2A for the 39th Street building and Plan A2B for the 51st Street building have the pedestrian site safety plan.
Okay.
The second note.
So wait a second, A2A also is going to show the curb cuts removed, right? No.
No, that's on a separate plan. That'll be on the plot plan. So the plot plan for both sets show that curb cuts will be removed and no new curb cuts will be installed. And that's on that, and that's been formally submitted.
That's the A2A. I'm just looking.
No, A2A is the pedestrian site safety plan, which was taken from the EAS. You want it as part of the
Oh, you
proposed
actually
set.
oddly, no, that's A2B. Oh, this is so confusing.
A2A doesn't have any.
Let's go with one site at a time.
Yeah.
Okay, so
Can
for
we make it easier?
39th Street,
Oh, you're on 39th Street. I'm sorry, okay.
4274.
Wait. Hold on a second. Let's all be on 39th Street when we turn pages. Okay, good.
So A2A for 39th Street is the pedestrian site safety plan from the EAS, signed and sealed by the architect and made part of the proposed set of plans.
And it shows the bollards now.
Yes.
Right, okay.
And then for the next site, 51st Street site, is A2B.
Okay.
The curb cuts, note stating that no existing curb cuts will be removed and no new curb cuts will be installed, are on the plot plans.
So that's A2 on the 39th Street site. Right?
Yes.
Which says, no new curb cuts will be provided, curb cuts will be removed.
And then there's.
And I believe it's A2, no new curb cuts will be installed.
It says new curb. New curb. New curb cuts, okay. And ditto for A2 on 14th Avenue, 51st Street.
Correct.
Same existing curb cuts to be removed, no new curb cuts. Okay.
On 39th Street, is there only going to be one crossing guard?
For 39th Street, yes, the proposed one crossing guard. There'll be 4 teacher monitor locations, and then the bollards will be installed on both sides of the site.
So the crossing guard is a city supplied person, is that right?
We requested New York City crossing guard.
As opposed to the teacher monitors.
Then the teacher monitors, there's 4 locations where the teachers will be located during arrivals and dismissals, and those are indicated on the plan. There's a legend, it's a small circle.
Small circles, teacher is.
Teacher monitor locations.
Crossing guards, that's not shown.
It says exist, there's
It's
a.
right at the intersection of 39th and 14th Avenue. It says proposed crossing guard during arrival and dismissal.
Oh, I see. Okay, so that person is stands in the middle, so, okay.
And this is the same site safety plan that was reviewed by DOT. There was also a comment about the mechanical ventilation, and the plans have been revised to state that code-compliant mechanical ventilation will be provided in all interior spaces for both buildings.
That's not correct. So an interior space is required by law to be mechanically ventilated no matter what. These are DEP requirements that because the air quality levels are poor, or maybe it's noise related, I'm not sure if it's air or noise. I think it's actually noise. Because of noise levels being high, you need to function, this building needs to function in a closed window condition. Therefore, because the windows cannot be operated.
That's not, maybe
Yeah,
Max
that's what it
Stemper-Young
means.
could speak to this?
That is actually what it means.
Oh, sorry.
State your name for the
Mark
record.
Mariscal. So when I wrote interior, I didn't mean like interior as in windowless. I meant within the building envelope, whether it's next to the exterior wall or in the very middle. So that's what I meant by interior. So everything within the building would be rooftop provided with mechanical ventilation. That's how I was
That's
thinking
what
of
you were thinking
interior.
it meant, but that's
Yeah.
not what it says, obviously. Because interior space in 39th Street would be toilet rooms and
No,
your
but-
receptionist area and so on.
But, no, I guess, I can clarify, but in my mind, interior meant anything
Okay.
within the building
Understood, but
envelope.
so the way the DEP phrases this, they talk about a closed window condition where alternate
Yeah,
mechanical
of course.
means of mechanical ventilation will be
Yes.
provided. That's the language DEP uses, which is quite clear, that the reason that you're having mechanical
No, I
ventilation
understand.
is because the windows are in a closed
Right,
condition.
understood, yeah.
Right, but that's not what it says on your drawing, so that's our problem. So, and that was what was unclear before. That's why we wanted the drawing to be changed to say exactly what DEP says, because it's extremely clear. Now I can't find the note. Site A, sorry. It says words to that effect, sorry. Here we go. Site A, which is 51st Street. A composite window wall noise attenuation of 31 dBA and a facade of 28 dBA, and an alternative means of ventilation are required. So that's the alternative means for the
Right,
because
right,
of the
of course,
closed
the
window
windows would not be
condition.
used for
Yeah.
ventilation at all.
So here's the question, can you call your office and have them make the correct change to the notes and email it back to us?
Sure.
Okay, because that way we could put this
Let's
on.
be clear, so you
Yeah,
want to
let's-
say alternative mechanical ventilation? What's
So where the note is for the DBA, let me see. Okay, so it says, composite window wall noise attenuation of 28 dBA to be provided. That's, I'm looking at A4 on the 39th Street site. I'm just reading any one of these notes, right? So it would be a closed window condition with mechanical ventilation, with an alternative means of ventilation are required.
So closed window condition with alternative means of ventilation required.
The alternative means, I guess, of mechanical ventilation to be clearer.
And this would apply for both the
For
sites.
both, yeah. So, now that I read interior, I can see how you think that but all spaces inside of a building are interior.
Right, well,
So that's kind of
that's
a
what I was
confusing
thinking.
statement. It's like an extra qualification about space inside of a building,
Which is, well, anyways,
right?
I mean,
How do you have it in closed building? Everything's interior.
Right, that's right. You have exterior space and you have interior.
But you would never mechanically ventilate an exterior
No,
space.
no, I mean an
Right.
exterior space, meaning you're standing out on the street.
Yeah, I understand.
Or you're on the roof deck.
Right,
But it's
I
not,
understand what,
walking in the front door, you're in
In
an
the
interior
interior.
space.
right.
So,
Just regarding the closed window condition, Max Semper-Young from VHB wanted to discuss that.
Hi, Max Young from VHB. The EAS that was submitted to the board and reviewed by DEP indicated that the windows were planned to be operable,
Oh,
and DEP had reviewed that and provided their sign-off letter.
that's very confusing. But
So-
then meanwhile, they said it's an alternative means of ventilation are required, so how does that work?
That I'm not so sure about. I'll have to get back to you.
Okay, yeah. So if you want to clarify that, I don't know how to,
I don't know
they're
how
in
we're
conflict with each other.
well, why don't we just revise the note?
Okay, then we will just say closed window condition, and then we won't need to clarify it. So Mark's going to work on that, and I guess we'll have a second call, but if I can just get through the last point on the
Yes.
vapor barrier.
Yeah,
So I spoke to Carlo and Veronica, and there was comments about the vapor barrier, that there was a note to be put on the plans. We have done that, it's been emailed formally to
Yeah.
submit, and you should have a copy of that for
We
both
did.
sites.
well,
One
that's
says,
not on what you got. It's on this one. I see on A2 of the 51st Street building, it says a 6-inch reinforced concrete slab and 1.5 to 3 foot thick wall footings will be installed, which is a little confusing. A Stego wrap 20 millimeter vapor barrier or similar product beneath the building slab, elevator pit, and up the sidewalls of the excavation, as well as the ceiling of all weld seams and penetrations will be installed, which is, I believe, what it said on the.
Yes.
That's verbatim from the note from DEP, I think.
So after this hearing, we're going to print up hard copies and file it with the board. And we could fill out a new certification for that drawing if required.
Okay, so, but if you send to submit, because Mr. Mariscal's going to modify the drawings, right? Just to add that little note. So that note, in addition to this one that we're seeing right now,
Yes.
together on one set, would get sent to submit, and then we could have a second call on it.
Okay.
Because I don't think there were any other issues, right?
We're just, we'll have to actually email a full set because the window conditions on almost all the
Yeah,
plans.
yeah.
Okay.
Correct, okay. All
Okay,
right,
thank you.
that's it, thank you. So second call.
We don't need hard.
No, we don't need the hard copy, I don't know. That
No.
they're,
They'll submit
Yeah.
the hard copies.
right.
We can accept the digital.
Item number 21, 2016, 4335 BC, 22021, 137th Avenue. Sandy?
This is Sandy?
Number 21.
It's okay. Okay. Raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board, and to respond honestly to board member questions?
I do.
Okay.
Good afternoon, Sandy Anagnostou representing the applicant. I attended the review session yesterday and noted the board's comments. We did, at the board's request, we did submit an alternative proposed plan showing an 18-foot wide building and providing a 4-foot yard along 220th Place, which the board feels is more appropriate in this case. We did provide a broker's letter as well, someone experienced in this particular area, who states that based on his experience, it's going to be hard to market a building of this size. But we understand the board's position on this. So this alternative proposal is actually quite a bit smaller than our original proposal, which was 1,980 square feet in floor area and over the maximum allowable by 180 square feet. The current proposal is 1,674 square feet, and that we're using the 300 square foot bonus for the one-car garage that we're providing, as well as area under display, which is, we calculated that is 129.36 square feet of area under display on the second floor.
Where's your area under display?
It's shown on the calculations on,
No, but
Here.
where is physically in the drawings the area under display? You know, we call this an attic bonus. That's the fond term that is described as.
Yeah.
You don't have an occupiable attic.
it's called attic bonus, attic rule, but actually, section 23-142 doesn't specifically say attic, it's area under display, and that's area that's between 5 and 8 feet that's directly under display. So we show our calculation, we have,
But wait, but looking
Right.
at your drawing, you don't have any area directly under the display.
yes, we show
You
it
have
in,
an attic first, and then you have a floor.
no, we show it in the section drawing, but actually,
I'm looking at the section drawing. You have an attic, which is directly under display, but it's not you can't stand in the attic. So if that was a 5-foot attic, for argument's sake, then it might count as floor area. I don't know if it counts as floor area normally in that area, in which case then you get your 20%.
no, it's area, I'll sh-
Yes, we're looking at it. You have an attic between your display.
So you're talking
But
about the
you have a
section.
ceiling
Yeah,
on
you
that
have a
second floor that goes straight across.
Right.
So your attic is above that ceiling.
Right, and the height that you have is 7 foot 10.5 inches. Is that the area that you're counting towards your attic bonus?
Oh, no, the 710 is measured.
that's further over. It's between 5 and less than 8 feet. It's between 5 and 8 feet. But we can provide a more,
Between 5 and 8 feet.
the area under display.
There is no area that's between 5 and 8 feet under the display. There's no splay.
That's the area, okay, there's area under the sloped roof. You have that the slope roof coming down. That's that area there, which is less than 8 feet.
You're looking, so that one little thing that is about 1.5 inches, you're counting as an area under a splay?
No, if you look at the calculations, it's more than
Where's
that.
the calculation?
On sheet PO, the actual floor area under display, it totals 129.36 square feet.
But where is it on the drawing?
So we show it in the section drawing, but we could actually provide a more detailed drawing with the area shaded in to show how it's calculated, to clarify that.
Could you just say what page would show it, and could you point to it so I can?
Okay, the calculations are on PO, and the section drawing is on P6.
That's what I thought.
But the interior dimension is 16 feet 4 inches. There is no 18 feet dimension. So I'm a little confused as to where that 18 feet is coming from.
18 feet is the width of the building, and 43 is the length of the building.
Okay, but why are you, but the interior wall-to-wall dimension, as shown in your revised plan, is 16 feet 4 inches. So the interior space where that attic ceiling is hitting that interior wall, interior portion of the exterior wall, is where that attic rule will apply. It's not from the outside, it's from the inside, and the inside, you're showing a height of 8 foot. So I'm not sure.
No, it's not, it's not 8 feet in the area we're talking about. It's 8 feet further, as shown in the section drawing, but
Okay, so I see a dotted line on the second floor, and the dotted line, okay, it does require an enlarged plan.
It says 15 foot 9 inches length of one dash line, for
Right.
example.
So I still don't get that 18-foot dimension. The dimension, if you are showing the 15-foot 9 as where the height of the ceiling is 8 feet, and between that dimension of, between that and to the exterior wall, that dimension is showing a 16-foot 4, it's not 18.
Oh, to go out to, no, that's inside dimension.
Inside dimension,
Yeah.
but 18.
It's supposed to be the inside
It should be,
area.
that's what I'm saying, it should be the inside dimension, not the exterior dimension.
And they're measuring, now I see the label on the second floor that says splay, that says on the, right near the word roof terrace, go to the left here, right near the word roof terrace, on the left side of the second floor
Oh, yeah,
drawing,
yeah.
there's a word splay, and it says 1 foot 1 inch or something like
But-
that.
But that's on the wall.
That's including the exterior wall and 1 inch or something of the interior. So I don't even understand this. This is supposed to be the attic phone. I don't
Okay, but
understand using this.
it does not say specifically in the section, it has to be under, in an attic. It specifically says area under a sloped roof, between
Understood.
less than 8 feet,
Understood.
between 5 and 8 feet.
But the whole intent of the attic rule was habitable space. Now, when you have a wall, which is a structural wall, the structural wall is not a habitable space. It's the space inside that structural wall that falls in that attic slope is where that attic rule starts applying. And I get it that you may have 1 inch beyond the structure wall where that attic rule will apply. If that is the case, then you need to revise the dimension. The dimension is then 16 feet 4 inches, not 18 feet.
Okay, we'll revise the calculations, and we'll provide a more detailed drawing and shade in the area that we can deduct based on this section,
Yeah.
and submit that.
The total dimension of the building is 43 feet 0 inches, whereas in P0, or P1, PO, it's 50 feet. So you cannot count the balcony space.
No, we're not counting the balcony
Your
space.
calculations.
But based on the calculation, it's 18 by 43. Okay, I'm sorry, I read the sellers.
It's 43, actual floor area under display, 43, and that's the second
That
floor.
dimension is, but again, that's the exterior. From exterior wall to the exterior wall is 43. The interior dimension is not 43. It's 43 minus the thickness of the exterior walls.
So, and I'm frankly having a lot of trouble understanding even the concept of this, that who builds the roof line to be exposed for 1.5 inches to the second floor when you've got an attic level? It's requiring that somehow or other the framing of the attic is at the second floor instead. You know how you could cure this is eliminate the attic totally. You just take out the rafters in the attic and don't have it finished, then I don't know how the building stands up, frankly, because you sort of need those cross rafters. But you need, if this was a double height space, now you've got an area directly under display, right? But by creating a crawl space attic, you've eliminated a legitimate waiver, except to say that it doesn't have to be between, it doesn't have any purpose, it's not floor area unless it's 5 feet, right?
It can be a nice sellable space, you have a very high ceiling.
Yeah, so, right. So the only, I mean, if you really want to take advantage properly without the silly thing where you're measuring 1 inch, make it a full height second floor. Or create an opening in the second floor where you've got an area under display along, something like that. I don't know exactly, but you would need to show how it's really under display. At the moment, it's sort of a game, and it's not really believable. And I don't know that the buildings department would even buy
We've
this.
applied this to hundreds of buildings we've done and never had an issue, but,
Of a display like this?
Sure.
Of 1 inch that travels around the perimeter of the building? That anyone even noticed? Maybe they didn't notice.
well, regardless, we're still under the maximum allowable floor area of 1,800
No,
square
not
feet.
regardless. So that was the thing, is if you don't have legitimate area under display, you're over.
But our proposed floor area is 1,674 if we don't deduct the 129 for area under display. So we're still under 1,800 square feet.
No, so the way it works is as of right floor area is 1,250 plus 300 for your garage. That's 1,550. You're proposing 1,620. So you need, I mean, it's really not a lot, but you're over by 70 square feet if
Right,
you don't have
okay.
area under display. I think the simplest thing to do is just to either get rid of the 70 square feet or open some part of it up to the under display, and then you you've got your, and take full advantage of your bonus. I don't think you were taking full advantage of your
Okay.
20%.
We'll take a look at it, but we do qualify for the 20% bonus. And we have narrowed the building down significantly. We've really scaled it down from what we originally filed.
Okay, because another way that we could do this is to say the board's not waiving floor area, and just say the buildings department to determine whether the 20%.
The base floor area.
Yeah, we're not waiving we're not providing a waiver on base floor area. So buildings department to verify any of the so-called bonus floor areas apply. We could do that. Yes, I mean, because I don't know that we had any other.
I think we
did
need
had-
to be very specific that we are, that the base.
You could provide more detailed drawing that would
No, but so
clearly
the
show
thing
that.
is, I don't want to take a position that the area under display for 1.5 inches along the second floor qualifies. Because then, and once the amount of floor area is in our documents, DOB looks at that as an approval on the total floor area. So we can say that we're approving the base floor area and DOB to determine whether the bonus floor areas apply. Bonus floor areas for attic and garage apply, and just leave it at that.
That's fine.
Right? Otherwise, you're asking us to make a judgment call on it at the moment. None of us have ever seen this 1 inch, I've never seen anyway, this 1 inch thing under display on the second floor. So-called under display. We see so many of these little houses, and all of them use it in the attic, right? So, okay, so I don't think there was anything else. Are there any speakers on this? Okay, so we are therefore accepting what's called the alternative plan, right, which is labeled, what is it labeled?
Proposed plans, alternative 18-foot wide home.
Okay, that's what it says on the PDF title, right? And they're dated, revision date?
10/31/18.
10/31/18.
Submitted January
7th.
Yes.
Okay. All right, then. So I'd like to make a motion to close then. We're all right with this? Oh,
Who's
we
gonna
don't have
do that?
anybody to close with.
Hello?
Where's Tony?
Thank you.
Chair Perlmutter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown?
Aye.
Commissioner Shetza?
Aye.
Commissioner Shabeta?
Aye.
And I'd like to make a motion to grant on condition, so grant the noted 18-foot wide building, right? On condition that Department of Buildings, that the board is not waiving floor area requirements, and Department of Buildings shall verify that, that the, whatever it is, the
Bonuses have been appropriately calculated, or?
yeah, I don't know if the word bonuses is, really, we should be citing to the sections,
Yeah.
right? The attic and the garage bonus floor areas, but that's not what they're called. They're pursuant to section XYZ.
It's 23-142A and C.
24.
23.
23-142A and C. C is the garage.
Okay.
Okay, great, provided DOB verifies those. Okay, on that, motion to grant?
Chair Perlmutter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown?
Aye.
Commissioner Shetza?
Aye.
Commissioner Shabeta?
Aye.
Motion is granted.
Thank you.
Item number 22, 2017-8BZ, 356-362 East 139th Street, the Bronx. Do you affirm, tell the truth, the whole truth, and nothing but the truth in your testimony before this board, and to respond honestly to board member questions?
Yes.
This one, what's a plan set?
Right.
provided that.
Which was the additional noise regarding the noise attenuation, noise, alternate means, and the acoustics.
Yeah, okay, and they were all done. Okay. Aye.
Good afternoon. Amanda Iannotti on behalf of the applicant. We made a submission yesterday afternoon with revised comments on the plans in response to the DEP noise sign-off letter.
Right, we saw them.
Okay.
Okay. Any other comments on this? Are there any speakers on this application? Okay. So I'd like to make a motion to close.
Chair Perlmutter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown? Aye. Commissioner Sheta?
Aye.
Commissioner Shabeta?
Aye.
And a motion to grant on condition. So this DEP's noise conditions, which are shown on the drawings about window wall noise attenuation of 33 dBA on the south facade. And the proposed third floor outdoor play area will be provided with acoustic fence with a minimum attenuation of 10 dBA at a height of no less than 10 feet. And that an alternate means of ventilation is required and should be incorporated into building design and construction. So alternate means of ventilation. All of those notes are on the drawings, but I just want to reiterate. And, oh wait, I'm sorry, and there was also,
There's materials, and there's also the amplification.
yeah, I just want to make sure I'm not repeating a note here. I am, okay. And then condition the masonry on the sidewalls materials, masonry rain screen, metal panels and glazing on the front and rear walls will be the proposed materials, and that the use of an exterior insulation finishing system is not permitted, okay? And also no amplification of sound or lighting on the roof.
Chair
Based on that,
Perlmutter?
motion to grant, yeah.
Chair Perlmutter?
Aye,
Sorry.
sorry.
I just want to clarify that the window to wall noise attenuation is 28 feet and above.
Correct, yeah, yeah.
Okay.
That's,
At 20 feet and above?
28 feet and
28
above.
feet, and that's consistent with DEP's letter?
yeah, that's what
Okay.
it says here.
Okay, thanks.
Thanks.
Motion to grant.
Yeah,
Chair Perlmutter?
aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown?
Aye.
Commissioner Sheta?
Aye.
Commissioner Shabeta?
Aye.
Motion is
Thank you.
granted.
Thank you.
23. Now we're at 23. Okay, good. We granted this one too? Kevin?
Yes.
Okay. Item number 23, 2018-10 DZ, 1238 East 26th Street, Brooklyn. Raise your right hand. You're the only speaking? Okay. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board and to respond honestly to board member questions? Okay.
Fan Baton from Sheldon Loeb LPC for the applicant. We attended yesterday's review session, and I don't believe there were any outstanding comments since the architect reduced the rear roof.
Correct, thank you. So I'd like to make, are there any speakers on this? I'd like to make a motion to close?
Chair Perlmutter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown?
Aye.
Commissioner Sheta?
Aye.
Commissioner Shabeta?
Aye.
And a motion to grant on condition, our standard condition, that removal of walls, exterior walls shown on the approved plans, or joists in excess of that shown on the drawings, will void the special permit.
So the Chair Perlmutter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown?
Aye.
Commissioner Sheta?
Aye.
Commissioner Shabeta?
Aye.
Thank you.
Item number 24, 2018-58BZ, 1182 Broadway, Manhattan. Got it. Raise your right hand. Do you affirm to tell the truth? Raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board and respond honestly to board member questions? Good. Yeah. Good. Nobody else speaking or anything? Okay.
It's 1182, right?
Good afternoon, Chair and Commissioner. Daniel Braff on behalf of the applicant. I attended the review session. I don't believe there were any outstanding issues.
No, there weren't. Thank you for changing the drawings. Okay, I'd like to, are there any speakers on this? I'd like to make a motion to close.
Chair Perlmutter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown?
Aye.
Commissioner Sheta?
Aye.
Commissioner Shabeta?
Aye.
And a motion to grant.
Chair Perlmutter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown?
Aye.
Commissioner Sheta?
Aye.
Commissioner Shabeta?
Aye.
Thank you.
Thank you.
Item number 25, 2018-64BZ and 2018-65A, 725 Mobile Road, Queens. Are we all speaking? Raise your right hand. This gentleman speaking also. Raise your right hand. Good, thank you. Do you affirm to tell the truth, whole truth, and nothing but the truth in your testimony before this board, and to respond honestly to board member questions? Thank you. Sign your in and proceed. I'm sorry, Sam.
Richard Lobel of Sheldon Lobel PC for the applicant. Good afternoon. Madam Chair, we had a representative at the executive session yesterday, so we're familiar with the board's comments, particularly the gating item here, which would be the discussion of self-created hardship. So believe that we probably are going to have to address many of the discussion points with regards to self-created hardship in a subsequent memorandum to the board. I would just briefly discuss some of the points that were raised yesterday in an effort to kind of clarify the conversation. So obviously, we're dealing with a case where we have a religious organization, and the board understands that pursuant to New York State case law, every accommodation must be made in order to accommodate the religious use of the premises. So I think one of the things we want to note here and to clarify.
I just want to interrupt there. I'd like case law on every accommodation, because that's actually not the case law.
Oh, sure.
So, because, as we said, there are many findings, and so we asked you to brief how deference works against the various findings, and we never received anything on that, so.
Okay. I'm not sure if the chair received our supplemental legal memorandum on self-created hardship.
There was a supplemental since the last one?
No, the last one.
The one that was submitted previously in December?
Correct.
I referred to it in yesterday's review session.
Right, but the idea was that that memorandum contained several points regarding deference due to religious organizations in the course of self-created hardship. So we feel that much of that was addressed, but again, we're happy to.
No, so it wasn't addressed, so just to make it clear.
Please.
Those cases were about purchasers of property where they knew that the property was somehow defective, and they came to that defective property, and that was not viewed as a self-created hardship. Like coming to a piece of property that was created in 1953 in a too small lot, that's not held against the property, the purchaser. Those are not viewed as self-created hardship, nor does the board ever view that as self-created hardship. When the property owner or its predecessor in title does not create the hardship complained of. But don't forget also that those state court cases often are not based on the zoning resolution.
Correct.
They're based on common law hearings on variance applications, so the courts are, in those cases, are often viewing a different set of criteria. We have a very clear statute that has to do with hardship, right? So none of the cases that you provided addressed the first sentence in the D finding, which says that the property owner or its predecessor in title cannot create the hardship complained of. So if you can find, you haven't provided us with any
Sure.
cases that address that, which was what we asked you to address at the last here.
So, Chair, the subdivision of the property here, which created the lot for which the synagogue is the contract vendee, was created by application to the Department of Buildings and Department of Finance in 2014. At that point, this synagogue did not even exist yet. The congregation was not created until 2015. So one of the things that I wanted to make sure was clear, because it's on the record, it is on the record, but it may be unclear, is that this property was for sale for purposes of a residential property for some time, years really, before the congregation became familiar with the property and entered into a contract to purchase the property in 2018. So while we introduced subdivision cases, which demonstrate that the creation of two substandard lots would indeed be viewed as a self-created hardship, that is not the case here. Were a residential developer or owner to come in prior to the time of the synagogue's purchase and purchase this property, they would be able to place a residential building on the site. The synagogue merely came in and, akin to these other cases, entered into a contract to purchase a property which was subject to the zoning that would prevent it from building the synagogue that would satisfy its programmatic needs. So we find that that situation is extremely on point in that many of the cases that were cited are for organizations which came in, had a property which was subject to zoning, and merely because it was subject to zoning, whether or not a self-created hardship exists, were the organization to make the other findings, the defining states that would not prevent the granting of the variance.
No, now you're conflating the first sentence and the second sentence. In order for the first sentence to have meaning, it needs to be left alone. Then the second sentence says, coming to a site that already has a hardship, like one from 1953 that was created that was too small, is not viewed as a self-created hardship, right? But if you create the hardship, and it's not even a predecessor in title that's creating this hardship, it's the title, the fee owner, the current fee owner creating the hardship complained of, right?
But not the applicant.
There is no hardship, well, the applicant's not an owner. It's not in title, so it's a contract vendee,
Well,
right?
but some of the case law that we submitted demonstrates that religious corporations, which are contract vendees, have standing to bring an action at the BSA.
Yes, they have standing to
That's not
bring
the
it.
argument.
Yeah, go ahead.
No, you can continue. That's just not the argument.
Yeah, that's not the issue, and I don't want to hash this out too much here because we were very unsatisfied with the brief as making an argument to support the finding that there is no self-created hardship, and you're going to need to do a careful legal analysis, which this was not. So that brief submitted in December was not the kind of legal analysis you would submit to a court, where you're providing the court, for example, with all of the cases that are on point, not off point. We got a lot of cases that were unrelated to the question before us. The question is very, very specific, right?
If I could.
Yeah.
You also, and this happens often, you have to stick to one argument. At the last hearing, we stated that, it's while this may be a self-created hardship, this is a religious institution, therefore it has deference. And now you're also saying it's not a self-created hardship. So I think you're going to have to argue both now. You're going to have to say why this isn't self-created hardship, and if this board deems it to be self-created hardship, we have deference pursuant to these cases. And I read the cases. I read each of them. No case that you submitted stood for the position that a religious institution or any institution with deference can overcome a self-created hardship simply because of deference. And that was one of the things that I was expecting from the brief because of the last hearing.
So those are the arguments that we are making. So first of all, we feel that this is not a self-created hardship, to be clear. We feel that the synagogue here is purchasing a property which has a productive use. This is not the situation where, and we can cite cases, where a property was purchased with the expectation when the lot was created that they would need to get or would be going to get a variance. This is a property which can be provided on the record. This property was for sale for years for an as-of-right use without any discussion of waivers. The synagogue, the congregation came upon this property, and at that point, were they to apply for, at DOB, the necessary application, they would be provided with a ridiculously small synagogue. As is the case with most synagogues which come to the board, they then applied for waivers which would allow them to enlarge the physical plant of their building. So as far as a self-created hardship, we don't feel that one exists. Regardless of that, we do feel that even if the board was to find this was a self-created hardship, that the purchase of this property, subject to that being the only finding that would not be met, the board would still be able to grant this application.
So could I ask?
I would just, yeah, please.
Could I ask, so the first sentence in D, by your definition here today, the first sentence in D would rarely ever apply.
That the practical difficulties or unnecessary hardship claimed as a ground for a variance have not been created by the owner or predecessor in title.
Right.
Well, so first of all, it's, many of the cases that were discussed by the board, including one that was cited by Commissioner Sciabetta in the executive session, they dealt with for-profit corporations. So to the extent, and I apologize if we didn't set out all of those cases in the memorandum, the reason we didn't do that is because of this unbelievably strong preference in favor of religious institutions. The statement in and of itself from East Hampton Library versus Zoning Board of Appeals of the Village of East Hampton that says courts have found that where negative impacts are not so extreme to justify the denial of an educational religious use, it is incumbent upon the zoning board to accommodate such uses while imposing conditions to mitigate adverse impacts. That basically is, it's a very strong statement to make. It basically puts the board on the side of the religious institution, and to the extent that the religious use would be excluded from an area by imposition of the variance, the board is instructed to in essence, assist the applicant.
But you're sidestepping the question entirely,
Please.
right?
So you didn't answer the question.
Okay.
The question was, if the definition that you gave moments earlier, how would the first sentence in D ever be applied? Especially when you have to consider the predecessor and title portion of it.
Creation of a substandard lot, upon which no building would be permitted absent a waiver would satisfy or would not satisfy the defining condition. So, and that is.
By your definition, it has to be, the lot has to be substandard.
Well, because that's in the cases, and we did cite the case and I can recall it, but because the creation of two substandard lots has been found to be a violation of the defining which can't be cured.
Sure, no, I agree.
So then that's the answer.
Hold on.
So that's the answer.
But is that the only time that D only comes into play when a substandard lot is created, not one that could have been created differently?
I would say that if a lot was created, which there was evidence that the applicant purposefully was going to a zoning board and requesting relief, then I think that probably would also satisfy that as well.
That wouldn't be the predecessor in title, would it?
It could be the predecessor in title. It could be basically a predecessor in title that there is some sort of affirmative evidence that lot was created solely for the purpose of going to the zoning board and requesting that relief. And I do want to address the case that you raised in the executive session, I think it was the Albany case, for a rehabilitative center, is differentiated on a number of different items. The first was, it was a for-profit corporation. For senior housing, it was a for-profit corporation. Ours is not a for-profit corporation. It was decided under town law. Ours is decided under New York City variance pursuant to 7221. Most importantly, cases decided under the town law distinguish and discuss the fact that should a use variance be sought, the D-finding will be terminal to that application. So I asked for a use variance, as was asked for that institution within a residential district. They asked for a use waiver. And so first of all, they didn't meet any of the findings. So the cases were clear, they didn't meet, there was a financial hardship finding.
No, they-
So, okay. But as far as the D finding is concerned, pursuant to case law, under town law, for a use waiver, the D finding, the inability to satisfy the D finding will be fatal to that application. Whereas for an area variance, it's not. Under town law, should an applicant be able to meet the other variance findings, then similar to 7221, the D finding can be overcome. So those were, and again, I understand the fact that you want to understand that area, that we should include that, and particularly that case. But I think one of the reasons we didn't include some of the cases is because they were so, so far from what we were seeking, which was, an area waiver pursuant to 7221 for a religious organization.
I think my bigger problem here is I'm not convinced that your definition of the first sentence of D, or that D should be interpreted so strictly to how you define it. And that's going to be something that to convince me at least,
Sure.
you're going to have to provide me with substantial case law on that.
Understood.
And then I haven't seen anything, and even within my own research, that supports the statement that religious deference can overcome a self-created hardship. So these are two both roadblocks, at least from my position, that I welcome you to.
Right, and just to pick up on, and I didn't create little briefs on each of the cases that you submitted, but the case of Patrick v. Village of Russell Gardens, the court found that a self-created hardship existed when a single-family home lot was subdivided to create a non-conforming lot, right? So that's their definition. They use the word non-conforming and non-complying kind of interchangeably in the courts. But that's actually what's happening here. For the purposes of a community facility, this is a non-conforming lot. You can build a house on this lot. That was shown in the drawings that were submitted back at the time of the subdivision. You cannot build a community facility on this lot because the regulations are different. And the drawing that was submitted as the as-of-right drawing is inaccurate because it's measuring the front yard off the property line, not the widening line. So when you take all the correct measurements into account, it's basically a tool shed that you can build on
Right,
the
but
site.
Chair, it's very important, that tool shed is very important, because to the extent that every religious application or the overwhelming majority that come to the board ask for waivers of lot area, of floor area, of yards, of height in order to locate, so that's essentially, in essence, the same thing. You can fit a congregation in any of these, on any of these properties that come before the board, but you can't fit a congregation that's before the board. And so here, it may be different to the extent that you could not locate a religious institution here absent, at all. But that's not the case. It's basically the case that you have the ability for a physical plan of a congregation. It's just that we're asking for the waivers that everyone else is asking for in order to locate. And I would note to the board, as we cited in our papers, that the waivers we are asking for are indeed in the range of what's been granted by the board, if not on the low end of what the board has granted. So floor area, yards, and all of these, we can provide cases upon cases to the board that what we're asking for is small.
There's no dispute about whether on lots where there's not been self-created hardship, the board looks at a lot that a synagogue, say, comes to and asks to get waivers for, then the board has entertained waivers of all descriptions, right? But that's when the property owner, let's say the lot existed since prior to 1961 as a lot that's too small for the community facility and often too small for the house. We often see sites where the lot's not good for anything. And the only way to develop it at all is with waivers, either for a house or a religious institution. So that's not the question here. We're still stuck on the fact that the lot was subdivided with an assumption that it was going to be developed for some purpose, whether for residential or for community facility. We cannot know whether this property owner had in mind selling it to a synagogue. But for me, the precedent is very dangerous, because what it's suggesting is I own a piece of property with a house on it, I subdivide it into some really untenable lot, and then I I call the real estate agent and I say, broker this to a religious institution or a school so that they can come to the board for religious deference or educational deference and get waivers on all the yard requirements and the heights and the floor area and all of that. And therefore, I sort of double dip on the value of the property. That's not what the waivers or what variances are for. And really, this could be taken to such extremes that it makes me extremely nervous.
Chair, I feel that it's far more dangerous to the board to ignore the strong beneficial presumption in favor of synagogues and religious institutions than what the board is addressing now, for the following reason. For better or for worse, applicants before the board now come and testify to the truth, to the fact that they're being truthful before the board. So if people were purposefully attempting to be devious to the board and to attempt to subdivide property in order to take advantage of the zoning law, I feel that would be, essentially they'd be perjuring themselves when they came before the board.
Only if they got to speak before us. And most of the time, the sellers don't come up here and speak to us.
So we can provide that, we can easily provide testimony with regards to the status of the property, but again, this is a religious corporation, and actually, it would probably behoove us, if I may have an executive officer of the synagogue speak for a moment about their finding of the property and the marketing of the property at the time they found the property.
I don't think it's relevant,
No,
right?
I think it'd be better in writing at this point.
Right, yeah.
I would just like to speak, if you don't mind. If you could give, my name is Edward Hertz. I'm an executive member of the board. of the synagogue, excuse me. For 2 minutes, I'll speak quickly. I know you have a long day behind you and ahead of you.
But the more important thing is that we're working on a legal question, and what you're about to say doesn't go to the legal question,
I would,
right? We're looking at
It
the
does to some
question of law, and
I request anyway to allow to speak for a minute.
With that proviso, can you, yes.
Very quickly, okay?
Comments.
Firstly, just understand, I'm one person standing in front of you. I represent 85 women, 85 men, and hundreds of children behind them. The families that we represent, to whom the synagogue is the central point of their life, it's the focal point of their communal life, their religious life, everything they stand for. I can't speak to how much, I can't possibly impress upon you how much it means to the children and how much it impacts their lives, that they have a safe haven in a world that pulls them in all directions. I'm familiar with Brooklyn, I'm familiar with Queens. I grew up in Brooklyn, my wife grew up in Queens. There are probably hundreds of cases that come before you of synagogues that's from Brooklyn or Queens that it's easy to find properties. We're not that kind of situation at all. We're a community where it's impossible, for whatever the reasons are, without getting into them and boring you, where it's impossible to find sites that work for religious institution. We searched all in all for a total of 2.5 years and came across this property. We had 10 people searching. This is the one property we came upon. We called 3 lawyers before we started. We didn't hire Richard initially. We called Richard to ask if we'd have a problem with, if there'd be an issue with our variance. We requested that of 3 lawyers, Richard and 2 others. All 3 of them, we discussed the potential pitfalls. All 3 of them raised a potential self-created hardship issue, and all 3 of them said they don't believe it will be an issue. I then sat across the table from the chairwoman, who also told me, I point-blankly asked the question, and she said she doesn't believe it will be an issue.
I'm sorry, you were directed not to discuss what happens in review sessions. Those are
Pre-application meetings.
I'm sorry, pre-application meetings, and I don't want to discuss it anymore. Those are done as courtesies.
Okay.
Now you are getting a hearing before the board, and the board and its lawyers review the case that is presented, which it's not aware of at the time of the pre-application meetings, and really.
Okay. Okay, I'm sorry, I'll take that back. I just want to make my point.
You're opened up privilege, you need,
It wasn't.
All I'm just trying to make a single point.
The conversation he had with his attorney.
I'm just trying to make a single point. My point is, if there is religious deference in general, not to self-created hardship, if there's religious deference in general granted to a religious institution as opposed to a for-profit, all my point is, granted, I don't know anything about the law. Let's assume for a second that you have a very compelling argument that the law is on your side. There is certainly an argument felt by 3 legal minds that I spoke to on the other side. Doesn't deferential treatment say that we don't have to prove beyond a reasonable shadow of doubt that that this is not a self-created hardship?
Okay, I need to cut this off here. You're having a legal argument without being a lawyer.
Okay.
We can't do this anymore. Your
So then
lawyer
can I just
needs
discuss
to
the
do
history of the
this.
property for 1 minute?
Sorry?
I discuss the history of the property for 1 minute?
We've already heard
Yeah,
a lot
I believe
about
you
this.
testified at an earlier hearing about your search for the property. I think now, though, we're trying to get to a place where we can cross a threshold, and I think your attorney is well-versed in
Okay.
what the issue is, and I would advise that you kind of let him.
Okay, thank you.
Okay, what's the date?
Okay, yeah, are there any speakers on this? Okay, we just need to set a date for briefing. The
Okay.
briefing needs to be thorough. Thorough, you're appearing before the Court of Appeals.
Chair, I've argued this point of self-created hardship before the appellate division, so
You said that at the last
I have, but
hearing, and we did not
it's true.
get quality submissions,
So
so I don't want,
but
that
I
is
just
your
wanted,
preference.
I want to confirm to the chair that I'm happy to provide what I regularly would provide to a court listening to this matter.
Thanks.
Okay.
How much time would you need to do that?
The synagogue is obviously pressed for time on this matter, so whatever reasonable amount of time that the chair and the board can bring us back, I'm happy to do the work necessary to provide it prior to that time.
April 23rd?
Do you have the hearing?
On this calendar? I can't tell.
What date?
Jim's. Yeah, it's okay.
Okay, so April 23rd with a submission April 3rd.
Given the holidays, I'm just checking the calendar for a moment, if you'll allow me.
Please, go ahead.
April 23rd would be great.
Great. Hearing April 23rd, submission April 3rd.
Thank you, Chair. Thank you, Commissioners.
Item number 26, 2018-99BZ, 275 Pleasant Avenue, Manhattan. Raise your right hand, Richard. Are you the only one speaking? No? Okay. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board and respond honestly to board member questions? Okay, just sign it. Here, this one's swear to see.
Richard LaBelle of Sean LaBelle for the applicant. Chair, I know that there have been a number of submissions in this matter, including opposition submissions. I understand the popular topic of self-created hardship was raised. We did.
With a very good brief on the
Oh,
subject.
thank you, Madam Chair.
You'll get compliments, too.
Excellent. We'll take it when we can get it. So we do appreciate that and are happy to answer any further questions on the board.
Okay, I think the only question was, and that's what I'm just checking, I had a question in terms of the drawings about whether that obstruction in the rear yard
Right.
was a greenhouse.
So the applicant has, we've submitted on the record the plans with notations, as was indicated by the board, that the board was not approving anything in the rear yard, and that the rear yard, the greenhouse should be reviewed by DOB for compliance with permitted obstruction regulations.
Okay, do you have?
I have
one of
copies of
those?
that.
Can we just see one? What?
I emailed it.
No, he has a copy right there. I just want to read the note.
Ooh, you okay? Too many wires.
Don't get. It's not worth it. All right, it says someplace, hopefully. Can you tell me what page? Oh, here we go. No.
It's just too many damn wires, what it is.
What page is that note?
It should be on, give me a moment.
No, it doesn't.
It's on Z003.
Correct.
Really?
Yeah, it's in the,
Oh, on the elevation, okay. DOB or sections, DOB shall review greenhouse for permitted obstruction compliance within the required rear yard. Okay, normally that goes on a floor plan, but all right, it's on the drawings. Okay, and we can make it a condition. Are there any speakers on this?
275 Pleasant Avenue, Manhattan.
Ah, yes.
Sir?
Please come.
Please state your name for the record, and you'll have 3 minutes to speak.
Sure, thank you. Want to read something into the notes, please, ma'am? My name is Ian McPherson. The president of the 277-279 Pleasant Avenue Corporation. Just want to read this in. Dear Commissioners, I'm the president of the 277-279 Pleasant Avenue Corporation.
Speak a little louder, please, or maybe.
Sorry.
You can take the mic.
Yeah, hold the mic.
Sorry
I don't know if you can do both.
I'm not used to this kind of stuff.
No, but it's just you're so tall and the mic is very far away from you, so that's why it's hard to hear.
I'll bend.
Okay.
Okay, thanks. Dear Commissioners, I am the president of the 277-279 Pleasant Avenue Corporation, the owner of 277 Pleasant Avenue, Lot 125, and that property abuts 275 Pleasant Avenue, Lot 25. I want to make the following notes. The applicant's architect made a distorted and inaccurate statement to the DOB to obtain the DOB permits as stated in my letter of 2/19/19. That's February 19th of this year. The applicant commenced construction based on those permits which were, faultily given. The applicant is now seeking a variance to legalize the work and continue construction. In the applicant's memorandum dated 1/2/19, that's January 2nd, 19, references the case of Shakoff versus Hitchcock. According to the memorandum, the facts in the case are: a permit was obtained after an architect had submitted plans which were distorted and inaccurate. The petitioner and the building claimed they built the structures according to the permit. But the hardship was self-created and distorted by the distorted, misleading permit that the application submitted, gained from the wrongful or misleading application. The memorandum goes on to say that in this matter before the BSA, the sole revocation of the building permit is the size of the zoning lot. This is partially true but inaccurate. The building permits were revoked because the architect stated the property, Lot 25, was owned separately as of 12/15/1961. In fact, lots 25 and 125 were jointly owned on that date, 12/15/1961, and remained jointly owned until 1976. The ownership title chain is documented in the applicant's statement of facts and findings dated August 28 of 18. Therefore, the hardship complaint in this application is self-created and the application should be denied. I hereby submit copies to everybody here.
Thank you very much. But you already sent that to us, right? Didn't
No,
you?
ma'am.
Oh, this is the separate thing? Okay. Thank you.
Can I have a copy to keep? Okay. Thank you.
And I think I have to give it to the lawyer, whoever he is.
Okay.
Mr. LaBelle there. Okay. And then give it to Mr. LaBelle.
Are there any other speakers on this?
Mr. LaBelle, he's the attorney representative.
Thank you.
Thank you.
I think, though, Mr. LaBelle, I think we've already gone through the history of ownership, and that's what your much better brief on hardship
Correct.
was addressing, which was that it was the city of New York who actually ended up, sorry, once you've spoken, please sit down, and thank you. And that the city of New York ended up becoming an intervening party, so it's much different than when an owner, what we call actively subdivides the property with the intention of creating hardships.
That is our point, Madam Chair.
Yeah. Are there any other questions, comments? Okay, so I would like, so we got this one already. Okay, I would like to make a motion to close then.
Chair Promoter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown?
Aye.
Commissioner Shepherd?
Aye.
Commissioner Shabeta?
Aye.
And I'd like to make a motion to grant on condition, the condition is picking up on the change on the drawing, that that the greenhouse as an obstruction in the rear yard is for DOB to determine compliance, and that the board is not waiving rear yard requirements. So on that, a motion to grant.
Chair Promoter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown?
Aye.
Commissioner Shetta?
Aye.
Commissioner Shabeta?
Aye.
Thank you, Madam Chair, Commissioners.
Application's been
Thank you
granted.
for coming. Thank you.
Item number 27, 2018-107BZ, 1441 South Avenue, Staten Island. Is that right? The swearing sheet is yours.
You mean the...
Who's speaking? Who's speaking?
Yeah, we did.
Okay. Oh, wait.
If anyone speaks.
Oh, no.
Raise your hand.
This is our last one.
Thank you. Do you affirm to tell the truth, the whole truth, and nothing but the truth of your testimony before this board, and to respond honestly to board member questions? Oh, I'm sorry, did you?
We had Todd as the second.
Yeah.
Okay. Yeah. Todd was going to submit something. And Neil. Yeah, we're Todd.
Oh.
Yeah. Todd Dale. Yeah.
Todd's and Neil's.
So we did attend review session and know that there were still a few outstanding questions with what we presented. We do have Mr. and Mrs. Nakotra, property owners here. We also have Jeremy Lisinski from the school team, architect team is in the back in case any of those questions come up. But with respect to the circulation plan, here it is right here. I know there were some questions raised. I just want to start.
Take the mic with you, Todd.
Mike.
Especially voice like it is today. I just want to bring up some points, and Jeremy can supplement if there are any other questions. This is actually simpler, I think, than the board might be making it. Just to clarify, these are existing routes. These are the proposed routes. The existing routes will remain. The proposed routes will be new. Essentially, each bus gets one building. That's it. So buses are not going to stop at Corporate Common 1 and then go to Corporate Commons 3. It's a case where the schools are existing and the certain areas are going to be relocating to the new building. In our papers, we noted that there were 7 yellow buses currently and 5 the MTA buses, which are the dedicated MTA buses. It's not a typical bus that everybody gets on. The anticipation is, with volume, they might add 1 or 2, and a lot of it depends on what the school enrollment is. But these routes as shown are the routes as shown, and it's not going to be moving one way or another. Okay? I know there was a question also raised about the parent drop-off. Just to clarify, we do realize there's a crosswalk there. That's why this proposed security sentry station is right there. We have one here and one here, both on sides, to ensure that any students being dropped off here can safely move into the new building.
When it's a crosswalk, it means there's a monitor who's there to make sure the kids are crossing? What does it mean?
How's this? I will defer to Jeremy in a second, okay, to speak to that. But I think that those were the key questions. So I don't know, Jeremy, if you want to talk a little bit about, the system has been in place for many, many years with the existing school, and he can speak a little bit more to what those sentry points mean. So you can maybe just describe a little bit of what the existing sentry points are.
And
Sure.
state your name before.
Jeremy Zielinski, Director of Security. Essentially, it's your typical school crossing guard. They stop traffic when there's a group of kids on the corner, cross the kids. Once the kids are safely across, they open traffic up again. We have posts all over Corporate Commons 1 now. These are the proposed Corporate Commons 3 posts. They're going to be doing the same exact thing.
So those open circles represent a person standing there,
Correct.
making the kids come and
Correct.
go, cars.
Stopping traffic
That's what I
and
want.
crossing them.
Okay, great.
Okay?
Yeah.
I think that those were the key questions relating to the circulation plan. I don't know if you had any other questions.
On circulation?
No, okay. The next item that came up was a question raised about the gate at the loading dock. I have 2 handouts. I'm going to pass them up. We'll address the second one for the next point. 2 handouts, printouts. Just so the board is aware, we did make a submission yesterday. I don't know if you saw it, with revised 4th floor plans. No, this morning. I'm sorry. Came in.
we didn't see
This 4th floor. I've got copies of that to show you, but it should have been submitted to the record. But the 2 handouts are coming, the first one is just a demonstration of the existing ground floor plan. And what happened is the architect team actually took typical size box truck, which would be the only trucks that realistically would ever come to this loading dock, showed that the way the gate is currently designed, that gate, as it's designed to swing, you could actually have 2 trucks, box trucks in there, and the gate could still open and close freely. So there's not going to be any interference whatsoever with the gate as it's currently proposed.
Okay.
And just to supplement what we already said, these are office uses. They're really not expected to use them much, but the intention all along has been to keep those gates closed during school drop-off and pickup and absolutely forbid people from making deliveries. And the security team, if they see trucks that are coming in during the rogue hours, are just going to tell them no. So that's the plan.
Okay.
Okay?
So in other words, it's something like the crossing guards or somebody like that just tells the truck, hold back in the parking lot or something like that.
We submitted photos of the last submission. Not only are they crossing guards, but they have radios where they can communicate with each other, so they can communicate back and forth like with the queuing. So I would say they go above and beyond even a typical crossing guard. Another question came up was regarding the 4th floor separation. Now, the submission that we did make, we took to heart the questions the board raised about, continuing concerns about possible intermingling of the older new venture students and the younger students. So what happened is a extra door was added on the 4th floor, okay? And what we did to help describe it a little bit more is this color plan sort of designates how that 4th floor would be used. And you can see that the gray area, I didn't keep one for myself, so I get the colors wrong, you could tell me, but the gray.
No, it's gray, it's gray.
Okay, so
The gray area
is where the
gray blue.
It's the only place that the new venture students could go, or excuse me, the light blue. The gray is their only passage, and the 2 doors restricts the space that any of the new venture students could come in. And just to clarify, the only new venture students that would come up to the 4th floor would be the limited population that would be part of the culinary program, and the bulk of new ventures comes after the other 2 schools close at 4 o'clock. The ones who come early would be supervised by staff, the 2 doors would prevent entry, and they would only travel back and forth. So the blue area is the only area they would get to. And then the green areas and the purple areas, which are designated as far as administrative, and then the Lavelle and the Nicotra Early College, you can see that there's a clear separation. So, based on the board suggestion, that extra door at the end over here really does fully isolate those 4 rooms for the new venture students.
Okay. So there's an S7, I don't have the key in front of me. Do we know what S7 stands for?
It's probably part of the full proposed plans that were just sent.
Yeah.
Let me double check here.
So S6, I remember reading, which was the doors locked from the school side, though it's probably got to have panic hardware for fire department run through. But and then also, I think a door was added to the P123 elevator corridor, which is good, because it keeps everybody in there in that gray area, but that doesn't have a code on it.
So S6, I know S6 is the locked from poolside.
Is what S7 is?
Remember to speak to it?
S7,
I forget.
there is no S7.
Yeah, unfortunately, the colored plan, which was done for demonstration, doesn't have it.
You didn't swear him before, right?
Charles can
Do
speak.
you affirm to tell the
The
truth?
architect is here,
I'm
so we
sorry,
can clarify.
just to swear him in. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board and respond honestly to board member questions? Go.
I do.
He's the architect, I need him.
Charles Thompson from Feburary. It was just because one was from the pull side, we added a separate note that was locked from the push side.
Okay, so S7, don't go. So in other words, the drawings that were submitted to us tell us what S7 is?
Correct.
Somewhere, because we don't, is that a new set that you were looking at or an old set? Oh, okay.
No, that's the
old set.
They were submitted this morning.
It was emailed to the this morning. Okay. And then the other question is, because you do show another pair of out-swinging double doors into the P123 corridor, and that doesn't have any kind of a designation of how it's going to be treated. I'm pretty sure that's a new set.
So, just to clarify, the doors that
The
are
double doors.
next to P1,
Yeah, next to P1 elevator that swing into the P1, oh, I see, so S7 was added, it just says locked from push side, yeah.
It would be an S6 note.
that would be an S6.
So the S6 is S6 is locked from pull side and S7 is locked from push side.
Yeah.
That's,
Okay, so I think, I don't know whether you, does this double door have a designation? It doesn't, no, I was talking about that one. Okay,
this one.
I don't want to torture you with more little things like this. So what we can just do is, now that you've designated this area, that we can describe as including, how does this work?
The new
Class-
ventures classroom, the instructional kitchen, and the executive dining room.
There you go. So that corridor will be an isolated corridor. We can actually just say that the corridor that gives onto those 4 rooms becomes an isolated corridor protected from the rest of the building by these doors that are locked but pursuant to fire department, whatever that means. That might be panic hardware. So from the out, from whichever side, I don't know, the push side. From the swing side, it's indicated by the swing.
Right.
The swings are always in the direction of egress, so that's the way they're supposed to be. Okay. So just to make it easy, we'll just say that, okay? All right then. Was there anything else that we left off? Yeah, well, we still have DOT issues.
The only thing that I can speak to is I know
That one away. We need
that we've been working with Ms.
Oh,
Pringa
I see.
with the DOT school safety, and I just want to make a couple points about that. Originally, when we received the initial correspondence, I believe it was 6 weeks ago, we've been diligently trying to be in contact with them, and they were radio silent till yesterday. And we've been reaching out to provide as much information. They asked questions about the sidewalk, and we did a very quick plan, color coding, and showing the sidewalk. We're happy to answer any of those questions, but I would note for the record that the tech memo was signed off, and when we reached out to the environmental engineer, OEC, in conjunction with DOT, it might be a different DOT department, but in conjunction with DOT, removed any study of pedestrian safety and school safety from the tech memo purposefully because DOT doesn't have jurisdiction over a private site. So they were prepared originally to do the tech memo and were told by DOT and the OEC not to include that, and DOT said, we do not have jurisdiction. So we were very surprised when we got this comment from, I'm not sure how the DOT departments talk to each other, but we got very surprised when we got this comment from a different division of DOT. That said, we've endeavored to respond to them, but we also believe that this application's tried to do everything possible, and we've tried to provide the answer, but we don't think that we should be held up further for an agency that already said we don't have jurisdiction.
Well, okay, so this is my way of thinking. So a lot of this is a charter school program, right? So it's obviously effectively a New York City public school project, right? So, and it's serviced by MTA buses, which recognizes that this is effectively providing public school education, right? So the involvement of DOT seems reasonable to me because it's children who are going to effectively a New York City public school supported building, right?
Right.
The fact that it's taken so long and DOT still hasn't gotten around to you, I'm appreciative of, and I know that we've looked at as many things as we can think of without being traffic experts. Makes me say that I'd be willing to close this, but condition approval on DOT's continued review of the school safety and the applicant's willingness to work with DOT and introduce other safety measures if required by DOT. Yes?
I'd say we're happy to work with DOT.
Okay. All right. Sound fair? I don't want to cut them out of the process at all because they're right to be concerned. So, okay.
Yeah, we're happy to do that. And as noted, this is not just we've said it before, but this school is not brand new. They're in operation on that site, different buildings, so they're familiar with the site. And they've had a great safety record and program, and they're willing to adapt whatever way necessary.
Okay. No, and I think that you're working with us here is proof that there's a willingness to come up with solutions.
Sure.
So, okay. So then, anybody else, any other comments? Did I already ask if there were speakers? Maybe not. Are there any speakers on this? Okay. So then, I would like to make a motion to close. We've otherwise cleared all the environmentals, right?
Yeah.
Any OEO, okay. Okay, so a motion to close.
Chair Promoter,
Aye.
Vice Chair Chanda.
Aye.
Commissioner Otley Brown.
Aye.
Commissioner Sheta.
Aye.
Commissioner Shabeta.
Aye.
Okay. And a motion to grant on the following conditions. So the first set of conditions are what I just mentioned, that, that the applicant works with DOT to ensure school safety and makes whatever changes are recommended by DOT to improve the school safety of the children. Do that after, okay. And then the next one is that, as we just discussed about the New Ventures corridor, so that the corridor that gives onto New Ventures classroom number 1. Oh, they actually, are these numbered classrooms? Are there classroom numbers on the main drawing? Yeah, we can make it easier. The classrooms are numbered. Classroom number 415, 416, 417, and 421.
What plan sheet is that on?
That's,
It would be BSA 204. It's not noted on the color plan, but it's BSA 204.
204, okay.
So the corridor that gives onto those 4 classrooms will be separated with double doors that swing in the direction of egress, that are locked from the, I guess it's from the
Entrance.
from the, how can that be? It's the direction of egress. That are locked and meet fire egress requirements, right? So if that's with the panic hardware or whatever, that have required hardware to meet fire egress requirements and also to provide security to isolate that corridor from the rest of the school. What's that?
Okay.
You can't really lock them, then that becomes this isolated, scary space. Okay.
Okay.
All right.
Insecure.
It could be on some sort of link or, yes, or just panic hardware, or an alarm, panic. Anyway, okay, so on that, a motion to grant.
Chair Promoter.
Oh, wait, sorry, stop.
Yes?
Sorry, I left out some
Left something
conditions.
out.
Yeah, sorry. There were conditions from the attenuation. Right. Let me make sure I've got the right one. Yeah. So the conditions are DBA attenuation and traffic mitigation measures stated in the tech memo, and as shown on the approved drawings.
Okay.
The gate at the loading dock to be kept closed during all arrivals and departures of children.
Okay.
Elevator S2, these are shown on the drawings already, but elevator S2 to be dedicated to school use without access by other building tenants. And security controls as indicated on the approved plans shall be implemented. Great. Okay. Good. So with that, motion to grant.
Chair Promoter.
Aye.
Vice Chair Chanda.
Aye.
Commissioner Otley Brown.
Aye.
Commissioner Sheta.
Aye.
Commissioner Shabeta.
Aye.
This application's been granted.
Okay, before we go on our lunch, go back to the second calls briefly.
Chip.
Are you available from Flatbush Avenue?
I'm available right now.
Okay.
Yeah, I'll take a minute.
Just let me get to that page.
Which case? Which? We don't know.
This will be,
Item number 9,
there you go. Item number 9.
33698BZ, 33798BZ, 324, 334 Flatbush Avenue, Brooklyn. Please remember that you remain under oath.
Good afternoon, Todd Dale from the applicant. We did submit the revised zoning analysis for the one lot reflecting the correct square footage for the proposed PC.
Great. Everybody all right?
Okay.
Okay, so I'd like to make a motion to grant.
Motion to close.
Oh, close, sorry, close.
Chair Promoter.
Aye.
Vice Chair Chanda.
Aye.
Commissioner Otley Brown.
Aye.
Commissioner Sheta.
Aye.
Commissioner Shabeta.
Aye.
And a motion to grant.
Chair Promoter.
Aye.
Vice Chair Chanda.
Aye.
Commissioner Otley Brown.
Aye.
Commissioner Sheta.
Aye.
Commissioner Shabeta.
Aye.
Thank you.
Did we have another second
Mr.
call?
Weisbrod, are you not
You
ready
ready?
yet? Okay, so
Okay, so now a 30-minute break for lunch, right?
we'll come back at 3 o'clock. 35 minutes.
Oh. Make sure
35
you're
minutes.
back at 3 o'clock.
35 minutes.
Okay.
Yeah.
Go. Okay, item number, we're going to do a second call first. Yowza.
It is.
Item number on the zoning calendar, continued hearing items, item number 19, 2016 4274BZ, 1411 39th Street, Brooklyn, and item number 20, 2016 4339BZ, 5018 14th Avenue. Please be reminded that you're still under oath.
Neil Weisbart on behalf of the applicant. Good afternoon again.
Okay.
We submitted the new drawing with the mechanical ventilation required note, and it's been submitted electronically to submit at PSA.
Right, okay, so just looking, we have it, it's just where is it? Okay, it says composite window wall, nose attenuation of 28 dBA to be provided, closed window condition with an alternative means of mechanical ventilation required, yay. And that's on both
That's on
sets.
both 39th Street and 51st.
It's on both sets.
Yeah, okay, so you saw it, because I've only seen it on 39th Street. 39th.
Take a look at it. Make sure, double check.
I didn't get the one for 51st, did you?
Here.
Oh, yeah, here it is, it just came. Okay. You see the note?
Just getting to it.
It should be there.
Find it for you.
Yes, composite window wall noise attenuation 28 dBA to be provided along the 51st Street frontage and 31 dBA along the 14th Avenue frontage, closed window condition with an alternative means of mechanical ventilation required.
Great, okay. So then, I'd like to make a motion to close.
Chair Promoter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown?
Aye.
Commissioner Sheta? Commissioner Shabeta?
Aye.
Okay, and a motion to grant on a whole bunch of conditions. The conditions, of course, are referring to submissions by the Department of Transportation, for instance, that has to do with closing the curb cuts, providing protective barriers, bollards on the 39th Street site, and about, so I'm just going to refer to this DOT school safety sign-off letter that's from January 11th, 2019. The conditions that are in that letter should appear because it'll take too long to read all
Okay.
of them. And I'd say all of them are showing up on the drawings in some form or other. Also, there are also the noise attenuation conditions that were in the DEP noise sign-off letter, and also the DEP, what is it? The sub-slab vapor barrier system, that's also in the DEP sign-off letter for 51st. And then, generally, as to the 14th Avenue site, no commercial use of the multi-purpose gymnasia or dining halls for catering or banquet hall purposes is permitted. And I'm just noting in an R6 zoning district. And then the other is the maintenance of a permanent location for school bus parking is a condition of approval. No buses are to be parked on the street. We have a lease, of course, about that. Let me just make sure there's anything else. So DOT conditions include like crosswalks and things like that, widening of crosswalks and so on. So just to alert council to check for that when you write your resolution. Okay, so with all of those conditions, which everyone knows about, and they're in the drawings for the most part, a motion to grant.
Chair Promoter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown?
Aye.
Commissioner Sheta? Commissioner Shabeta?
Aye.
Thank you.
Thank you.
Both cases are granted. New cases, item number 1, 2017-301BZ, 467 Marcy Avenue, Brooklyn. You the one speaking? presenting or whatever? Okay, raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board and respond honestly to board member questions? Okay.
Anybody from the owner?
Good afternoon, Madam Chair, Commissioners. Marvin Mitzner, the applicant. As was stated at the exec session, the fire department has issued a letter of objection based primarily upon the concern about the structure of the facility. We've had discussions with Chief Daley of the fire department concerning that. The structure is a membrane structure that has received, that is fire retardant, and it meets the NFPA standards. We will be supplying the fire department with confirmation of that. Additionally, the fire department will be visiting the site tomorrow to get clarity on that structure as well as other issues they have raised concerning certain tanks that are unrelated to our use but relate to the main use in the building. Those tanks are located about 100 to 150 feet away from the structure, but we will, and I'm not even sure if they're used or not, but it's an issue that we will be discussing with the fire department once they visit the site. They've also indicated an issue with respect to the fire hydrant that's right near the structure, which is currently being used for some refrigeration of some equipment that, again, is unrelated to our use. That use of the fire hydrant was approved by DEP, so it's there legally, but I think the fire department may have some concerns about that. It really is not our issue, it's unrelated to our use, but once again, when they visit the site, they'll try to clarify that also.
Worn out.
The use of the current use of the facility has also received temporary PAs. I have a copy that I could hand out to both from DOB and the fire department, which attests to its use. At the executive session, there was also some comment about the location of the toilet facilities. The toilet facilities are in the building. Some are located about 350 to 500 feet away. That is, my understanding is that the building department has wanted us to include those in our drawings, include those in the submission to the building department. We also have temporary trailer that we're using, and we have no problem in continuing that use throughout and keeping those trailers there. So if that's something that is of the board's concern, we can certainly include those in our drawings and maintain those.
So I'm just looking at what does the building code say about a so-called permanent use for use group 9 physical culture establishment and the requirement to provide sanitary facilities and where the sanitary facilities have to be located relative to the use and so on. These are code requirements. It's not a BSA determination about whether you can use fancy portisans for to satisfy code requirements. I actually just don't know. So
Well, my understanding is this issue was discussed with the buildings department, and they were satisfied with the facilities and basically signed off on those.
But they were, if it's a temporary public assembly permit, which I have actually a lot of experience with on my former job, it's assuming temporary public assembly. So it means the event, or the use is short-term, and you can have parties in unusual spaces and have a portable toilet, and it's just for the night or for a few days, or in the case of a circus, it goes on for 2 weeks, and then that's the end, right? But this is being proposed as a permanent use. So when you say you have sign-off, it depends on how Department of Buildings looked at this as a permanent use. which apparently was filed with an alt 2 as temporary use, so in which case DOB looked at this and said, well, it looks good for a few days or a couple of weeks or however that works, because the word temporary is actually a defined term in the building code. So that's, yeah.
Well, I'll provide the board with more clarification on that, but there was an Alt 1 application filed for the PCE, and that is a permanent use. And so the building department has, my understanding is we've met with the building department on the Alt 1 application, separate and apart from the Alt 2 application.
But if they're in conflict, if there's an alt 1 for a use, but the alt 2 is for the structure, they're not working together, right? There's an alt 2 for my understanding is, there's an alt 2 for this temporary structure, into which you're putting an alt 1 use. It's like a change of use.
Right.
But the structure into which you're putting it is being treated as a temporary structure, apparently. So the two conversations have to merge together into one, if this use is really a permanent use as opposed to circus for the spring or something like that. I mean, I'm sure that when the circus used to come to town, they would stay for a couple of months, and that was a temporary structure. Or like when the fashion fairs come, they come for a couple of weeks, and then they take down the tents.
We can provide clarification for you on that.
Okay, so what we really need is a clear DOB sign-off on the use of this structure for permanent. It's the structure, not what's inside, right?
Right.
The structure as permanent housing for a use, whatever that legal use would be on that site, prior to even considering a PCE, right?
As I say, we'll provide a clarification on that. And the other issue raised was that you mentioned the floor plans were not clear on egress. I'm not quite sure what
So the
you're
floor
referring
plans,
to.
as you can see from the drawings, are they're really sketches. That doesn't look like I don't mean the drawing of the entire site. I mean the drawing that is of the sort of interior of this structure. It doesn't really, it's more like a diagram of the structure than it is a drawing.
Are you talking about sheet 3?
I think there's only one drawing of the interior of the space, which is basically showing, I guess that's a route of egress?
Yeah, sheet 3, rest is the abutting building and other things.
So I'm not sure for what purpose that drawing was done, but the plan is super sketchy, so it's hard to know where what is
Well, we do have a drawing that shows the path of egress externally, and we also show the path internally.
But it doesn't, for instance, it says there's a door, it's again very diagrammatic, but there's a door that says that opens to what's called outside. Where is outside relative to the site plan where we see the larger site? You don't see it located there with a door that's indicating. Does it go directly to that private drive, that thing that's labeled private drive? What's the distance from the door that goes in the direction of Marcy Avenue? Is that an open courtyard? Like, what's going on? It's not really
If you like, we can get clarification. We do have a drawing that shows the entire site as well as a path of egress from the facility. But if you'd like greater detail and a blow-up of that, just to show what the relationship is of those egresses to the site, we can do that.
Is it all open inside? Or are
Yes.
there partitions of any sort?
No, it's all open.
It's all open.
It's a gigantic tent. But we only know that from photographs.
Right.
We don't know that because the drawing told us that.
Well, we have elevation drawings that show that. We have a number of elevation drawings that show the interior space and shows there's one large space.
A number of,
Well, I just see one elevation.
we have
The south, section AA.
We have exterior elevations, And an interior section.
Yeah, there's one interior section.
And in the interior section, something says movable seating, typical. And then in the plan, there are 4 cordoned off, I think, cordoned off areas that says gym area for certain number of people. And then there's the vacant area. So the plan and the sections are not completing the picture uniformly.
Well, there is an open area that's used for the facility itself. Then when there are demonstrations, school demonstrations, there may be some seating around the area for people to observe. So that's where that comes in.
So it's already up and running. So
Yes.
are there any interior photos that you can provide?
Sure.
We have them from our compliance officer, but we don't have them submitted with the application. It's so great, the site visits.
So we can provide interior
Our
photographs.
compliance officer did a site visit.
Yeah, that's what I just said.
Oh, okay. I didn't-
So, I don't know if it's actually in the folder or if it's in another.
It's probably in the other folder. It's not in the compliance folder.
Okay. Okay, it's just that it's requiring a little bit of guesswork here. So to the extent that you could give us more information.
We'll clarify the drawings so you don't have to guess.
Okay, good, that would be very helpful. Okay, so, for me, the biggest issue is this a legal structure? So we got that, right? So let's hear from fire department.
Good afternoon, John Daly, Fire Department. I did visit the site with your compliance officer, Mr. Ricketts, last week, and with the task force, and there were several things that we had observed that would affect the structure indirectly. Right now, Fire Prevention and Operation are reviewing this application that's before the board. I contacted the manufacturer of the membrane structure. They have provided me with additional details, especially flame spread, that I'm very concerned about. As Mr. Metzer mentioned, we are visiting the site again. I have members from operations who will be meeting us there, along with the administrative company. We have concern. To the north of that structure on the site plan, it shows the word tank. It's actually a 5,000-gallon tank that holds acetone. We were told that they no longer use it, but we in the fire department are trained. When we see a tank, it's full. So 5,000 is quite a large capacity, and there's nitrogen lines. The tank has not been decommissioned nor piping removed. As Marvin mentioned about the fire hydrant, no permit was provided to us from DEP. Another tenant, Square Root or something like that, is tapped into the fire hydrant, which makes it inoperable for us to use. The nearest hydrant is over 350 feet away. The entry, on the site plan shows off of Marcy Avenue, the gates are chained, which we can easily break, but there was a car parked at the time of my inspection, so we can't move cars. We'd have to go all the way around, enter through Tompkins Avenue. And another concern we have is another tenant at the Trapeze School. They took storage containers and converted them into refrigeration units. And off of these units are 44-pound propane tanks, no permits.
This is at the Trapeze School?
It's about 100 feet south of the tent structure. So there's already a large fire load surrounding the tent structure that we have major concerns.
Were they all violated, all these other tenants? Were they issued violations?
Currently, no, because what happened, see, this building, well, it was formerly used by Pfizer. They had permission, it's 7 buildings on this site, and they had permission to connect all the buildings. Now they're no longer there, that we have various units now going through the whole building. I mean, I have a distillery there. While the finished product is not flammable, the unfinished product is. So I have a lot of concerns with the site, with the tent structure. So again, I tried to get operations there sooner, but they were unavailable, but they will be visiting tomorrow with an administrative company, so they can tell me their concerns about this particular application, which I'll then forward my report to the board and to Marvin as well. So that's where I'm at right now, and I am, excuse me, as mentioned, I'm waiting for the manufacturer's spec. They're supposed to provide me more detail of their testing with the National Fire, NFPA group, and give a better answer, if we're going to approve or object to this application.
Okay.
Chief, when you say the structure is made of combustible material, you're referring to the whole structure or parts of?
The whole structure. The tent structure has an interior and exterior layer of membrane structure. And the inside of it, we have batt insulation. So again, now we have that fire load, so it just, if God forbid, it does catch fire, it's going to spread. And I do not know what the flame proofing of the material is, which the manufacturer will provide to me to make a better, give you a better answer, a better educated answer. So that's where we are.
So it's got the insulation between the two membranes.
That is correct, yes. As per the sectional drawing that was provided. So that I have a lot of concerns with the site and with the structure itself, but I'll have a better answer for the board after I meet there with operations.
Okay, thank you very much. All right, are there any speakers on this?
I do have a question for Mr. Sorry, I do have a question. As the Chief Daly mentioned that the entrance from Mercer Avenue is closed, and I'm looking at the Google map, it is closed. So how does one access this facility from the main street? Because the street, that gate is accessing a private roadway.
The main entrance to the entire facility is on Tompkins Avenue, and it's a controlled entrance. So that goes straight to the trapeze school, if you look on the site plan.
So it's, and it's walking along the private drive to the... Okay.
Right,
I see.
you travel along the private drive to the facility.
Okay.
So you stay outside the whole time? You stay outside the whole time till you get to the tent?
No, this is a gated area.
No, I know. So when you enter from Tompkins, you open a gate and you walk along the private drive to get to...
You drive along the private drive, and there's parking there near the facility.
Okay, so, but it's gated, so somehow or other you get open, how do you get through this?
Well, there's a guard there, usually.
Okay, so assuming you're driving, the guard asks you where you're going, I'm going to the trapeze school, they open the gate.
Right.
No.
No, it's not a gate, it's just an entranceway with a guard.
That is correct, yes. There is no gate on Tompkins Avenue's side of that private drive.
So you could walk through?
That's
could
correct,
walk through, yes.
Yes.
Okay.
You just identify yourself and they'll let you in.
Okay then, it sounds like you have a lot of work to do with the fire department, so we should, and buildings department. So,
Well, as the fire department mentioned, they're checking with the manufacturer, but we're confident that when the results of that inquiry come in, the fire department will be satisfied that the material that's being used is fire retardant sufficiently for the
yeah, but that's
operation.
just the structure, let's just say it says it's fire retardant, then we have this issue of all of these dangerous tanks and storage and so on the site, and fire department's not so happy with a public assembly going on simultaneous with very combustible uses, just to throw out an idea. And in addition to which, we don't know whether the Department of Buildings realizes that this is a permanent structure. So you also need to go to the Department of Buildings and make clear, however that's done, that this is an application to permanently occupy this tent structure where, for one, the toilet facilities are 500 feet away, et cetera,
Mhm.
right? because we're not doing this in a temporary structure. I think that, I mentioned it yesterday, the closest equivalent is this would be like a tennis bubble on the roof of a building, right? The tennis bubbles are truly permanent structures, been there for decades and decades. They're constructed in a certain way, whatever it is, that makes them safe, permanent structures. I just don't know what this is.
Well, I think the structure of the facility is constructed with footings, so rather than any temporary type of secure method, and that really makes it a permanent structure, but we can get clarification.
Oh, yeah. We're not going to decide that here, this is DOB.
Yeah, understood.
Okay?
Understood.
So I want to give you time to do this, so I'd say at least 2 months. To do the back and forth with DOB and fire department. So that's March and April, so the end of April submission, or?
Yeah, okay. That would be May 7th or an April 17th.
May, or June, May?
Sorry, April 17th submission, which is like 7 weeks now?
That's
Or May
fine.
7th hearing.
That's fine.
May 7th is special, wait,
Oh, I don't,
I'm sorry. Sorry, March.
Yeah,
I'm thinking
May
March.
7th,
May
submission,
7th.
April 17th.
That's fine.
Great,
Thank you.
thank you.
Thank you.
Item number 2, 2018-96BZ, 145 Ludlow Street, Manhattan. Anybody? Anybody else? Raise your right hands. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board, to respond honestly to board member questions? Yes, sir. No, here. That's for the neighbors. Print would be better. Can't read your writing. Jeffrey. Thank you. Thank you. That's okay. That's fine.
Right.
You want?
That would be bad. Thank you. Van Baton from Sheldon Lobel PC for the applicant. We attended the review session yesterday. We made a submission this morning, which is in front of you right now. It includes a revised plan set, specifically page 3 was revised. That notes the existing ADA bathrooms in the cellar, so it's page 3 of the drawing. So it notes the ADA accessible women's restroom and men's restroom, as well as the egress corridor to the common elevator, which is from the first floor. So in the previous
But
plan.
wait a minute, the common elevator is through the residential lobby.
It's used, it could be used by both.
What?
No, there's an entrance. So it's a residential lobby, but if someone needed to use the elevator, they could use it for the gym, for the PCE.
That's not ADA accessible? That's not normally what we consider to be ADA accessible. Because it means going into a private residential building with the general public.
It's the same building. It's just the residential entrance.
I understand. It's a commercial use where you have people of all descriptions who are coming in, and so you're mixing the commercial use and the residential use in the same lobby.
I believe we've had this approved separately for other gyms where they could use the same.
Not to my recollection.
Elevator.
My recollection is that we don't look at an entrance to a residential building, residential lobby, a devoted residential lobby as the
Devoted residential
access,
lobby.
right?
It might be
We
that the
did-
2 uses share a lobby, and there might be dedicated elevator.
There was one case, I think in Tribeca area, where the residential elevator, one of the residential elevators, it may have had two that I don't remember, but that was used by the PCE that was located in the cellar and on the first floor with the mezzanine.
I don't remember this. So, because what you're doing is you're, yeah.
This is a case, this is one I don't remember.
I think this had a mezzanine and we had some,
Well, maybe the mezzanine didn't need access, so maybe that was
no,
part of
but because the cellar had all the studios.
So I don't
We have
know.
the 80, sorry, we have the ADA bathroom on the first floor with the entrance.
So I think what the real issue is, because you cannot use the residential lobby elevator to access the commercial use, we don't allow that. The argument that is usually made is that you've already got the same facilities on the first floor, so there's no reason to go into the cellar. And you do have a toilet on the first floor, and it seems like the only thing that's down in the cellar are toilet rooms, showers, and lockers. So what would make it the same facility is a shower on the first floor and locker rooms, and lockers. Because I don't think that this otherwise qualifies.
So instead of showing the access through, ADA access through the residential lobby, show the same services on the first floor.
Correct. That's how you get around.
Or a lift on
vertical.
the stairs.
What?
Or a lift
Or
on
a
the
lift.
staircase.
Yeah, sure, that's another option, a vertical lift.
All right, so we'll have to look into this.
Okay. I think the lift is more expensive than the little shower that you would put in. This, for instance, is a pretty big bathroom. You could modify this bathroom.
We'll have to look into it and talk to the architect.
Okay. To make it handicap adaptable, I don't know if you could do a shower so easily, but anyway, yeah, you could. You
About
just
that.
need to reconfigure the bathroom.
Okay. There are concerns regarding sound attenuation because there was one letter in opposition that was submitted that we received yesterday. Submitted this morning, there's a letter from Kokoza Group, which was the general contractor, noting that they installed what was on the plans that were submitted, as well, you could look at that, as well as a letter from the sound engineer, the acoustic engineer, who on May 30th, in their letter, noted that on May 30th, visited the site, the apartment above, and took tests, and noticed they observed that the music from the gym was barely perceptible and was therefore at an acceptable level. We got this very last minute. It's the Lewis and Goodfried letter. Goodfriend letter.
So, it's barely perceptible. Why is it perceptible at all? Why should anyone hear music coming from? So this is after?
This was after they opened.
After they opened, it was barely perceptible. That's kind of depends on how you're perceiving it. At 6 in the morning, when you wake up and you hear the music, it's probably the only thing that you're hearing, right? As opposed to a bunch of people standing around during a test. So, right? So that's not acceptable. So we should hear no music. And certainly the way that letter described it is it's vibrating the glasses. That's a lot of music. And that, so apparently what's happening is the sound limiter is not being honored, if there is one. So the music has to be reduced to a level where it produces no audible sound or vibration in any of the units above. And that's the maximum setting it can be on. So the acoustical engineer has to find out what that is, set it, and then test that, and also participate with the upstairs neighbors.
I know that they installed what was reported. Do you want to? Yeah. Okay, 1 second. Here.
Dan Morello, I'm one of the partners in the gym. So I'd met with the tenant the first time she complained. We actually met with them this weekend. and there's a speaker that happens to be right under their apartment or right under one of the bedrooms.
Which
that
apartment are you talking about?
There's only one apartment that covers our entire gym. So it's a full floor apartment that goes over the entire gym. So we met with them about relocating the speaker to be, I guess, more in a common element of their apartment, meaning a hallway instead of under the bedroom or the kitchen. Does that make sense?
It makes sense.
Yeah.
But I don't know why anyone should have any sound audible anywhere in their apartment upstairs. They're accommodating you by saying you can be noisy in my closet. You can't be noisy in their closet. You have to have your, that's the reason why found it so odd. There was all this acoustical work done in your space.
Right.
And then it's not working.
So, well, part of it is where one of the speakers is in the corner where there's a glass wall of windows, which could be where it's traveling from. So we're going to relocate the speaker off of that wall of windows because their apartment, their back wall of windows is right above our back wall of windows, is relocating it there in addition to a limiter on our amp, which we haven't connected, which we will connect.
Was that part of the recommendation to move the speaker?
No, it wasn't.
Shabeta, can you be closer to your mic, please?
Was that part of the recommendation?
No, it was our, just speaking with the tenant, it was our recommendation and working with the tenant to eliminate any sort of sound. You really have to be in the apartment and stop and really try to hear it. But we're working with them to make it completely where you cannot hear it.
And when do you plan on moving the speaker?
Immediately. I mean, we met with them on Saturday of this weekend.
So you don't have your acoustical or your sound technician person here with you, do you?
He couldn't make it today. We had him write a letter on our behalf.
Okay, so the thing is, it's kind of, when we talk about these limiters, it's almost like the acoustical expert determines what the maximum sound amount is that can emanate from your sound system, and that's it. It's like they break the system so it doesn't go any higher, and so none of your staff, no one can modify it, right? Because it's not okay to exceed what is determined to be the maximum.
Right.
And it's not okay to remove the limiter, whatever, modify the limiter in any way, right? So you need to take care of this.
So one of our issues part of it, it's a franchise. So part of the franchise is on Saturdays, there's a live DJ. And the DJs bring their own equipment. And it doesn't mean, we're not running a nightclub, but they bring their own equipment. They've been unhooking our amp.
Okay, so you
that's
can no
what we-
longer have them bring their own equipment.
Correct.
No independent equipment.
Correct.
So you have to enforce this, otherwise, by the way, we're very strict about this. If you turn out to be a nuisance, we will discontinue your operation, because nobody should have to live listening to music at 6 a.m. or on whichever day you have your DJ and all
And we
that.
agree
If-
100%.
If they are at home reading a book, they should not be reading a book and tapping their feet.
Right.
Okay? So, that's a new one, so no more live DJs, or if it's a live DJ.
Or not using
Not using,
unplugging
yeah,
Not
but
using
the
their own
live
equipment.
DJ has to
Right.
use your system that's on a
Right.
sound limiter, and it may cramp their style, but that's just the way it goes.
Right.
Right?
The two complaints we did get were on a Saturday. Which,
So we've isolated what the problem is, hopefully. and
right, so.
I guess we can address it appropriately.
Right.
Great.
Okay, all right, so a lot of this has to do with you implementing the changes, the neighbor experiencing that the changes hopefully are successful, you reporting back what the changes are, and that becomes a condition to the approval, and should the neighbor complain again, we bring you back here, costs you lawyers, costs you time, we'll end up having a sound consultant that costs you money, go back and do testing, you won't like it.
We
Okay?
agree.
All right. All right, are there speakers? Yeah, of
Yes.
course. Please,
Come on, please.
Please state your name for the record, and you have 3 minutes. You can sign in later.
Yes, my name is Tom Veach, and my wife and I live on the 3rd floor of this building.
Oh, on the 3rd floor.
And we've lived there now for 2 years. And We were there before the facility came in. We've been there through the construction of the facility, and now we're there in the operation of the facility. There are, as he correctly stated, on the second floor, there's one unit, and on the third floor, there's 2 units, and we have the back unit. We've noticed 3 types of noise. One is music. Another is the beat.
Oh,
And
the beat, you're saying.
The beat.
Yeah.
You know, it's the bass.
The thumping. Yeah.
Yes, thank you. And the third type of noise seems to be a weight being dropped. So all of a sudden, there's a going on. To your point, it varies during the day. There's a lot of activity early in the morning. We're early risers by 5:30 or 6. We hear things then. Saturday seems to be an especially busy day, and we like to sleep late on Saturdays, and we wake up to the sound.
Can you tell me a little bit more about the sound? Okay, so would you say it's as loud? How loud would it be? Is it as loud as me talking, or?
So it's varied over time.
Okay.
When they first started, we like to have our windows open, and I made a comment to a gentleman, I've never seen these people before, and he said, oh, we open up a patio door on the basement, we will close that, but since then we've closed our windows, so we don't have our windows open at all because we hear sound. I would say you can hear that there's some sort of melody, there's some sort of music going on. It isn't, I can't recite the words.
Okay.
But I'm conscious that there's some music, something melodic happening.
With the banging, would there also be vibration?
The vibration is what I've tried to comment by the second thing. There's this heavy bass beat sort of thing that goes on, and it seems to vibrate. It reminds me of a piano where it just vibrates through. And I did comment to a gentleman that it might be helpful if they put some sort of insulation between the speakers and the floor or the wall, because it's vibrating through the building, and that might cut down on the pulsating nature.
Would it seem to vibrate things in the apartment, your apartment itself? Like if there was a glass of water, would the water?
I haven't tested that.
Okay. I just get that.
I've woken up in the morning and hearing this pulsating beat going on, and I'm going, no, I didn't drink too much. No, what's going on? And I go, oh, it's the gym.
With regard to the last.
Sorry, could you step closer to
I'm
the
sorry.
mic? I'm not even sure we picked up.
I'm sorry.
that last one.
With regard to the last type of noise, you said it was like a weight being dropped. Did you ever investigate where that was coming from, or what activity was happening?
No, I'm not a.
No, I'm not suggesting you are.
I didn't single-handedly want to go to a gym to investigate in my pajamas or whatever. No, but I am familiar with gyms and people lifting weights and not correctly putting them back down, and they seem to. It seems to be a weight being dropped.
How often would you say that you witnessed or experienced that type of noise, that weight being dropped type of noise?
At least once a week. At least once a week.
And would it be during the daytime or time varies?
I would say time varies.
Thank you.
Okay, thank you very much.
All right, thank you.
Thank you.
So, please, so we also have a letter from a neighbor who, on the second floor.
If you're in favor.
Yeah, second floor, who says that the glasses vibrate.
That's the one we were discussing,
Okay,
the single.
so I had no idea this is actually moving up to the third floor, which is a much more serious issue. So what this is telling us, because we have unfortunately a lot of experience with gyms like this, where the vibration and sound communicates
great.
to an upper floor, means that something about what was done in your sound insulation system is incomplete. It means there are openings in, around the, say, for instance, there's an engagement of the sound system, sound insulation to the columns. And it's the sound and the vibration are traveling up through a ventilation system or up through columns or something So your system is defective.
So I think part of that would be the glass wall in the back. So like he explained, is this 3rd through the 5th floor, there's an apartment to the east and an apartment to the west. The west apartments face the back corridor, which act like an acoustical tunnel, if you want to call it that. So the speaker that's on the back wall by the windows, I believe, and obviously we'll get our sound engineer in there, is going to eliminate the sound traveling into that back behind the building.
Okay, but that doesn't account for dropping a weight that
Yeah,
makes you go thump?
And I think because, based on the photos submitted, it seems the weight area is by that window.
But there's weights all over, I mean, from the entire gym, there's weights.
Oh.
So what is the situation with your weights? Why are people hearing thumps?
I'm not sure. So we're entirely, we could put signs up in our gym to make sure our members don't drop the weights, because it could be the fact of someone just not, kind of like what he said, is not placing the weight down like they should, and instead of just letting go of it.
Signs don't work. We've seen this story with signs. What works is the correct amount of padding, and it doesn't sound like you have it. So you need to, again, we of course didn't have time to read this report, but you need your acoustical technician to go back in, and understanding what we just heard, needs to take care of all of this, whatever it means, and unfortunately is often very expensive, because it means that your ceiling was not properly installed, and that you probably need to have some kind of floating floor, which you don't have. So that's bad news. That's the thing about, and we've even had gyms that stop having music because of this, right? So you're gonna need to take care of it, and that's what happens. Okay, so are there any other speakers on this? Okay, so my direction, and please, other commissioners, please feel free, or anybody else, feel free to jump in. You've heard the specific complaints of your 3rd floor neighbor. We have 2, right? And we also have the complaints from the 2nd floor neighbor. We should not hear those complaints anymore after the work is done. So you need your acoustical engineer to go in, do the necessary testing, make recommendations, and you need to install according to the recommendations. Okay? So we need to give you time to do this, and I would like also that the neighbor who's here, and I don't know if there's a way for us to communicate this to the other neighbor, that they keep track of, keep like a little log of
Any noise.
any disturbances you hear over the course of between now and the next time they come back. The next time they come back should be after the acoustical engineer has done the testing and made a recommendation, and the work has actually been done. Okay, so it'll be a few months of you logging, so that's not a small amount of work.
Should they share their log with the PCE?
Yeah, so that's another thing. So do you have some kind of, are you emailing or texting or something like that, or?
We can arrange something.
Okay, so, all right, so with both of those tenants?
They can maybe share information.
So you'll arrange something that when you have a day of complaints, send your information to the gym, so that the gym is aware that whatever it is they're doing isn't okay, and maybe that way they can correct behavior. But for one, no DJs on a different system, and the system has to be set to a limiter, and the limiter has to be turned on according to whatever the recommendation is in here, if there is one. I don't know if there is one. Okay?
And you want their logs submitted to us also?
Yeah.
Yes.
Right, so before the next hearing that we'll set, if you could submit, if the neighbors could submit the logs of their complaints to us, and you can get that information from Ms. Matias. That way, we'll have it independently, And then also the gym will have it so that their acoustician is aware of what the issues are and whether they've been successful in ameliorating the problem, okay? Understood? So I think you need 2 months to do all of this, both to hire the acoustician back, to do more testing, to make recommendations, and to install, and then to do follow-up testing, okay?
There was another project that we had worked on that also had a cellar in the basement, and the noise was traveling from the window, from the rear up. And I think there, the applicant provided some kind of thicker,
Oh, yes. Some kind of they blocked
a
the
city
window.
window?
something that blocked the noise by the window.
Like a city window, almost like another layer of window.
Yeah.
Don't know. That's really for the technician to
Right.
figure out where the sound is traveling from. I'm sure there are technical methods for doing that, so we don't have to guess. Okay?
Okay, so how about May 1st submission for May 21st hearing?
Yeah.
More than 2
I think it's going to take longer than
Oh, if you're going to speak, you have to
Yeah,
come
you
up
come
and
up to
say
the
your
mic.
name.
Jeffrey Catenacci, also an owner at the property. It's going to take us longer than 2 months to actually get that all done. That's a lot of work if we have to do all that work. So I just asked for a short extension.
Okay, so I'm just not wanting
We-
this to
we have to
drag
do-
out too much, because if people are miserable, I sort of want to check in.
Yep.
So,
Yeah, what if instead of asking that all the work be completed, we just have a check-in as to how, what's the status?
That's all we ask.
Okay,
Thank you.
okay.
Yeah.
We'll do that. So we'll have us May 1st for May 21st submission.
right, and so, but to the extent that the...
May 21st.
May 1st.
Yes, yeah, sorry.
To the extent that the acoustical engineer says, install this, you should be installing this to beginning the installations or underway on the installation so that we can see good faith. Because we don't want to be May 1st and no work has been done. Okay?
Okay.
Thank you.
Thank you.
Thank you very much for coming.
Yes, the next,
So we're coming back here May 21st, is to just check the status update, and then it'll be at 10 o'clock. I don't know what time it's 10 o'clock, so we're not going to come back at 1 o'clock.
Right. And then, so if the hearing is on May 21st, if you could send us your report on complaints, yeah, say the Friday before, that would be really helpful.
Yes.
And you would send it to, and Ms. Matias would give you,
Yes.
okay.
You can also still come as well to the hearing.
Yeah,
That'd
you, of course, come to the hearing if you're able to. Yeah. Okay, thank you.
thank you.
Item number 3, 2018-117 BZ 2060-63rd.
Oh, there is a dog. Oh.
Oh. It sounded like an enormous dog.
What is it?
Wow, it's
I don't know
bark.
that we've ever had a dog in the,
Yeah.
wow.
But he was a really good neighbor for this.
really good.
Really quiet.
Yes.
Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board and to respond honestly to board member questions?
Chihuahua with a baritone.
He's a kitty.
I thought I very confusing.
I actually thought it was the ringtone.
Me too. I know somebody with a ringtone like that.
Thank you.
Thanks.
Oh, no, that's his. That gentleman out there.
Oh.
You can stay there if you want.
Thank you, John.
There's comfort.
But you have to wear a vest.
Oh, really?
Elise Fullader from Eric Palatnik, PC. I'm here with the project architect, but I don't want to ruin his name, so I'm going to let him state his own name. Sorry.
You have to come to the microphone to identify yourself.
Ruslan Gachev.
Okay.
So firstly, the homeowner is more than happy to bring it to 1.25 FAR.
And to bring it back to 1.2 FAR, we can also respond to your setback comment about the third floor. It'll set it back even further on the third floor, so it's not visible from the street, and it's 1.25 FAR. So that kind of does both.
That handles that part.
Yeah,
right?
that part.
So, and the not visible from the street, that's kind of a Landmarks Commission characterization. In order to be able to demonstrate that, you have to show that it's not going to be visible from the street, right?
But I also want to point out, I handed to you, we're trying to make it less visible from the street, but I handed to you a ZD1 for a home that is across the street and about 3 or 4 homes over, and it's also a semi-detached home. And it shows that other homes on the street are doing as-of-right construction that's similar to our construction. So if you turn the page, you can see that this will be taller than our home and larger, and they'll have that same idea of a setback on the third floor. So we are not the only, although we're at the BSA, we're not the only people on the block adding a third floor extension.
Doesn't mean it's legal.
Because this, as fortunately or unfortunately, it's an R5 where a lot of homes haven't yet extended, but they're starting to.
So we're looking, what's difficult about this is we're looking at a current condition where it's a neighborhood character and there's one application there,
Yeah.
but it's not built. And-
Yeah, it
and
was
the
approved in
the
2017.
more than the predominant, the characteristic of this area is these 2-story semi-detached.
At the community board, they seemed appeased as long as we set back that third floor.
Right.
Yes. So we're trying to do it even further, so it's a compromised position.
So I'm not saying no third floor, but I am saying that we've got a character that's very consistent throughout this entire block of these semi-detached houses. Well, that one's still only a 2-story.
That's the one that with the addition.
Yeah, right. And that, the only anomaly is the one that doesn't seem to have what is that one? It seems to not have a little porch front to it. But other than that, everything else does, and they're all 2-story with a little shallow attic, right? So the best solution, which, by the way, if you were to use that characterization of it not visible from the street, you would not succeed, because everything there is 2 stories. So you shouldn't offer that, because you're never.
I was trying to mimic, the.
Right.
We're
You
trying
just
to push
won't,
it back.
because no matter where you stand, you'll be able to see this house.
Okay.
Okay?
We're trying to make it less
Okay.
less impactful on the street view.
Street front.
Or street front.
So if you were to stand on the side, in front of the building on the sidewalk, that building should not be visible, the extension.
Yeah, but that, if you stand right opposite of, that's never how you perceive, right? So that's part of the point is, how does this addition affect the neighborhood character, right? And so you will see this thing. So the question is, how are you, and this is really a question for the architect, how are you modifying the form of the building so that it does not appear like a sore thumb in the neighborhood, because you are before the BSA. It isn't an as-of-right project, right? And without the BSA, you can't do it, right? Because it's a straight line extension of the side yard. You can do it on your own, but then you'll have to pull to the required side yard, right? So that's why,
A pitched roof was one of the solutions, not the solution, but it helps, because.
that's just from the front. But I'm talking about, the fact is, you will see this addition from everywhere.
You will see, but if you look at the roof of the building, right, the third floor does not have a flat roof. It's sort of pitched roof with a gable roof. So when you look from the side, far away, let's say sideways, you look at the building, you will see mostly a roof. You're not going to see a vertical wall that much.
Okay, to be seen. So if you can show us,
We could create some kind of 3D diagram.
Yes.
Let's say standing 100 or 200 feet away
Yeah.
across the sidewalk, looking at the building, which portion is going to be visible. Pretty
Right.
sure it's going to be only the top, the ridge of the roof.
okay, yeah. So the best way of making this argument is if you did sort of long-distance renderings, if you're doing this in CAD, if you're doing this renderings from several houses away across the street and on the same side of the street, and then your ISO to explain the roof line.
Right. Plus, we're about 300 square feet over to get to a 125. So that, if we cut the top floor by 15 feet in the front, that will take care of the FAR issue, and it's going to be more setback.
Okay.
And I'd also like to point out that fortunately, in the rear, there's trees, there's like no houses behind it.
Behind, but adjacent.
Yeah,
there
but
are houses.
we're talking about all the sides, and I'm saying on one side, it's not going to like be right overshadowing a house behind it, because there is no house behind it.
Right, that understood. This is what we also, that we see so many of these cases where most of the time they argue, oh, I don't even like a rear yard because we just want to pave it over and have, I don't know what, nothing. And our neighbors hate rear yards also because they've paved them over and they have nothing. According to what I can tell, these neighbors have gardens where they grow plants, right? They grow vegetables.
But this also, like I said, has a whole forest in the backyard, so it's...
No, but that's the back. I'm talking about the adjacent sides.
Oh, the sides?
So I'm talking about, so this is a question to how will the extension, which is enormous, it's an enormous extension relative to the size of this little house, right? What will it do to the neighbors whose sunlight will be completely obliterated by this, at least for, other than the summertime, at least for afternoons. I'm not sure which sides are, where the...
Shadow diagram?
Yeah, shadow diagram. You can do that.
I also
Yeah,
want to
that's
say that
really
at the
easy.
community board meeting, which I attended, we did have neighbors attend as well, and we discussed with them what they would like to see or what they wouldn't. And the easement in the back, they were concerned about that, and we talked to them about how they'd get their cars in, and we showed them the design. So before issuing that condition, we personally spoke with all the neighbors who showed up, and we had the guy next door who was attached.
Okay.
So he's
That's
on
good.
notice.
Okay. But they may not have realized, because people often don't know how to read drawings. They may not have realized how far back onto their neighbor's adjacent property this building will reach, and the impact. I don't even know if those adjacent neighbors attended the hearing. They may not realize whether that their light will be obstructed by this. Maybe it won't be. Your shadow diagram might show it's obstructed for 45 minutes on December 21, or something like
I
that.
just wanted you to be assured that the attached neighbor was at the community board. We provided with.
No.
But there is another neighbor on the other side.
Yeah, I mean, I can't speak for every
Right.
single neighbor in every
Also,
single.
there's the shared driveway, 20 feet wide, at the rear of all those properties.
Right, understood.
And then you have the garage, 20 feet. So
Understood.
40 feet of the property is not usable, except for the parking.
Understood.
I think what the chair is talking about is mostly the impact to the adjacent neighbors who are enjoying their gardens.
Right. We're talking about the garden areas, not where the garage is, all that stuff. And the fact that you have an abnormally deep lot to work with, which is what's responsible for giving you so much floor area. This is it's like almost like a one of a kind in the city to have such a deep lot. And so we're not used to seeing such an enormous addition that's as of right.
We're not used to being in an R5.
Right, well, no, we see R5s, but not on lots that are
I'm not-
150 feet long, right? So it's almost, let's say it's almost twice the floor area that everybody else gets as of right. So, okay,
Yeah, other people.
all right, are there any speakers on this?
We had more
Oh, I'm sorry.
that you wanted to address.
Yeah, sorry.
We will do a calculation to show that 50% of the exterior, 50% of the interior will be maintained, with a note about how the joists will be taken care of. And then I think that was your last, and we'll add. Oh, and then the street wall, I guess, was your last question. We'd like to maintain the street wall in the drawing, but, because we'd like a bigger front. You asked about the front yard and bringing it up.
No, it's the
So it
reverse.
lines with the,
No, it's the reverse. You seem to be counting interior walls as exterior walls, And we're talking about exterior walls that need to be maintained on the exterior. And by removing the first floor's front wall, you don't meet your 50%. And if you left the first floor front wall in place, it would match the neighbors, because all the neighbors have those little front sort of former porches now enclosed, right? So that's something very consistent in the row, with one anomalous, unfortunate exception. It's an unpretty building. So if you kept that, and then you've got on your first floor the 50%, because you have one side wall and one front wall maintained, then your extension goes back. So that's obvious.
Said we need to have long sidewalls, 50 feet each, and then 20 and 20 from.
No, but the side wall is an interior wall, and the whole idea is to be maintaining a building floor area, right? So, and we're just talking about the front wall of the first floor, because on the second floor, you're maintaining the second floor wall.
We're talking about the up and front wall itself.
Correct. No, of the total. But you're removing the back wall, so that matches the front wall. If you keep the front wall, you're good. And you can't count that interior wall. That's the party wall. So you've got the exterior wall, which you're keeping. You make 50%, right?
The only reason for that is they have 3 existing trees in front of you. So that existing front wall is pretty close to all the branches. They all come into the house. But what we try to do, we try to keep the face of the building on the same line, except it's supported by 4 columns and 3 large openings to create this covered porch. So the actual front wall of the building is set back an additional 5 feet. But the overall is the same face. Just those 4 columns.
So the issue is maintaining the existing exterior walls.
Exterior.
That's just the standard. Yeah. You're getting into another layer of things. I know architecture, it's complicated, but that's the thing we're looking at, okay?
Okay. Oh, and then you asked about seeing the home next door. It's on BSA 26, BSA 22, and BSA 23. We show the
Those are the existing drawings.
Okay, so you...
It needs to show on the proposed.
Sheet 26 has both. The top is existing and the bottom.
The top is existing, oh, and the bottom is, okay. Yeah.
It's not a 3D.
No. So that's the thing is, when I look at that, I look at, it's not compatible with the house to which is attached. This is architecture speaking. You just look at that and you say, oh, that's a bad idea, right? The 2 little buildings live together, they're attached to each other, right? They travel as a pair. So you need to do something that's sensitive to how they travel as a pair. That's not easy. These semi-attached applications like this are not easy applications. That's one of the reasons for your, the need for the renderings. And I'd have to say, you really need to do treat the building like a sculpture and see how you're going to do.
Couple.
Yeah, they are a married couple and they should not be in dispute on the verge of a divorce, right? Okay. All right. Okay, I think that's it. So how much time can we give them? Make it in April.
April? So April 9th, we have 26, April 23rd, 24, April 30th, 15. Okay. Ms. Holder?
Yeah.
How about April 3rd for submission for an April 23rd hearing?
Yeah, April 3rd for April 23rd?
Yes.
Okay.
Okay. Great.
Thank you.
Thank you.
Item number 4, 23115BZ, 5278 Post Road, the Bronx.
Raise your
hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before the board and respond honestly to board member questions?
I do. Good afternoon, Mitchell Ross. I was at the review session and listened very carefully to the board's extensive comments, many of which go to core threshold issues, including the possibility of an affordable housing bonus, that kind of thing. It's extensive enough that at this time I'm just going to say that I would respond in writing at a later date to everything that the board has addressed. I'll work with the board's examiner to make sure we address all the issues. Also, I see there are folks in opposition, and I should listen to them and have an opportunity to respond to their concerns.
Okay, thank you. Okay. All right, so I don't know how many, sorry.
There's a few, but there's a couple of people representing elected officials, correct?
Yeah, I just,
Yeah.
could you give me a chance to just speak before you do that? Sorry. Okay. All right, so I'm aware that there are people in the audience who want to speak on this, and I don't know how many of them were able to listen to our recorded, videotaped review session. So yesterday, we had a review session where we discussed this application at length, and we didn't discuss too much the what we call the merits of the case, in the sense of whether the building is the right design or the right shape. We focused mostly on what we call the A finding, which is, do they have a unique physical condition, which is the first finding in a variance application. And we were having trouble, collect the entire board, which is the 5 of us here, we're having trouble coming to a conclusion that they had a unique physical condition, so that the reason that the applicant's representative is not going to give more of a presentation is without us getting past what we call, getting past the A finding, there's no case. So that you should understand that that's where we left it, and we didn't get into whether they should, for instance, set the building back further or give us, we often ask for those kinds of things when we're getting into the details, or maybe provide more parking or less parking or anything like that. We didn't get into any of that because we didn't think that they even have the beginnings of a case. So the job of the applicant, if it's possible to do for the next hearing, is to prove to us that they even can make that unique physical condition finding, which at the moment we don't see. Okay, so now bring up testimony. We start with the elected officials, who can please come speak.
Representatives of elected officials, and there's 2. Please state your name for the record. You can come sign back in.
Hi, I'm Patty Intrader, and I'm speaking on behalf of Councilmember Cohen. He has submitted 3 letters, and I don't think I need to repeat them. I just wanted to state his objection to the variance.
Okay, thank you. We read them, by the way, so, and if you listen to the review session that's on the videotape that's on our website, you'll hear that we acknowledge the letter and what the objections were.
Great, thank you.
Frederick Klein, I'm here on behalf of Assemblyman Jeffrey Dinowitz. I have a letter that he has submitted, and there a slight revision since it was submitted last week, but if I could just read it here. I urge you to vote no on the requested variance for 5278 Post Road, located in my district of the Northwest Bronx. The application before the board today is one of self-created hardship. When developers first came before Bronx Community Board 8 a few years ago, claiming a need for a variance due to financial hardship, many of us in the community were incredulous. It was well known and obvious to anyone who could see that the site was covered with extensive rock outcroppings. The rocks have been here since the Ice Age. They are not new. It is outrageous to request a variance based on financial hardship for something that was obvious on its face since day one. The property developer should have factored the fact that this site is approximately 3/4 covered by this rock outcropping into the purchase price. The developer made a decision to purchase this property, fully knowing the situation, and should not be rewarded for what some might characterize as a very poor decision. Furthermore, the scale of the proposed building is severely out of character with the surrounding neighborhood. The property already includes a combined lot on a slope, which allows them, even without a variance, to build much higher than they would have been allowed to on an individual site. The introduction of 120 units into this neighborhood will certainly strain existing infrastructure that is already stretched very thinly. The site is immediately adjacent to major thoroughfares, Broadway, which is New York State Route 9A, and Henry Hudson Parkway, exit 23A, which are already frequently congested with traffic. Local street parking is already scarce, local schools are already overcrowded, and our sewage system is already overburdened. The approval of a variance would establish a bad precedent for future developers who want to be bailed out for their poor decisions. There is no hardship under existing conditions. The developer is already able to construct a large building and should have been aware of the challenges at this particular site prior to their purchase. Their neglect of due diligence should not result in our community having to deal with the very real infrastructure ramifications that this proposal would bring. There is nothing unique about this application that would justify its approval, aside from the sheer boldness of these developers attempting to circumvent long-established guidelines.
Thank you.
Thank you.
Okay, next speaker?
You already submitted that to us, right?
You can give me.
Okay, you can give it to Ms. Mattia. Thank you very
Ms. Branca.
much.
Yeah. thank
We
you.
appreciate you coming.
And then please sign. Thank you. Okay. the next
Any others
speakers? Next speakers? Mr. Merdler? L'Oreal?
I'm not, are you representing
I
a?
represent the community board.
Oh, okay.
Okay, so no time frame, right? I just want to make sure.
No,
I
it's-
affirm.
Now, we don't
No,
have to
it's-
ask.
So we appreciate the offer.
Madam Chair, members of the board, my name is Charles Merdler. I represent Community Board Number 8. I'm chair of its Land Use Committee, and I am the former Commissioner of Buildings of the City of New York. Yes, ma'am. I make that point for only one reason. This is an area that way back when I held that office, we focused on an issue of uniqueness. You will recall that the zoning resolution was enacted in 1961, effective at the end of 1965. It greeted me on my arrival in 1966.
Oh, wow.
And at that point, we had to take a good hard look at what was going on here. So let me make a point on uniqueness and stop right there in light of your comments. There isn't a meaningful area of land west of Broadway to the Hudson River that doesn't have rock. Lots and lots of rock. And the ways that people have dealt with it in the past have been to build it on stilts. Indeed, a block away, the Riverdale Country School is elevated on stilts to deal with rock. Many of the buildings have dealt with it by putting the buildings themselves elevated so that the rock is hidden underneath. Indeed, my basement is rock for most of it. And that's been the case, as someone else has observed, since time immemorial. Now, the only predicate for this application is uniqueness. Now, what is unique about this rock? Across the street is Van Cortlandt Park. All the rocks you want to throw at anyone, you'll find there. All the rock you want to find is behind it. There is an important element to this. Councilmember Cohen and Assemblyman Dinowitz have for some years been making a very serious point. And it does go to the character of the community. And that's one of your findings that you have to make. This is currently has been a speedway. It is right on the border of Broadway, of Yonkers. It is at the juncture of a highway, and it is a point at which we have had numerous traffic deaths. Documentation of that is in the submission we made to you, not provided by us, but provided by the Department of Transportation of the City of New York and the Police Department. Shows that there have been more deaths in this area than any other part of this community board district. Why? Because the speed limits are always violated. And as a result, what we have done, thanks to Councilmember Cohen and to Assemblyman Dinowitz, is to narrow the roadway wherever we can, so that people who are elderly and the kids can go across the street without getting hit and go to the park, because that's an issue. Now, that becomes germane here for the following reason over and above character of the neighborhood. It's germane because if you have a high-rise building as is proposed, without adequate parking to really cover what is needed here, you will A, go against the policy of the City of New York as manifested by DOT and the police department. And two, if you have on-street parking, you can forget it completely. We're back where we started. I will tell you, this community board has spent literally a fortune in designing a 197A plan for various portions of the district to make sure that we try and uplift our community and preserve and maintain it. It is a homogeneous, integrated community. It is a community that has affordable housing as much as it does luxury housing. It is a community that is fit for people and fit for living, and that was our principle. This building, this application would destroy that. Destroy it in the sense, and I'm not exaggerating here, it would destroy it because we will have the same problem that we have today of people getting killed, people getting maimed, and discouraging families. We had hot sheet motels right down the block here. We went to work, we eliminated them. We had situations with people getting killed among the homeless that were located in nearby motels. We eliminated them. We have worked for our community. This board is a board of people who care about their community. And what we ask of you is look at these findings, look at this application. We did as a board. We heard them, not once but twice. And the points you have raised at your preliminary review were, with one exception, all raised. The one exception was the count that, of the number of cubic feet rather than square feet. Mea culpa. But the fact is, we have done that. We have tried to do it in fairness. In my daytime job, I represent applicants. My firm represents applicants. We represent the real estate industry. I do not make it a practice to do this side of the aisle, except when it involves my community. And I will tell you, when we saw this application and we went through it carefully, we could find no justification for it. We told them so. On its face, it was a request to get every variance in the book. Accessory uses came on the other side of the street, et cetera, et cetera. You've pointed all that out. This is not a good application. This is something that really deserves to be rejected sua sponte. And I thank you for your courtesy.
Thank you very much.
Next speaker?
Next speaker?
Please just come up.
You can just line up if you wish to speak on this application.
Thank you. And you can come and sign later if you haven't already.
Good afternoon. My name is Laura Spalter, and I am speaking today in opposition to the 5278 Post Road development on behalf of the Broadway Community Alliance, a civic group dedicated to the improvement of the Broadway corridor and its environs. We oppose any variance which would increase the allowable building height, whether through increase in floor height or through the addition of the 2 extra floors. It is disingenuous for the applicant to claim to be asking for a 9-story building. The reality, the way we looked at the maps, is that on Post Road, this 111.5-foot building is equal to the height of an 11-story building. On Broadway, it would be 133 feet tall, equal to the height of a 13-story building, the highest on Broadway. The developer has already seen significant financial benefit due to the merging of the Broadway and Post Road zoning lots. The allowable building height on either lot by itself would be less than has already been approved for the joint site as of right. No further concessions or variances should be made relative to building height. I will skip my piece about the 70 to 80% of the rock, it's a white elephant, that's been covered very well. The applicant's environmental assessment statement is inaccurate and incomplete. The EAS reports that the development is located in the borough of Queens. The developer falsely claims that there will be no impacts on the community from this project. As BSA is indicated as the lead agency, we request that BSA call for an assessment of public health, a preliminary construction assessment, and a traffic study for the following reasons. 1, the noise from ear-splitting drilling, incessant hammering, and blasting of the rock and use of diesel equipment will produce extreme noise, dust, and pollution, which are deleterious to residents' well-being and health. There are schools, nursery schools, and the W-assisted living right there. They will also be affected. The EAS states that the project is not located along an arterial highway or major thoroughfare. It is totally disingenuous to make this claim. The rock outcropping to be demolished is adjacent to the 23A exit ramp, Broadway southbound, of the northbound Henry Hudson Parkway. By using their pictures, New York City map, Do-It, Citywide GIS, it could be extrapolated that the northeast section of the building will only be 60 or 70 feet from the Henry Hudson Parkway 23A exit ramp. During the construction, the inevitable increase in traffic and congestion will be a nightmare for residents and thousands of commuters. Additionally, absent the forest of trees embedded in the rock outcropping that currently absorbs stormwater runoff, flooding and erosion will be a serious problem for our roads and residents. I have to skip, but I have sent it in with all my amendments. Let me just say that the developer claims that a building that is 112 feet tall at least, and containing 120 units will not alter the essential character of the neighborhood. This is inaccurate because he fails to mention that the adjacent buildings are only 20 and 50 units respectively, and that the site sits among many private homes and low-scale row houses. In regard to building heights on Broadway, this is not contextual. A survey by the Broadway Community Alliance from Manhattan College Parkway to the Yonkers City line found that the overwhelming majority of buildings on Broadway are clearly low-scale. 22 of them are only 3 stories, 14 are 1 story, 10 are 6 stories, 5 are 5 stories. You get the picture. Only 2 are 12 stories. This would be the highest. The use of lift parking for commercial areas does not belong in this residential neighborhood. In closing, we ask that we don't feel this meets the findings, meets the criteria, and we ask that the Board of Standards and Appeals deny these requested variances. Thank you.
Next speaker, please.
Any other speakers? Any other speakers? Please come up to the mic.
Just give her a minute, she's...
If I could have a show of hands of how many other people wish to speak after.
There's you and who else? Anyone else beside her? This lady coming up? Anyone else who's going to speak besides this lady?
Or else she'll be the last speaker.
Okay.
Okay.
Good afternoon. I'm Ava Zilberfein. I live on Lakeview Place, which is just is just adjacent to Post Road. I'm on the same block, and I'm asking...
You're on Post Road, on the Post?
No, I'm on Lakeview Place, which is actually for the vehicular architecture of the street. Has Broadway and the exit of the highway go directly through my street and then onto Post Road. I ask that, I believe that the reason why we have these building codes is to protect neighborhoods. And I believe that this violation of code, this amendment to the code, would destroy the fabric of the neighborhood. It would destroy the value of the homes. It would destroy the peaceful enjoyment of home ownership there, and basically it would increase all the pedestrian traffic, the vehicular traffic. It would increase I'm so sorry, I'm not used to speaking in this forum. But I know firsthand what it's like to have larger buildings on my block. When I purchased the house, I purchased it because it was a small, nice street with private homes, and the larger buildings with the transient tenants have people on your property, littering on your property, noise pollution, they litter on the property, they encroach on the property, and that's not what I signed up for when I purchased my house. So I'm asking that you please, on a personal level, for the home residents on the street, to please not allow for this amendment to the code that's already set in place to protect us.
Thank you.
Thank you.
Thank you.
Anybody else? All right, that's it.
Okay.
Russ?
Okay, so,
We're going to need substantial time to look at all of these issues and address them all.
yeah.
And I think at least a 2 or 3 month, probably 3 months. Yeah.
So end of May submission, I'm guessing.
3 months to submit.
So that,
And, well, I would say, 3 months to the hearing should be enough time.
End of May submission.
we can
That's
give you
fine.
slightly less than 3 months for
Yeah,
submission.
yeah.
So June 11th hearing,
Mhm.
May 22nd submission. That's a little bit less than 3 months.
Okay, thank you very much.
And,
Yeah.
go ahead.
Oh,
So for the community's information, they will then be submitting a response to our comments, which are focusing on, they're not going to be talking about a lot of other issues we have with the application, which we didn't even discuss yesterday. They're going to be focusing on the A finding, what's unique about this site, and they will be submitting it to us on May 22nd. That information should be CC'd to the community board
mhm.
and to Mr. Merdler, actually. If you could share your contact information as representative counsel.
Yeah, I'll be happy to
Community
provide that to
board.
Mr. Merdler.
Okay, so to CC opposition counsel, and so for the other members of the community, though, the materials will be available for viewing at the community board offices, so make sure you're submitting a copy to the community board, or at our office, which is less convenient because it's down here, 250 Broadway, and you have to make an appointment to come view it, okay? But, so then they will return on April...
On June 11th.
June 11 in the what we call the morning session, but morning sessions sometimes are around 2 o'clock in the afternoon. So you can check on our website on the day before the, on say Friday before the hearing, to see what number on the calendar you are, and that'll give you an idea whether to come sharp at 10 or more like around
11, 12.
11, 12. Apologies in advance if you have to wait, because often we go over. And then on Monday morning, we discuss, the Monday before the hearing, so that's June 10th, we discuss what we've read, and the commissioners voice their opinions about what we've read. And so you can listen to that on YouTube, which is linked to on our website, which is usually loaded by the afternoon about 3, right?
Yeah.
Okay.
If I may, Madam Chair, as I'm going to be affording a courtesy to Mr. Merdler, I would just ask that Mr. Merdler kindly send me, if he has any responses to my submission.
Okay, which he'll do.
Okay.
Okay, great. Thank you.
Thank
very
you.
much.
Thank you. Thank you all for coming.
Thank you for
Yeah,
waiting.
Thank you, we appreciate you coming.
This concludes we don't have any second calls, we did all that.
We did all the second
This concludes the public hearing for February 26, 2019.